to add to that, can I then ask you, I mean, if it is regarding personal data, which this information is being transmitted all over the world, right? So to ask the question, the more important question, is it at all important? I mean, I can start with Ravan on this point. That is it at all important to harmonize this regime? I mean, is it at all important to have a global privacy laws or a regime?
Thank you, Ray. I think it's very important to harmonize the data. Why? Because we have several types of data, like personal data, sensitive data, whatever type of data. Data is floating all over the world. We have cloud, we have so many, Facebook, we have Instagram, we have social media communication. So it's very important. Also, we have data inside the organizations and through individual data. So it's very important because data is floating all over the world. It's very important to harmonize it. Like we have one global law. I know it's not easy, but because sometimes some countries will be rigid to their local laws and regulation, but at least the minimum common things or ideas in the GDPR, they can accept it and use it for data harmonization.
Okay. So, and Sanjeev, what do you think? I mean, is it time that we have a global regime for for data privacy?
Good morning, everyone, and thank you, Ray, for the good question. I think data harmonization law is very, very important today, right? More than ever before, because today we are living in a borderless world, right? You can move people and data across seamlessly. So if you do not have a basic baseline, it's going to cause a lot of problems. And going with what my fellow panelists have mentioned, right, it's very important we know why we are collecting the data, how we are using it, how we are going to dispose it, and how we are going to store it, right? So it's basically your CUDS, collect, use, dispose, and store. So you need to have a basic baseline law. And like what all my panelists have said, if you do not have that, it's going to be a problem because Europe, as we know, is the gold standard in data privacy laws. And then you got the US, and then you got Asian countries, and then you got the Middle East. And now Africa also is going into that space. So it's very, very important we understand, because today in the new world, data is money. Money is not data, right? So that's my 2 cents worth for now.
So Sanjeev, I think you hit on the right note when you're talking about everything is working on artificial intelligence, for instance. Now, when we, even, when I was traveling to Dubai, I had to go through a screening process where my biometrics were taken, and I mean, all this data is going somewhere. We don't know where, but as per the laws, I mean, I'm from India, so I can tell you from Indian perspective that in India, if you are collecting a data, you need to get the permission from the person from whom you're collecting the data, and also you need to inform them as to how you're going to process it, and the security measures that the collector is going to take. So can you throw a little more bit light on the fact that all the data which is being floating around everywhere, even for, let's say, for this conference, we had given our data. How do we deal with that? And across the globe, it's not one restricted to one country, because here we are from all different jurisdictions.
So excellent point again, Ray. I mean, what he mentioned was that, when he traveled, so same thing when I traveled from Singapore, right? They basically, at Singapore Changi Airport, in Terminal 2, if I'm not wrong, where I traveled, it's all using AI. So I put my passport in, I'm talking to a machine. The machine takes the data, everything is in the cloud. But the problem, and my fellow panelists, he will answer the second part. I'll throw him the spanner now. For Singapore, the data privacy laws do not apply to the government. Okay? It's as simple as that. Whether I like it being a citizen or not, it doesn't matter. The government has all the right to collect my data. It's very different in Europe. and in Canada, and he can comment on it later on, right? So when the government collects the data, who is the actual people behind managing that whole cloud service, right? So in the case of Singapore, I was just talking to Vikram earlier on, right? It's managed by Infosys, the Indian company. They have got the entire back engine of Singapore government. Okay? So everything is in the cloud. Where in the cloud? It's in the cloud. Which jurisdiction applies?
Nobody knows.
Nobody knows. And that's where the tech companies have problem with China. And China has a problem with tech companies. Right? So, for me, as much as I didn't like my data being collected, if I don't do that, I can't come to Dubai. The government is saying very simple, no, talk to the machine. So I talked to the machine. So when I landed at Dubai airport this morning at 2 a.m., which was at the Emirates terminal, and they make you walk a lot, again you can see there is a lot of cameras, a lot of images all being taken. Now, I may not like it. Do I have a choice? You got no choice. So I think it is a tough thing when it comes to government, and that's why I come back to my first point. You as the data subject, as what they call it in Europe, or in Asia, we call it the individual, need to know what is the purpose, that means the C, when they're collecting. How are they going to use it? How are they going to dispose and store it? So in Singapore, they tell you we will use it as per the law. What is the law? It's for the law to define. Okay? So they are very, very clear about it. So I will let over to you, sir.
So I think, thanks Sanjeev, and I have a follow-up question to Ionis on this. What I felt, during what Sanjeev was talking about, can there be a data holocaust? As in, if one center is collecting all our biometrics in one center, one company is doing it, and you can obviously add to the concept that Sanjeev has built on, but also if you can answer the question, if suppose one company decides to shut the server, will all our data be gone and none of the servers of the airports or offices, biometric systems will stop working? Can that be stopped? And how? I mean, what are your thoughts on that?
Well, that's indeed an excellent point, and thank you, many thanks for that, because it touches upon a core privacy principle which is called transparency. So the principle of transparency is absolutely critical in the new European privacy regime. And this principle of transparency mandates all organizations, as we call it, data controllers, to proactively inform the people, the data subjects, on the purposes that their personal data are collected, where this personal data is going to be stored, for how long, where it's going to be transferred, and what measures have they taken to secure this data. So, in my opinion, the difference between the GDPR and the other European privacy laws versus the privacy regimes in other countries is exactly the criticality of this transparency principle. As my fellow panelist very rightly pointed out, this is not automatic in other privacy regimes. So people may do not know why their data is being collected, where it's going to be stored, to whom, if at all, is going to be transferred, and for how long is this data going to be retained. And this lack of transparency creates many issues, creates uncertainty, creates confusion, and doubts. So one of the key aspects of harmonization would be to, let's say, expand this transparency principle to a global standard.
Thanks for that. That's very interesting because I think my next question is quite connected to that. So when you say that there's, in the dissemination which happens to people who are sharing data around the world, there's confusion, and one of the reasons why there is confusion is because we are not certain, or we don't know, we don't have the knowledge of what the other jurisdiction has to offer from one jurisdiction to the other. So I mean, for instance, there are, and I think before the panel discussion started, me and Ravan, we were talking on this point. So I would pose this question to Ravan, that what in your opinion, I mean, what INS was hinting at was that there is confusion because probably we don't have, I mean, we are busy working in our own jurisdictions, and so we don't know what's there in the other jurisdiction. So, what are what's your opinion as to the challenges that would come to us if we try to harmonize the data privacy laws around the world?
Thank you, Ray. As I said before, it's very important for global data harmonization because every country, I think the local laws and regulation in each and every country is rigid. Some certain countries are rigid to their laws and regulation, and they want to apply it, and the residents there, they have to comply with the laws and regulation. When we have like a convention between countries or international agreement to have a global data privacy law, like GDPR or European or any other law or regulation, it will be more practical. At least when you go or travel all over the world, you will know which jurisdiction will apply to you. However, this will not be easy unless all countries have one convention or agreement. However, UAE Protection Data Law number 45 of 2021, I think it harmonized the data privacy or data protection because most of its common things, it's from GDPR, about personal data, about sensitivity of the data, confidentiality, how to secure it, because it's a risk. Data floating is a risk all over the world. What organizations has to do, how to protect their data, sensitive data, because for example, in any organization, the HR, the legal department, the finance, they have the data of all the employees. This is very important. So the employee in each company is the owner of the data. He will transfer this ownership to the company. So this company has to take proper management in order not to disclose this risk, because this is a very big risk and high risk. They have to be transparent. However, they have not to share the data unless there is consent from the original data owner, he is the employee. Even they cannot share it with governmental authorities unless there is, for example, a letter from the government or letter from the judicial committee or letter from the court that we need this data. Otherwise, it has not to be disclosed to any third party or shared with any third party. When we are doing, for example, we want to share our data, we do the KYC, know your customer or know your supplier, in order to understand who we are dealing with, and we do NDA agreement, non-disclosure agreement, before sharing any data, in at least to help, and our data will not float to any third party, and reduce the risk for sharing this data. As well, it will be part of our confidentiality agreement when we deal with any third party from legal perspective. And we put all the data sharing, data privacy, the NDA annexure as part of any agreement we will do with any third party.
So I remember when you spoke about KYC, the very interesting incident which happened recently with me. And I think it would also be a nice anecdote for this panel discussion. One of the clients that we were dealing with, they were producers of a product of a machine, like a photocopier machine or scanner, and they were selling those scanners in India, and every scanner would have a barcode on them. And what used to happen that they said that whenever something goes wrong with our product, by using an app on your cell phone, you scan the barcode, and the information would travel from India to actually Japan. It'll be stored there, and it's only a QR code. So the query from the client was that do we need to comply with data privacy laws in India? And their view was that you wouldn't have to, because it's a scanning of the barcode, and basically barcode is not private information, because you cannot identify a person with that code. You can identify a machine, but not the code. But when that query came to us, we delved deep into it. And then we realized that actually the phone, the app that you download on your phones, whenever you're scanning and sending something, your phone details they are transmitted. So ultimately, you can be identified because every phone has a machine number, and actually they can take down your mobile number from there. And once they've got the mobile number, then they connect with the service provider, and they can get all your details. So ultimately, all those informations were being carried over to the server where these information were being stored. So sometimes we are faced with situations where we, at the first instance, think that this is not private data. And then when we delve deep into it, we realize that, oh, this is actually private data from in a different country. So they had their own laws as per which they said that this is not private data. But we gave a different opinion. And then we later supported that opinion with a few judgments from the Supreme Court of India. So I think what I mean to say is that, as you said, KYC, we take down KYC. That's a direct form of private data. But there are many hidden forms of collection of private data which people are not aware of. So I think if Mr. Ionis can take up that and let us know what, in his experience, certain such interesting cases you've come across wherein hidden private data is being transmitted and the clients are not aware of the compliance issues.
This is also another very interesting point in my view, because it touches upon the thousands of, let's say, day-to-day applications of data transfers and data storage around the world. There is another core privacy principle which is called privacy by design. So this principle has been a best practice prior to the GDPR, and after the GDPR came into force, it became mandatory. And this principle, in very simple words, practically mandates that in every product or in every service that you are about to launch, you have to incorporate privacy as a default setting. You have to incorporate privacy into the design phase of your product or service. So in the example that you brought up, Ray, clearly there are data involved. Clearly there is processing of data by accessing the scanner. By scanning the barcode, you get immediate access to the data stored into this machine. So since you get access, you can have also personal data stored therein. And by accessing them is exactly the same as copying them. So this principle of privacy by design has to do with minimization of storage. So this data should not be stored in the first place in the scanner, or they should be stored, but for a particular period, and then should be eliminated. It's exactly the same like in the CCTV cameras. It's exactly the same
When
principle.
when you say particular period, is that a very short period of time, or like maybe 1 day or 24 hours or something like that?
Yeah, it could be 24 hours. For instance, through the access card to enter a room. Your data is being stored in the access card, but usually after 24 hours, it's being deleted automatically. So the same should happen, and this is one of the many applications of privacy by design. So you design your app, you design your product in a way that privacy is incorporated therein.
Understood, understood. So Sanjeev was telling us about a story before while we were having coffee outside about one of the incidents where certain personal information was passed to 51 people who were not supposed to receive it. In such situation, and if you can narrate the incident, and in such situation, in your view, what can be done to save the privacy of the person?
Okay, so it's again an excellent question. So before I answer that question, I just want to add on to what my both panelists, my right and my left, have said. Right, two very important points on privacy by design, which is mandated in Europe. Right, when you talk about new product implementation or using new technology, whereas in Asia, privacy by design or privacy impact assessment, as they call it, it's not mandated, right? And then the other point that he brought out was on data anonymization or minimization, right? And how long do you keep the data? For example, if you travel on Singapore Airlines or even any other airline, and if you're a European citizen, right, they ask you, are you a citizen of Europe? And then you put the tick box, yes, right? So they will keep your data for the period for which you are traveling or the duration, right? And once you complete the travel, they will purge your data. So it's mandated, they have to do it. They cannot keep your data forever, right? So it's very, very important that organizations and companies realize that, right? And just to share with you one example, before in Singapore during the COVID time, right? The government basically knew exactly where Sanjeev Gatani was traveling. A to B, B to C, C to D. Because you had to on your Bluetooth, and every building that you entered, they knew. Every place that you visited, they knew the date, the time. So if you were a naughty boy or a naughty girl, you would get caught. Because every data they had. Okay? So coming back to answer Ray's question, the example that I gave was one of my clients, right? We were giving them an award because they'd achieved their sales target. So my HR manager, being very smart that the person is, sent out an email saying that congratulations, Ray, congratulations, Sanjeev, you have achieved your targets for the last quarter. Send it to 51 other people who had absolutely nothing to do with it. And my bank account number, my salary was disclosed to them. How cool is that? 51 people that in the company that no need to know my salary, knew my salary, they knew my bank account. And worst of all, the email that it was sent out to is your Gmail and your Hotmail and your Yahoo Mail. So can you imagine how cool is that? And when I asked my HR manager, I said, what have you done? It's okay to share this information. It's not personal data. I said, how it's not personal data? My bank account number is different from hers. Am I correct? My salary is different from hers, right? And exactly what he said, it's personal identifiable information. I can connect the two. And it was a boo-boo, mate. Right? And just to add one more thing, and then I'll pass back to you, Ray. We talk today, we are living in the world of IoT, Internet of Things. Everything is connected, right? There is nothing that is not connected. Tell me what is not connected. Today you have your mobile phone. Every mobile phone has got an IMEC number. Am I right? By virtue of that, I can basically know what you're doing and I can get all the information that it's needed. So I just want to share with you one experiment that I did. And I'm not suggesting you all do it. So please do not do it. I'm putting the disclaimer right up front. Before you all come and sue me, because they're all lawyers here, I don't want to get sued. So I did this simple experiment. I developed an app under my own company. Okay? And nothing illegal about that. You're allowed to do that. I got developers from China and Russia to do it. And basically this app, it's a app that, collects information. And I said that, I'm doing a survey and the first prize is around the world business class trip. It doesn't matter whether I actually fulfill it or not. Okay, it's round the world business class. And one of the T's and C's inside there, which I embedded, and he can comment on it and you can comment, right, is you will give me your firstborn child. Are you with me? If you're a man or woman, of course you are in marriage, we say legally, your firstborn child will be given to my company. Okay? Yeah, you all laugh. Believe me. Yeah, if you have one. I mean, most of them have more than one. But I had 500 people who signed up, and everybody ticked and were willing to give me their firstborn child. Because they never read the T's and C's. So when you are talking about what you said, the apps, all the T's and C's are so fine printed that you don't even know. Right? And just to add a simple twist to it, if you order pizza in your own country, right, through your mobile, why does Pizza Hut need to know or have access, or Domino's, or whatever pizza that you have, to your photo album of your phone? But if you don't give them the access, you cannot go the next step. That's exactly what happened to me when I booked my hotel booking at Crown Plaza through Expedia, through my phone. They wanted access to my address book. They wanted access to my photo album, to my contacts. What has this got to do with me making a booking at the hotel? Food for thought. Okay, so I think I talked enough already.
Those are interesting points, but I think Ioannis wants to add something on that, right?
No, actually, that's exactly, Sanjeev, that's really excellent points. That's exactly, ties back to my earlier point on privacy by design. So these apps should never allow access to your address book or your photos. Never. By design, they should prevent it.
Correct.
And that's exactly the situation. If someone tries to, let's say, to check the most popular apps around the world globally, it's not only in Europe, globally, we will find that 8 out of 10, they are not privacy compliant. They're not. Because, for instance, take a health app. You take a run, you have your app, your run static. It's by coincidence the example to measure your heartbeat, to measure your blood pressure, to exactly identify the exact location where you run. And then the app automatically shares this information on the media without your consent. So this is a classical example. It has to do with health apps as well. So you upload an X-ray in the app to get a medical opinion, and this, you make a mistake. You want to delete it. You cannot. Once you upload it, as Sanjeev said, it's up in the cloud. Which cloud? Nobody knows.
God knows.
God knows.
You want to add something?
Yeah, I want to say a comment related to Facebook and other social media.
Ravan, I think. Yeah.
I want to say a comment related to Facebook or other social media like Instagram or whatever. Please don't share private information, especially your, or put the password as, for example, your date of birth or your children. There is some very smart hackers, they know everything. And not just hackers, there's a lot of people behind the scenes, they know everything. And don't share your, for example, private occasions, because everyone know, I went to this restaurant, I have to put my pictures. They know everything, they know your connection. They know even there is some psychiatrists, they are analyzing how you think, what even you eat. They know everything about you, by your picture, by everything. So please be careful. And I want also to comment related to the HR. You can sue the HR, Ray. This is from legal perspective. Secondly, an investigation has to be done internally inside the company. Third, the legal and compliance advisor or professional in your company, plus investigation, they have to make a legal register to assign responsibility, like visa and passports. We all, if we are residents in UAE, they will take our passports, our visa, our children's passports in order to do the residency. So they know everything. Even sometimes they take the rent of the house rent contract in order to apply for the residency. So we have to be careful when sharing. Don't share via WhatsApp, please. Don't share your passports. It has to be a secure email. This is also another important thing. No, don't say I am busy. Please don't share WhatsApp. WhatsApp is not secure. I'm not telling anything about WhatsApp. However, don't share your personal important visa or passport or your identity through social media. This is also very important. And in any organization, reputable organization, they have to assign accountability and responsibility to each department, especially the HR department, because they have all the sensitive and personal information. They will be liable, legally liable. This is very important. That's it. Thank you.
Sorry, just one thing I want to add to all my fellow professionals down here. How many of you here are using the free Wi-Fi that is provided for by the hotel?
Just.
Hands up, please.
Oh my God. Oh
come on,
my
come on,
God.
ladies and gentlemen, you can do better than that. So my free advice to you, when it's free means you are free. When it's free means you are free. How do you know who is not watching what you are doing now? Food for thought. Think about it. Because to hack whatever that you are using now, it would take, and not that I'm going to do it, please don't think that I'm a bad guy, I'm a very good guy. It'll take less than 45 seconds. Right, sir? For me to find out everything about the young lady down there who said that, you're using the free Wi-Fi. It's as simple as that.
Actually, somebody wise told me once that nothing comes for free.
Exactly, no free lunch in life.
No free lunches. So if you are getting something for free, that means they are earning out of you. So, but I think we are running short of time. One last question which I think I need to pose to the panelists is that, do you think it is time that, like how the arbitration laws evolved in the world, around the world, and then all the countries came together and they came up with the Geneva Convention and the New York Convention. That is point number one, and your comments on that, because the life becomes very simple once you have an arbitration clause in the agreement. And if you're a Geneva Convention country, we know everybody knows the law. A New York Convention country, we know the law. So it's very simple for two parties across the world to enter into agreements. Is it time for global privacy laws to also come to that level? And your thoughts on that. And I think we'll then open for question and answer rounds.
So I believe that now it's the perfect time. As earlier mentioned, there were huge gaps between the different privacy regimes in the recent past, but now we have the GDPR, we have the CCPA in the US, and the new Data Protection Act. We have the new Asian privacy laws, as Ravan mentioned, the new UAE data protection law, the new law, the cybersecurity law in China, the other privacy regimes that have many commonalities. So it's definitely the right time to harmonize in data transfers, in data security, in expanding the principle of transparency. And there are many common aspects that can be harmonized, in my view.
Sanjeev?
Yes, so just to add to what has been said, so Asia, we have started this already. So in Asia, we got this thing called the APAC, right? It's all the Asian economies, right? They've come together, exactly what he's saying, to harmonize the privacy laws, just like what they have done for finance. So all those who are in finance, you know, IFRS, right? International Financial Reporting Standards. They have harmonized it across the globe. So I think it's just a matter of time. And I think this will definitely take off because US has got its own laws when you talk about data transfer out of the US and out of Europe, right? So it's a matter of time. And the sooner we do it, the better for us all. Because the world has changed, and I think COVID-19 has taught us the new way to live life.
Ravan?
Thank you for everything. This is first. Second, I think this is the time for global harmonization for data protection and privacy, because we will reduce the risk of data floating. Because as we said before, data is floating all over the world, and we don't know in which cloud it is, especially all our personal and sensitive data. And it's a time manner, as my fellow say. I wish it will be as soon as possible.
Thank you so much. I think, in my view, just to conclude this topic, I think it's important to at least, the legal communities and the business communities around the world should come together and at least agree to a minimum standards of global privacy laws, because every country has a different cultural background. For instance, I can tell you about India. There are many, at times, it's been an agrarian economy. So majority of the people over there have been farmers. So a lot of government policies are built around farmers. And a lot of subsidies, they go directly into the bank accounts of farmers, especially now, because a lot of bank accounts have been opened for farmers. So I think what I'm trying to say is that every country has its own unique cultural backdrop with which the laws are framed in that particular country. But having said that, I think data is something which, around the world we should sit, and then the legal communities and business communities should sit and decide on certain minimum standards for data being shared around the world. And I think finance included, because financial reportings are everywhere, because you have valuations going from here to there for investment purposes. So I think that's, thank you for your views on this issue, and I think I can open the floor for questions.
Thank you very much, panelists. That was a lot of valuable insight. There is a microphone in the center of the room. This is the new way, ladies and gentlemen. So please feel free to stand right in the center and ask away. Go ahead.
Okay, I wanted... Can you hear me?
Yes.
Okay, my question is, if you ask for data harmonization, there's another side of the coin. I mean, I agree with everything that you've said. Every point is a valid point that you've discussed. But how do you deal with harmonization when it comes to developing countries or underdeveloped countries? Can you ask them to comply with those data privacy regulations which are done by the US or by the EU? And if that is so, I know you give the reference of arbitration and the financial reporting, but these are voluntary processes. Data privacy is not a voluntary process. I mean, as you all mentioned, it's absolutely involuntary. You're compelled to do things in a situation where you don't have a choice. So how do you manage the developing countries or the underdeveloped countries?
I think all four of us can answer that, so you need to tell us whether you're asking Ravan, me, or Sanjeev.
I mean, anyone who has an opinion on this. I mean,
Yeah.
because all four of you said about data harmonization is required.
Right.
And I agree with it, but how do you deal with this?
Thank you for your question. This is a very important one. However, from legal perspective, for example, when we do NDA or any agreement, we will choose which jurisdiction we will comply with. For example, if we are in UAE, we'll choose the UAE data protection or data privacy law because we are in UAE. Unless we choose another jurisdiction, EU or Asia or whatever, what else jurisdiction, this is very important, using the jurisdiction. This is upon agreement between you and the other party when you do any agreement. So choosing like arbitration, you choose arbitration in the IFC or you choose arbitration in UK, it's the same. Or litigation, when there is a dispute between you and the other party, we choose UAE courts or you choose Jordanian courts or you choose UK courts. It depends on the agreement. This is the most important. And sometimes it depends on if there is dispute, what is the cheapest way for this dispute. It will be in UAE, it will be more cheaper than UK or US. So also this is another point of view.
Good morning. First of all, thank you very much actually for this important topic that's now is more arising, and we have witnessed new laws that have been enacted in the region, including UAE, KSA. Okay, I have been all the time actually talking about data privacy because I wrote about those things 20 years back in my PhD thesis. And one of my key issues and key concerns actually is using the data for marketing purposes. So what's your take actually about what Facebook is doing and other social media, but in specific Facebook, because it has been used or misused actually dramatically in so many occasions by big names, and we know what happened with Cambridge Analytica, for example, okay, how they manipulated the data, and what sort of protections that we can put in place to protect, our personal data from misuse under the coverage which is called, marketing utilization, and what sort of actually interference the regulators can really impose in terms of safeguarding our personal data from not being misused for purposes which is not the original purpose that, the authorization or the consent that had been given to the, the Facebook or the, any other social media platform to be used. So the extent where we can, protect ourselves, and sometimes what sort of, education the users should know and how to use and to protect their personal data when it comes to any social media platform. Sorry, I have another 10 questions, but I'll stop just here. Thank you.
So I would like to take up this question, if I may, if my co-panelists agree, because it's one of my favorite topics, the one that you brought up. Actually, the two major global privacy laws, the GDPR and the CCPA, have 4 principles in common. That's the principle of accountability, transparency, data minimization, and data security. So this could be the basis for the global privacy laws harmonization, in my view, starting from these 4 elements. But to come to your point, it all ties back to transparency. So if you inform the person, the data subject, for what purpose you collect the data, you cannot use it for a different purpose. It's illegal. It immediately becomes illegal. So how you inform it? Through the privacy notice, through the website. Everybody, every organization is obliged to have a privacy notice on the website. And this privacy notice, amongst other information, has to inform the visitor of the website for what purpose they collect and use the personal data. And they cannot use it for any other purpose unless the data subject gives informed and specific consent. So it immediately becomes illegal. It's as simple as that.
Yes, so just to add on to what I have said and to the question, it's an excellent question. So Facebook is known in the marketplace for what they have done. And I believe there is a landmark case in Europe where there was a guy that sued Facebook, right? Because he wrote to Facebook and said that give me what personal data you have of me. And prior to that, he had deleted his account. Facebook gave him 4 disks of his own personal data, and then he sued them in court and he won. So it's a landmark case in Europe. But the more important thing, like what my fellow panelists said, that 4 principles that are in CCPA and also GDPR. That's one aspect. But the more important part is what my fellow panelists on my left said, it's what you put on the social media. We as humans love to show off, right? If you come to Dubai, you want to tell the whole world you went to Dubai, right? If you went to stay in the Crown Plaza, you want to put what you do in your bedroom on the Facebook. For what? Why do you want to tell the whole world what you did? So if you feed that information to the social media platform, they are going to use it, right? And the point again on the privacy notice where you put up on your website, in Europe, they are very clear. It has to be plain vanilla. Plain vanilla means not your vanilla ice cream. Huh? The English got to be simple. You cannot put the Queen's English where people don't understand. So your marketing question, what you said, it's very interesting. In Singapore, we have this huge debate between the Direct Marketing Association of Singapore and all the companies, right? And we clearly now, under Singapore law, privacy law, you need to explicitly state the purpose of you collecting the data, and you have to give the individual the option to opt out. Not by default, the tick box. The person has to tick electronically, saying I opt in, opt out. And you cannot then threaten the person or tell the person that, oh, if you don't tick this way, I won't provide you the service. Because there are many companies that do that. But your question is excellent, and we can talk all day about it, but I don't think we have all day.
Thank you very much, ladies and gentlemen. We are all out of time. Please put your hands together for this incredible panel. Oh, fantastic.
Healthy ecosystem.
Thank you.
Or educational ecosystem. Also, when we talk about
I didn't know about this whole Wi-Fi thing. All right, if we can have hotel staff please remove the tables and chairs, as we will be commencing our awards ceremony. In the meantime, who is following the FIFA? Yeah? Who's going to win? France? Say aye. France, yeah. Oh, not so many. Argentina? Oh my goodness. Are you Argentinians? That was your prediction from day one. May I ask why there is so much belief in Argentina? Messi. Yeah, but Benzema is now going to be playing, everyone. What about that? Yes, sir. Proper pictures with this inside. I'm holding on. I'm talking about FIFA. No, I think we should do it. You can do it. It's a shame Morocco didn't win. It would have been a beautiful thing for an African/Arab country to make history. Yeah? Next World Cup. Yes. Saudi won a lot of people's hearts. But they had a French coach, right? Thank you, gentlemen. Okay. I'm Canadian, and I do believe that Canada should stick to hockey. Yeah? We didn't make it very far. Saudi made it further. Thank you. All right, ladies and gentlemen, it's time for a special recognition session dedicated to appreciating the change makers of the industry. And I would like to invite Dr. Abdelrahman Ahmed Omer, CEO of Burjeel Hospital, on stage, please, to award the awardees. Mr. Omer? I don't know if he was here this morning, but Dr. Abdel Rahman? Is he here? Hello? Organizer? I'll just have to call up random people to present. Dr. Abdel Rahman? How are you? Sandra, nice to meet you. All right, please welcome Dr. Abdel Rahman Ahmed Omer, CEO of Burjeel Hospital. Okay, so you will assist me in the awards giving, correct? We will give awards. Yes, go ahead.
Thank you for calling it assistance. I will just hand them over.
Yes, you will hand them over. Fantastic. All right, ladies and gentlemen, the first award goes to, where I got to put my glasses back on, you know, it's new. Virginie Tassin Campanella. Congratulations, Virginie. DJ, do we have a little ambiance music? Congratulations. And we could pose for a photo in the center of the stage. Congratulations. Congratulations. Next, we have Mark Saya. Congratulations, Mark. Are you in the house? Yes, you are. Can we center the... Congratulations, Mark. Our next awardee is Upendra Nath Sharma. Congratulations. Come on up. Congratulations, Mr. Sharma. Well done, thank you. Our next awardee is Yung Boon Uy. Congratulations. Thank you, Mr. Yung. All good, Professor? All right. All right. Next we have Miss Aliyah Alzira. Congratulations. Miss Aliyah. No. We will hold on to it for Miss Aliyah. I believe she is not here. Okay? Okay, our next awardee is celebrating a birthday today, I hear, Mr. Rahul Totala. Congratulations. Happy birthday, happy birthday. I won't ask you how old you turned. Next we have Aditi Tomar. Congratulations, Aditi. Congratulations, Aditi. Our next awardee is Mr. Mohammed Al-Qasim. Congratulations. Oh, he is not here. I'm sorry. My mistake. We shall skip him for now. Mr. Franco Taish. Or Taik. First or second? What is the proper pronunciation, sir? Taish or Taik? Taish. Congratulations, Mr. Taish. Congratulations. Our next awardee is Alif Fazal Boy. Congratulations, sir. Come on up. Congratulations, Mr. Fazal Boy. Our next awardee is Dr. Faisal Khazal. Congratulations. Dr. Faisal Khazal, Elite Capital. Our next awardee is Niraj Gupta. Congratulations, Mr. Niraj. Congratulations, sir. And down to our last three, Mr. Amer Halawi. Congratulations, Mr. Halawi. Thank you. Congratulations once again. And down to our last two, Mr. Wasim Jarkas. Congratulations, Mr. Wasim. Congratulations. Mr. Ish Anand. Congratulations, Mr. Anand. Thank you very much. And I will call again on Surav Ghosh. Mrs. Surav Ghosh. No, not here. All right. Doctor, thank you so much for helping me today. Let's hear it for Professor Dr. Abdelrahman, founder of iBlockchain. Here, would you like to say a few words, sir?
To start with, for those who came to Dubai the first time, welcome. It's addictive. You're going to come back again and again to the UAE. And those who live and work here, thank you for being part of the beloved country that we all love and live in. My journey is lifetime. It's Dubai and Abu Dhabi, actually, and UAE. And I'm sure that it's going to be part of your lives. Thank you very much for your participation, for every single human on this planet, for prosperity and future. Keep it going. We're all behind you. Thank you very much.
All right. Congratulations to all the awardees. And with this, we move on to our first keynote session of the day. A decade ago, clients were largely passive recipients of legal services, receiving a one-size-fits-all model. Today, clients are much more informed and much more active. This has led to a radical shift in how clients perceive the law and consequently how they engage with lawyers. Keeping this in mind, what does the next year look like for legal experts and for legal representation? Please join me in welcoming our next speaker, Ms. Vanja Mejevan, founder and CEO of Lawrence Legal. Welcome, Vanja.
My name is Vanya.
Vanya. All right. computer is there.
Good morning, everyone. Thank you very much to the organization committee for having me today for this very first edition of the Law 2.0 conference in Dubai. My name is Vania Mejvan, and I'm a Swiss attorney registered at the Geneva Bar. I practiced for 7 years white-collar crime and art law in a very well-renowned law firm in Geneva in Switzerland. Before I decided to change paths, as I clearly saw that the legal industry and legal needs were shifting. And so 5 years ago, I decided to launch the very first legal tech company in Geneva, Switzerland, actually. And the company's name is Lawrence, your reference in law. It's a B2B, B2C marketplace that operates digitally, mainly. A bit of a disruptive way of operating, untraditional, of course. We mainly use a legal platform that allows clients all around the world to ask their legal question, and a very fast and automated algorithm is actually putting in touch clients with the right specialist that would enable us to enable them to solve their legal issue. Actually, when I was practicing as a legal specialist, I discovered and I felt that clients were not sufficiently redirected when it came to the first preliminary legal orientation. They wouldn't really know whether they actually needed a lawyer and how long or how much the legal proceedings were going to take or cost, and whether actually it was worth engaging legal professionals and having legal specialists. So today, this algorithm that my team and I have come up with a couple of years ago presents a very broad, but quite broad solution and preliminary orientation to the client that has a legal problem and encounters a legal problem. So he could actually decide by his own means if it's actually worth engaging with a legal specialist. So it's a B2B, a B2C marketplace. Not only clients, but also lawyers are able to use this platform, as sometimes we might be, as legal professionals, quite specialized in a legal area and need other people's and other specialist skills to solve a problem. I'm thinking, for instance, of divorce law, where a divorce lawyer might not be so specialized for all that regards taxes when it comes to dissolutions of a marriage, and would actually engage via our platform, finding another legal specialist that could actually jump in and work on the divorce case next to him. So we also operate in a completely unusual way marketing-wise. We use a lot of social media, Instagram mainly. I would be very happy actually to discuss furthermore with you potential collaboration, as we're expanding in the UAE since 2 weeks now. So it's a really new venture that we're trying to do here, and I invite you to follow us on social media or tag us if you feel like it. But actually, let's come back to our current topic. I'm here today to present you the current legal tech countries and actually the shape of the legal tech industry in 2022 and the structural changes that we might expect in 2023. First, let's talk about the legal tech leading countries, as well as the capital that was raised by these countries in the past 2 years, reflect then on the ability of smaller countries to become legal tech leaders, and analyze the current regulatory frames that surround legal technologies, namely the European AI Act. Then I would like to share my thoughts with you on the structural problems encountered by the traditional legal market for both clients and legal specialists, lawyers, before truly discovering the 3 main legal tech trends that are expecting us in 2023. Finally, I will show you the newest inventions by 2 major legal tech companies that will hopefully blow your mind as much as they blew mine a couple of weeks ago when I actually discovered them. So 2022, where are we standing today when we are thinking of legal technologies? As you all know, legal technologies were almost inexistent 10 years ago. USA were, of course, a country that was the most advanced in their research and their discoveries, and I'm mainly thinking of private-led companies such as Ross Intelligence that you've probably heard of, that was founded in the early 2000s. It's the very first legal assistant, and it's a joint venture between 2 wonderful men that I had the chance to meet a couple of years ago in San Francisco, a lawyer and IT developer that actually were living together and not really getting along as flatmates, but one day around a beer they decided to discover each other's passions, and they came up with the idea of creating the very first legal assistant. And this was back in 2010. 2010, sorry. And since then, there was a fascinating development and evolution in the legal tech background. Today, almost every single European and leading country, Asian country, has a legal tech association, legal tech department within their governments and administrations. And the newest legal technology trends are now Asian, Middle Eastern, Singapore, Seoul, Israel, figuring on the top 10 of the leading countries. Now as I told you, I come from a very small country. You all have heard of Switzerland. And when I actually first thought of launching this legal tech of mine a couple of years ago, the actual interest and the consideration rose. Is launching from Switzerland a strategically good idea when it comes to legal technology? Small countries have a very clear advantage. I'm also thinking of Israel when I'm talking about small countries, because Israel is one of the leading legal tech countries nowadays. They have a clear advantage as collaboration between governmental administration and universities, institutions, is very, very close. Industries and governments are extremely close, and we do thrive for innovation. We do thrive for technological evolution, as universities and institutions are considered as the best worldwide in these very small countries. Today, major companies such as Google and Facebook hire from Israeli and Swiss institutions. I'm sure you have heard of Herzliya Legal Tech Department, as well as ETH in Zurich or EPFL in Lausanne. These are really very, very forward thinkers in terms of technology. And now today we're very lucky to count also very interesting computer science and legal tech department in all these universities. When I first launched the company a couple of years ago, it's true that it was a bit of a tricky decision, as small markets are extremely tricky. Being small comes with a very heavy cost. We lack data. Their population, these small countries' population are not big enough to enable a very big international outreach, and very often language becomes a huge problem and a barrier to expansion. In Switzerland, as you know, we have 4 national languages. We have 26 cantons. In Israel, there's a Hebrew that might be a major barrier when it comes to international expansion. And although technology might be very good and the collaboration between institutions, governments, universities is quite advanced, there is a major barrier, and this is data, expansion, and population. The main legal technology companies today are based in the US, and this is not a breaking news. We're thinking of IBM, we're thinking of Betty, of Joseph, of Immigram, Docket, Digital Walk, to name a few. And all these companies are amounting to a funding total of 68 million. But this shows one thing, is that legal technology is moving extremely slowly, at a very, very slow pace, as it took 10 years for these companies to achieve their current status. When we compare it to other industries and other technologies worldwide, legal tech is really booming in the past 2 years, but it took them a very long time to get started and paced up. Moreover, the 2 past years were the busiest ever for the legal tech and new law investments, as well as M&A activity, with $2.5 billion in total funding. There were 160 combination deals plus 220 approximative fundraising only last year in 2021, which is a record for the sector, legal industry, and new law investment. Also, the majority of investment and deals took place in North America, as 73% of these deals happened between New York, Seattle, Boston, and the Silicon Valley, with the US taking a notable but far smaller share, around 6%, and 21% of the deals took place in the rest of the world, mainly in Asia, Berlin, and Israel. Out of these $2.5 billion, $1 billion was raised in private APOs, $1 billion in high-tech experts, such as cloud solutions and cybersecurity, which we'll see a bit later on, whilst $500 million was invested in legal tech unicorns. Now, as always, whenever there's novelty, evolution, and innovation, governments have to put their noses in it to ensure that innovation is compliant with both data protection and international regulation. And we saw earlier this morning with this fantastic panel that data protection is one of the hottest topics at the moment. It's indeed extremely important that our data is protected. But now today, there's a European act called the AI Act that actually got that was passed in last April 2021. It's a European Act on Artificial Intelligence, the first law on AI by a major regulator anywhere in the world, and it ensures that AI doesn't affect any part of our human lives and forces government to respect a certain risk benchmarks. So when it comes to the European AI Act, like the GDPR, General Protection Regulation that was passed in 2018, the European AI Act could become a global standard, determining to what extent AI has a positive rather than a negative effect in our lives. So now we could ask ourselves the question, is regulatory and regulations in legal tech industry absolutely needed? Is it a push, a pull? And as much as myself, I'm a very strong believer in rules and regulations, Switzerland being a very strong regulatory framework. As you know, like most of countries and arbitration panels use Swiss law as a leading law everywhere in the world. Other countries even copied our legal system to incorporate it in their own legal system. I'm thinking of Turkey, for instance. I personally fear that this EU AI Act, when it comes to legal technologies, will become a major break to innovation, especially when it comes to legal technologies, as in maybe in other fields and other industries, it might be completely different. But when it comes to legal technology and legal industry, it's already led by a set of rules and standards that are moving very slowly. And traditional lawyers are controlling, traditional law firms are controlling this legal tech industry. And these actors are not very keen on change and innovation for the different reasons we know, as maybe the comfortable economical reasons that notable law firms might have, or the fear of lack of data or privacy law. But regulating AI seemed like an imperative to the European Union, and this European Commission is acting as a forward-thinking, self-proclaimed authority in the matter. So this is to be followed very closely in the next couple of months, especially in 2023. Indeed, today's very traditional legal industry encounters 5 major structural problems. We have an increased complexity of law and legal processes, internationalization of businesses and claims, with the moving populations coming from different conflicts or migration between populations and countries. We have an increasing load of court cases and data at a very slower pace, which might become a very big problem in the near future, especially in Asian countries such as India or China. We have competition amongst lawyers and legal service providers, as today universities don't have numerous clauses when it comes to accepting different students, and we have more and more legal specialists, legal service providers everywhere in the world. Timesheet also and hourly billing system are systems that lack modernity, and clients today fear that there's a very big lack of transparency when it comes to big law firms or notable lawyers charging their hourly rates. They absolutely have no way to ensuring in advance that these rates would be actually followed or strict when it comes to a major court case. In this environment, business to business, B2B needs innovation. We have B2B needs and B2C needs, and B2B needs are the document and data search, internal processes and automation, as well as compliance and long-term tracking, whilst clients and B2B, B2C interactions are aiming for an overall, as I said, increased transparency and equality of costs and decisions, provisions regarding costs and decisions, as well as a matching with the right legal specialists. I'm coming back to our own company, Lawrence, that I was introducing to you earlier. It came up with a very simple idea to allow all clients around the world to have a fixed benchmark when it came to legal processes, legal costs, also have a fair decision, as a court decision may fluctuate if there's not a very strict analysis of court data. And we think that artificial intelligence, natural language processing, AI, machine learning, all these automation processes might allow today more transparency and equality between clients, processes, legal processes, and a very strict benchmark when it comes to costs worldwide. So what is awaiting us in 2023? I would like to actually focus on the 3 main legal tech trends that we should watch in 2023. So right now, 2021, 2022, the hottest topic is cybersecurity, and we do not expect that to change in the near future. Large and trusted companies have had their reputations tarnished, and there's a general air of chronic unease within the business community, as it's no longer the case of if a cyber attack happens, but when. The global average of cost of data breach increased of 2 to 3% from $4.25 million US dollars in 2021 to $4.5 million in 2022. The highest it's been in the history of IBM security, and IBM came up with a very interesting report that I would advise you to read, the Cost of Data Breach Report by IBM. Legal departments and law firms will also need to be hypervigilant about the secure transfer of storage of information, storage of documents, and maintaining cyber-safe work practices within their own internal practices. Secondly, as the global regulatory environment increases complexity and scale, appropriately managing regulatory frameworks and maintaining legal compliance has become a significant challenge. Law firms are developing and will continue developing innovative ways to solve clients' pain points, with customized client or industry-specific regulatory workflow solutions, and incorporating a law firm's knowledge and expertise with workflow automation Technology will help clients navigate challenges and regulatory obligations. We will actually have an automated technology and some modern legal technologies platform that could be highly configurable and designed to be two-sided, so client to firm and both firm to client, ensuring the secure transfer information, instruction, advice, and client collaboration before a legal problem, while solving a legal problem, and after the legal problem is solved. Thirdly, cost control. So modern spend management practices and legal technology solutions must focus on the entire process of engaging a law firm and managing a matter, not just interrogating the bill after the work is completed. This starts with ensuring that instructions to law firms from the clients are sufficiently detailed and broken down into phases of work, a bit like an IT company with different flows and workflows and work sessions. A client will now be able to understand at which pace the law firm is going to submit certain information, certain legal analysis, documents, and actions to courts. Best practice also suggests that when briefing matters to outside counsel, the legal team can either send instructions to one law firm or opt to send a competitive brief. And I'm sure you're very familiar of these competitive briefs to multiple law firms to obtain competitive quotes from a law firm to another, from a specialist to another one. And ideally, the decision framework for briefing law firms has an agreed protocol and logic. Technology can be a powerful enabler to streamline and provide a structure for all these matters. And I'm really advising you to follow closely these IBM reports on these very interesting 3 legal tech trends next year. So now allow me to present you 2 innovations that I'm sure you've heard of that were tested this year and will continue to be developed in 2023. Firstly, the Swiss company Deep Judge, and secondly, IBM's Project Debater, by IBM. Deep Judge is considered the future of legal profession. It's the next generation AI-powered legal document processing platform that can automatically highlight and anonymize sensitive information, smartify documents by augmenting them with external data and search for related relevant documents across in-house databases. Project Debater, on the other hand, is the first AI system that can actually debate humans on complex topics. The goal is to help people build persuasive arguments and make well-informed decisions. And I would like actually to show you a small video to show you how far technology can go when it comes to debating against the most renowned debaters worldwide. I have a, sorry, can we launch the video, please? Thank you. Or if not, Project Debater, you should absolutely watch on YouTube. It's a fascinating proof that technology, and with all the data that is available online and in different data systems around the world, whether law firms or big companies, a machine can actually go plunge and dive and find relevant information to debate against brains, human brains, and the most advanced legal professionals worldwide. So I would like to end by a little consideration. What's next, and are we ready for legal tech, the future of legal tech worldwide? Are we all together, all the countries, ready to work hand in hand? What is next for the future of legal tech industry, and how will humans use technology to advance better rather than being pushed backwards and led by technology and robotics? Is the future of legal tech industry led by these machines AI and robotics, or does all these different automative systems and new legal technologies will actually just allow a better performance amongst legal specialists, law firms, and legal service providers? In a world where everything is equally excellent, where performance is reaching perfection, there is, in my opinion, only one space left to innovate in, and this space is you. And on this very note, I wish you a fantastic end of the year and a very innovative 2023. And I would very much appreciate if you could ask me your questions now, as we have a bit of time, I assume, to answer your questions, if any. Thank you very much.
Ladies and gentlemen, do we have any questions for Vanya? Yes. You know where the microphone is.
Good morning, and thank you very much. I have very bad habit that I ask so many questions in my life. So I'll be talking actually about legal technology tomorrow, so I have a big passion actually about legal technology. So my first question is about transformation and readiness, which you are highlighting. How much, what exactly that's needed from legal platform perspective towards transformation? So, and what are the key elements towards this transformation? Is it the laws, the legislative platform, the people, technology, mindset shift, or just a mix or blend of everything? And from where should we start?
Thank you very much for your very interesting question. And actually, I'm extremely thankful for this one. I think everyone should start with human. Human is today the main objective. It takes a lot of place in all different kinds of processes in every single industry, not only legal. Humans have a lot of empathy. And when it comes to technology, robotics might lack this empathy and listening and human interactions. So we should put humans in the center of the attention. What do they want when it comes to legal? What are they expecting? As you know, I mean, you probably, as legal specialists, have encountered a lot of legal situations where people are suffering around us, where they might ask themselves what to do, how to solve a legal issue. And when it comes to legal, I feel that us specialists have a huge responsibility in helping humans advance to our best possible abilities. And advancing, this can be done in different ways, by enabling a very transparent system and actually a world where humans can actually be aware of what is waiting for them. What were the previous court cases in similar situations that were given. And this is all provided by data today. So when it comes to humans and empathy and technology, technology should serve humans. And in my own experience, and a little for 5 years experience, and remaining very humble, I think that putting people first helped us growing really fast. As when you understand their problems, their fears, their needs, it's much easier to adapt technology to these fears and these needs. For instance, our platform will very soon enable clients that encounter an emergency, such as domestic violence, to actually ask their legal question or to ask for legal help using a video or voice recognition tool that will actually measure the intensity of the emergency and link them immediately with the right legal specialist. Also, when it comes to cost cutting and cost efficiency, I feel that maybe clients don't really know where to go when it comes to law. They might have heard of a very good specialist, but from one of their friends that had a legal experience with such specialist, and so they go to visit that specialist. But is this specialist really the one that they should actually go to seek legal assistance from? So all these problems, algorithms actually can solve these problems very easily. They're never going to replace legal help, legal assistance, and legal service providers, but merely they will just help to more transparency, more clarity, and simply more empathy and communication, which is extremely important between clients and legal specialists. Thank you very much for your attention.
There's one more question for you,
Yes.
Miss. One more question.
Wanya, thank you very much. A very interesting session. It always becomes extremely complex when finance, law, and technology come together. With an increasingly globalized scenario, and I want to focus on one domain, the fintech space, because we're talking money here. Let's talk about fintech. Fintech, the regulatory and the compliance regimes across the world are very different, and especially when you're dealing with multiple geographies. Combining technology and the compliance and regulatory piece is extremely complex. We as a company have been trying to do it for 8 years now. We've made some headway, but we're not there as yet. What are your thoughts on that, and how do you think that this particular piece is going to move further?
It's a very interesting question. I would love to know more about fin technology and finance technology overall. I feel that it's going to be extremely needed that both legal tech and fintech act together hand in hand. Merely because, as I said earlier, we might not feel it today, but the increasing complexity of legal processes, legal procedures, as well as internalization, globalization of legal processes because of migrating populations, this will lead to very, very strong need of collaborative tools and practices between different industries. And finance and law are two very interesting, very distinct practices, but actually work very closely together. M&A, joint venture, I'm only naming a few, but divorce, intellectual property, everything is linked to finance when it comes to law. And we might not be feeling it, but also like the cost and the way clients are charged. I'm working today on a very interesting project as well. It links fin technology and legal technology as I was asked earlier this month to be part of a very new legal venture capital structure where lawyers would actually give services and legal advice in exchange of equity from blockchain, unicorns, fintech startups, and AI companies. So we can strongly feel that these two practices will work together. But nevertheless, I think that when it comes to law, humans should be always put in the very center of the attention, while finance may be a bit less. I mean, I have absolutely no knowledge about finance. I'm a lawyer at heart, and I just feel that lawyers should never forget that they're here to solve legal problems and to help people with their own abilities, their own knowledge to suffer less from legal injustices or legal problems around the world. Exactly.
Thank you. We'll
You're
talk
welcome.
about it
I hope
offline.
I answered your question.
Thank you very much, Vanya, for all the insight you've shared with us today.
I'm looking forward to meeting you a bit later, all of you.
Oh, we're here for 3 days. Thank you. Okay. The next panel discussion will address one of the biggest challenges facing the legal system: delays in cases and trials. The panelists will explore ways to ensure fair, prompt, and efficient access to justice while considering issues such as limited court resources, backlogs, shortages of staff, and time pressures. I'd like to welcome the panelists today. We have Ms. Edith Norman, Managing Partner and Attorney at Law at ACG International. Welcome, Edith. Next, we have Ish Jain, International Arbitrator and Senior Partner at Regis Legal. Welcome, sir. Hello. and Ratvik Patel, Director and General Counsel at Tibea Energy, India. Thank Mr. Ratvik, welcome. If you might want to do a little bit of a semicircle. Yeah. So you can click them upwards. Mr. Panelist, the last 10 minutes.
I hope is
Mr.
it working?
Moderator?
Yes.
Who is the moderator here today?
That will be me.
Oh, there is no moderator. You're all moderators. So the timer will be set to 50, and the last 10 minutes will be for questions from the audience.
Oh, wonderful. There is
Okay.
a time management thing. That's amazing. Thank you so much. Well, I'm very honored to be here today together with these fine gentlemen. And it is a hot topic. Let me start with a short round of introduction. Please, Ludwig, I'll start with you.
Thanks. Thank you, Ish. Good morning, everyone, friends. I am Ratvik Patel. I am basically an Indian lawyer, and I work with Chinese MNC. That is the biggest FDI from India to China, TB Energy India. I'm a director and general counsel for this company. And I'm into this field for last almost 19 years. And I've practiced and then I've joined the corporate. So both the way I have tried to touch the work and scope. So this is the brief introduction I would like to mention here. Thank you.
Thank you very much, Ratvik. To you, Ish.
Good morning, everybody. My name is Ish Jain. I'm practicing in the field of arbitration and litigation for now 15 years. Now I practice mainly as an arbitrator since the last 5-6 years. I've been empaneled with about 25 institutes in UK, Middle East, and in Asia. I'm also empaneled with the 4 high courts in India, and done quite a bit of arbitrations in technology, aviation, space law, and art law. So I will try to give my perspective from that jurisdiction, that field, and from the perspective of an arbitrator on the topic today. Thank you.
Thank you very much, Ish. Well, I think it would be nice if I introduce myself as well. Well, I'm Edith Nordman. I'm the managing partner of ACG International in Amsterdam. I am a corporate and commercial lawyer and litigator. I've been doing that for more than 20 years now, originally from Switzerland. That's what I share with Vanya. And I'm also the chairman of the Netherlands-India Chamber of Commerce and Trade. I have a very international practice, and it's good to be here and to sharing thoughts also with you. I haven't shared that with the organization and none with my panelists. I intend to include you as well, because I want, it would be interesting to hear your opinion and your experience as well within this very interesting topic. So I will not wait to the last 10 minutes for Q&A, but I would like to include you, and I will do that regularly. To start with, let's say it's bifold, because one way or another, a non-speedy trial is nice for the lawyers. We have a lot of work, and we like it. Lots of incidents and interesting things, raising incidents, going to arbitration, trying mediation, all these things keeps us going and pumps our blood through our veins. We like that, but we also like happy clients. So there is a bit of a bifold thing here, but we definitely want to do our job right. So, starting with you, where do you see the most problems in slowing down the process?
Okay. Generally, if since I'm part of a corporate, so and especially from the country India, where the laws are very complex and the litigation numbers are very high, and everyone knows about the speed of the judiciary. So the first thing is that we corporate generally do not appreciate the time the courts are taking. So number one. Number two, if we have the problems in the financial recovery, then we cannot wait for number of years that we get the solution from the court. because the Indian constitution is very clear, and not Indian constitution, it's a global jurisprudence. Justice delayed is justice denied. So exactly the same situation is happening. We are working on the problems that we are right now we are facing, that why we are getting delayed. So when we see the laws, that the problems are with legislature, problems are with judiciary, executives. Where is the problem? When we see the Indian laws, for example, we say, we take example of Negotiable Instrument Act. So there is a provision that it has to be finished in 6 months' time. If we see even Civil Procedure Code, which is the oldest, even was incorporated or constituted prior to the independence of the country, it also has the specific clause in which the courts will have to give the justification why they are granting the dates further. So the laws are clear, legislature is very clear, then where is the delay? Why this problem? Then obviously the matter goes to the judiciary. Without any intention, I would like to mention that if we see the role of judiciary, and when suppose if there is a foreign direct investment like we have in India, or any corporate or any other person, if he's coming and want to face the litigation, then it will become a very difficult for the person. So how to resolve the issue is a question.
That's for the next round.
And that is the issue, that when we are facing that, when we have recovery of crores, what are the alternatives? How we are going to take up? So these are the basic issues, and when we see that judiciary, and when we compare the judiciary and legislature, then obviously we find there is a lacuna and problem in judicial decisions. That's why there is a clear slowness and delay in the proceedings.
Okay, thank you very much. Before I turn to Ish, who thinks, sitting here, that the problem and delay, well, we're all lawyers, is with the judiciary? Hands up, please. Yes, thank you. Sir, you ask a lot of questions, which is fine. So why do you think it's with the judiciary? Yes, please join in.
Good morning. Sorry, is that working? Yeah.
Good morning.
Good morning again. Thank you very much. You know, I've been an ex-judge, so I know it from heart. I know it from the kitchen more than anybody else, maybe. So sometimes there is a problem actually with the load the judges are having. And there is no, sometimes pre-analyzation, pre-preparation for the documents, for the hearings, that's coming to the judges. So they'll be overloaded, and sometimes managing the cases will be problematic for judges. So they have some sort of partial involvement. Sometimes it's the system itself actually that imposes more difficulties actually on the judges on dealing with cases. So it's judges sometimes, if they don't know how to manage the cases very efficiently, that actually will impose more hurdle in terms of managing the time in resolving the cases that being heard before those judges. But it will not be one reason. Actually, it's a mix of reasons. And if there is a time, we'll talk about that a lot. But actually, and I can tell about it from experience, especially from in-house, you know, being an ex-judge. So especially, the core thing is the support functions for the judiciary system is also play a significant actually role in whether reducing or increasing the pressure and the load and the time. Thank you.
Thank you very much. I'll come with an interesting suggestion in the next round, but first to Ish. Where do you see the problem?
Well, I see a lot of problems.
But that's what we do.
Yes. So one of the, in fact, in the first few years, I was fortunate that I practiced with an arbitrator, and before I actually, jumped into the hardcore litigation, I actually was with an arbitrator for 5 years as his research assistant, and I could upfront see when I entered litigation of the difference between arbitration and litigation, As our topic today is, that the problem lies at the trial. So leaving aside the problems of conflict of laws when we go to the international disputes, leaving aside the quality of judges or the outcome of the cases, I mean, leaving all that aside, the primary delay that is caused in our litigation system is at the stage of trial. And I think the first problem that my experience has led me to believe is the limited amount of judges that are there in most of the jurisdictions that I've practiced in. And, for example, in India, we have about vacancy for 471 judges only in the high courts. So, I mean, this is a kind of vacancy which cannot even be filled in the next 5 years. I mean, you can't overnight have about 471 judges, added to the bench. The second problem is the limited amount of working hours for the judges, the time schedule for the judges. I think, they're just constrained with so much of work, and with all due respect to one of the ex-judges that we have, I mean, he would testify to the fact that they're burdened with a lot of work, and for them to be able to schedule in a particular day of how to bifurcate trials from emergency hearings or, matters which require urgent hearings, it becomes absolutely impossible. So, this is something that we need to try and resolve for the judges, and the judiciary, the judicial management needs to support the judges. The legislature needs to support the judges to do that. Another problem so these are the first two problems that primarily, are common across all jurisdictions. Then we have the problem of the predominant nature of, the lawyers. Like, I mean, how many times have we faced a situation where, either we have to seek an adjournment or the other side seeks an adjournment because the arguing counsel is not there or the cross-examiner is not there. I mean, it's a part of our practice, and there is no way out of that. But as lawyers, we are also a part of the problem, and we need to find a way to resolve that. But yeah, that's about the two problems. The third problem is the lack of practice of having cross-examinations on consecutive days. How many of the courts do we see allow cross-examinations to run on consecutive days? It's hardly happening, across multiple jurisdictions. I mean, except for a few developed countries, everywhere else I have seen that the cross-examinations don't happen on consecutive days. We have judges who give dates after a month. I mean, as a trial lawyer, you need to then start preparing for that witness all over again. That just consumes more time. That's one of the reasons why the lawyers are then forced to take adjournments, because they're not able to schedule it in a particular manner. So I think that's the fourth problem. And the fifth problem is complicated laws and procedure, as Rutvik just mentioned. I mean, it's just so complicated that, there is no room open for the judges to expedite it. If a procedure provides that an X thing has to be done, and if the judge doesn't follow it, the first thing that a party would do is appeal it. And that's where the stay starts. So you go to the appeal court, and the appeal court then stays the proceeding until the appeal is not decided. We are at standstill in trial. Again, a major cause for the delay. So I think these are the problems that I think needs to be addressed. And it's something very easy to talk about, but very difficult to resolve.
Absolutely. Let me tell you something shocking, ladies and gentlemen. Our judiciary in the Netherlands, they also lack a lot of people in workforce. So they came up with an interesting idea. And not only was it an interesting idea, they put it into law. And the thing is, I haven't told you that, they reduced the appeal brief for the lawyers to 25 pages. 25 pages for an appeal brief. Can you imagine? All cases, 25 pages maximum in appeal. Why? Because the appeal judges, and the bench is always containing out of 3 judges in the appeal, they got briefs, well, we know them because we make them, of hundreds of pages, which slowed down the process. So they came up with an idea and decided to make it a law to reduce it to 25 pages. Of course, the lawyers went to court to fight it, and they lost. They went up to the appeal court to ask whether this was legal, whether this was good practice and in the interest of the parties, and the Supreme Court agreed that the courts can do that. So now we have to put our appeal brief into 25 pages without attachments. You know what happens, right? We put everything into the attachments. But still, you have to think a lot. And the idea was, if you can't put it within 25 pages, you have to rethink. And if there are more than 25 pages, what's going to happen is the brief will be sent back, and you get 2 weeks to put it into 25 pages. If not, then they will cut it at 25. So whether this will help to speed up the process in the appeal procedure, we will find out, because this has been introduced lately, last year actually, and we'll see about that. So that's, at least from the judiciary's part in the Netherlands, one of the tools to speed up the process themselves. I have some other interesting news from the Netherlands, but before we get to that, Ludwig, you have experience in China as well as in India. Could you share the difference in approach, how to solve the way of speeding up the process? Would be interesting.
Yeah, definitely it is. If we compare both the jurisdiction, Indian and Chinese, let's not talk about, I'm not talking about the fairness of the trial, I'm talking about the expeditious trial. So in India there is a concept that even if 10 guilty people are set free, one innocent should not be pleaded guilty. So that is a different concept, and that's why the Indian jurisdiction is, the courts are, judiciary is taking little cautious action to go ahead for any trial. But if we see in the Chinese jurisdiction, they have already implemented plea bargaining. So this is one of the fastest way, but plea bargaining, I would say that India also has started for, since I'm from the state of Gujarat, so the state of Gujarat has banned on the liquor is not allowed, so this is called prohibition cases. So such small cases, we have a plea bargaining. But we don't have the concept overall, and I think both of you would agree with that. In Chinese jurisdiction, this one is for the criminal and civil also. And for money matter or civil suits, they have a very beautiful established system that the courts are considering the rights of the litigants also. And they feel that after going through the documents, they also try to set the talks between the parties, and if try to like mediate, they try to mediate also, and they try to order. If the mediation fails, then straight away they order, so that the matter goes fast. So all the trial that, like if we go in Indian Civil Procedure Code or other codes, all the trial in between is eliminated. It straight goes for the evidence, and then it moves further for the judgment. So basically, mostly it goes on the evidentiary value. So this is how the Chinese jurisdiction, the Chinese Supreme Court have taken one step further to expedite, to deliver the justice on time.
Is it for small claims or also for bigger claims?
For punishment up to 3 years, they go for the plea bargaining.
That's the criminal case.
Criminal
what about
cases,
the commercial ones?
Is
there a plea bargaining thing in a commercial case as well?
That's also there. So they try to go for its plea is mainly for the criminal thing, but for civil matter, there's the same procedure that they discuss with the parties. They come up with the judgment based on the evidences and the documents. So generally it is 6 months or 1 year, they try to finish up the matters.
Okay, first instance, right?
Yeah.
Well, in the Netherlands, this is standard 1 year.
So
For a basic procedure, but we'll come to that. But that's quite quick. So in India, if you compare it to that, going to Ish, how long would such a procedure take?
Well, for a civil proceeding, it would for even small claims. So obviously, you know, we have the introduction of the commercial courts in India, and you know, having the whole enactment in place. The problem is that even if the enactment is in place, the implementation is near impossible, because with several high courts in India, you know, almost each state having its own high court. These are the courts which are deciding on the commercial disputes in an expedited manner. We still have, you know, the limitation that, you know, the plaint and the written statement has to be done in XYZ days. It says that, you know, the witnesses are to be examined on consecutive days. But it still does not put a restriction on what is the consequence if the witness is not examined on consecutive days. What is the time limit within which a trial is to be completed? It does not put a limitation. For example, as you mentioned, that, you know, the appeal courts in Netherlands have restricted it to 25 pages. In India, we have claims which, for hardly a few $1,000s, you will have, you know, plaints which will run into about 60, 70 pages. And it's utter nonsense. I mean, you know, you don't require 60, 70 pages to justify a small claim, but, you know, the judge's hands are all restricted, even in commercial courts, and it's difficult to reject it. So even if you have laws in place, like the Commercial Courts Act in India, it's becoming near impossible to implement it with the diversity of the judges, the cultural background that's there with the judges. So, you know, these are the judges who are lawyers in a different generation in India. And the younger generation has really not, you know, come up as yet to be those judges. So it's probably, you know, a few years before we actually see what Rutvik is saying, that, you know, we'll have that implementation of the Commercial Courts Act in India. I mean, it's going to be a long process.
Well, thank you very much, and also for the keyword commercial court, because once again, I have a surprise for you, but this one, a nice one. The Netherlands has started with the Netherlands Commercial Court in January 2019. It is for international commercial matters that have not necessarily something to do with the Dutch court or anything. It is a chamber of the Dutch court consisting of 3 judges with experience in international matters. It has to do with international commercial disputes. And it is quick, easy, and fully in English. So actually a solution for speedy trial, and the best of 2 worlds between arbitration and going to the normal court. And that's an interesting thing also because of the costs. We haven't been talking about costs yet, because one of the things that court has also done is to have a flat rate, flat fee, 10,000 euro per party. That's it. Whether you come for 100 million, 1 million, or 100,000 euros. Because in arbitration, I don't have to tell you that it's extremely, extremely expensive.
Touching my bread and butter now.
Yeah, I thought so. But also, together with the president of the Appeal Netherlands Commercial Court, I had the honor to be invited to come to Milan to join with the judges of the Paris Commercial Court and the Stuttgart Commercial Court to talk about with the judiciary and the lawyers of how a commercial court in Milan should look like and what the experience is in Amsterdam. Let me tell you that, of course, the Amsterdam Commercial Court, the Netherlands Commercial Court, was of the European courts the only one that has a fully English process from all the briefs through the hearing itself to the judgment, including the judgment and the appeal, which means that not only you can go to the Netherlands Commercial Court and use whatever law, material law you would like to apply, you choose it and they apply it. But also the foreign lawyers can be active within this procedure, which makes it very, very interesting, and which also was the reason why the Milan judiciary and lawyers invited the Netherlands Commercial Court to talk about it. So, talking about speedy process, summary proceedings with the Netherlands Commercial Court, and I'll come back to you, and I would like to ask the ladies and gentlemen here in the audience as well. Summary proceedings at the Netherlands Commercial Courts. Within a few days, you will have a judgment. And it will be fully in English and fully enforceable. So think about it. Next time you need something quick, which isn't that expensive and not going into arbitration. So who of you is using arbitration instead of going to the judges to speed up the trial? Yes? Is it only about speed or other arguments? Yes, please.
Wait, I'm bringing the microphone to you, sir.
I think you should leave the mic with him now.
Yeah, okay, thank you very much.
You should keep it for the day, yes.
Yeah. So, I like such interactive sessions actually, and this is very, very, close to my heart topic. So there are so many reasons actually in terms of complexity of the, the dispute, nature of the dispute. Okay, especially when it comes to specific types of disputes which we cannot take to court, where you need to have subject matter experts actually who can really understand what the case is about, and what sort of debate that the parties can have. So, and also it's related to the value of the dispute. So we don't go to arbitration if it's, small value type of dispute. So this is key for us. So it's about the nature, the complexity of the, and subject matter experience that's related to the disputes mainly. Thank you.
So is there a special arbitral court that you go to normally?
Yeah, it's, as arbitration centers. It depends actually where the parties are and the selection of the parties in the contract, whether that's regional or international. Mainly, we go sometimes to Dubai International Arbitration Center here in Dubai. Recently, because I'm coming from KSA, the arbitration, is still young actually. They're still developing, but we are witnessing big change, big shift in, the arbitration center in Saudi Arabia. For sure, the normal international, well-known like LCIA, ICC, will be always one of our main targets in terms of selection.
Would be interesting, by the way, because we also made a comparison between, there is a commercial court here in Dubai as well, and there is one in Qatar. So, but they are also, their court fees are immense. And regarding the qualification of the international dispute, it is a bit more narrow than what we have in Amsterdam. But I'm happy to share it with you. But
sure,
we'll come to
looking
you
forward.
back again.
Looking forward.
Sorry, but just to continue where my friend has left off. I agree with him because there are, for example, I deal with specific disputes in aviation law. And obviously, Netherlands is not a problem with aviation law and space law. We have the entire of the Leiden University and just the establishment of the Hague Civil Aviation's Arbitration Center. So, Netherlands may be a one exception, but overall, we don't have specialist courts which can deal with disputes relating to technology because of sometimes. We have judges who are not aware of technical aspects or especially relating to aviation and space law, or for that matter, art law. I'm sure Vanya can testify to that fact that, a lot of times we have art law disputes where the judges have, no semblance of idea of how an art law dispute has to be perceived because, it's very subjective. Art is very subjective, and the laws revolving around that are not so developed as yet. It's a lot of drawing inference from the contract law. So, for those kind of specialist disputes, you would still require parties to go to arbitration. And obviously, just to add on to that, we also have the confidentiality issues in these kind of disputes, because these are sensitive data, and you wouldn't even want the awards to be released at some times.
Absolutely,
So,
confidentiality is
yes.
a big thing, and that's also one of the reasons why people would go to arbitration. We can ask for closed doors hearings, but still publication, we can also ask to put it in a way in which the parties are not visible, but like with privacy, if you put one and one together, you know where you're at.
But that's the difficulty. So even if you have, somehow prevented the publication of either the award or the court judgment, when that kind of provision is there, the question comes of how do you then enforce it? Because for enforcement you need to go public, and that's the conundrum that we are there in today. And a lot of technology companies, and especially in space law, because again a lot of space law disputes are having a small aspect of national security also involved, because we have the state which is backing up those companies, and that kind of involvement normally triggers the whole, how do we maintain the confidentiality, at the same time seek the enforcement. So, yeah.
Well, combining art and enforceability, there was a very interesting judgment in the Netherlands recently about NFT. It was in February of this year, well, not that recent anymore. But what happened was that there was a gentleman who wanted to buy a piece of crypto art, of an NFT, with a bet on it, a crypto bet. And that was made by a famous person in the Netherlands, at least. Well, Ozzy Osbourne was the name. And there was this bet on the NFT, and then you have all these little particles, and the bet had a part, and then there were some blue parts around it. So he asked somebody to buy it for him. So when the guy bought it, he found out that this was a very rare piece of the puzzle with a very interesting part of the bet. So he thought, well, you know what? I'll keep it to myself. And I'll buy a new one and give that to the client. But the new one that he bought was just a piece of blue. So the gentleman who asked the trader to buy the NFT found out very quickly, and then he said, that's not okay, I want my piece of NFT with the bet on it, because that's what you bought for me. So they went to court, and the court ruled, and they could enforce, that liens were put on the NFT. Liens, can you imagine? So they put liens on the NFT, plus the obligation to give the right NFT puzzle piece to the gentleman. So that was quite interesting, because it combines enforceability as well as giving it to it. But one more thing. No publication of the judgment. We know that it's there, but they didn't publish it. So that's very interesting. Ludwig, what else do you think is interesting in the solution of speeding up the trial? Commercial courts against arbitration, mediation, going to normal courts. What are your thoughts to solutions?
When we talk about the trials, mediation, arbitrations, definitely even as I mentioned that the laws are clear. Like even for the summary trial, we have a civil procedure code. There, for any commercial matter, we can also ask the court, and court has to deliver it within the shortest span. Even still, it is taking the longer time. So here, generally, instead of going to the trial, so the best option is to go first for the mediation. So why mediation? Because if you see any dispute, so dispute starts, I would say, with the psychological aspect, that's ego. So let's try to resolve this. If things cannot be worked out, then definitely it will go further for the arbitration. And now India has started developing the arbitration laws in a such a way that it has to be finished in maximum 1 year's time, and after further extension it has to be not more than 6 months. So again, arbitration is fantastic remedy instead of going for the trial. But before going for arbitration, I would at least prefer that my company should not go into unwarranted cost, because arbitration is not so easy way in terms of cost. So I would prefer that why can't I discuss directly? First try to, let's have the settlement talks with the parties. If not, then I should take the support of somebody else who can come and mediate. So that mediator will at least try to support us, and both the parties, they will try to get, he will try to get convinced. And if things go well, there is a number that almost 35% to 40% disputes can be resolved if the mediation is put in a proper way. So this is one aspect. And if things cannot be resolved, then the third aspect is the arbitration. But again, arbitration, if we agree into the arbitration, that there are, the people agree nowadays that, okay, I am a company and other party supplier, for example, is a small party. So I will say I will appoint my person as an arbitrator, which again the Supreme Court of India has said that no, this is not a fair trial. So again, we have to approach to the High Court or the Supreme Court, as the case may be. This is I would say it's a faster remedy, but faster remedy when? From when? From the date the High Court or Supreme Court appoints an arbitrator. So before that, again, you have to come into the judicial proceedings. So try to resolve, my best solution is try to resolve by way of mediation. So it can be avoided. For criminal matter also, India does not have, we do not have the plea bargain, but at least for some of the penalties, at least for 3 years and all, for this matter, it can be resolved. And as you said about the commercial court, it was a fantastic example. The courts have now started adopting the commercial courts approach, and there is a law now about the commercial court. It has to be finished, but again and again, it is again going for the same way of the civil procedure code. So the real intention of the framers, it has got diluted. So that's why before going all into all the issues, I'm so sorry you are all the people are lawyers, but I would say, I will just give you example that somebody asked me that why are you insisting for the mediation? I would say that plaintiff who is fighting for the head of the cow, defendant who is fighting for the tail of the cow, and the lawyers, including me, we fraternity, we keep on milking the cow. So any organization would not, sorry for this, any organization would not require this kind of cost. So mediation, I would prefer that with this way, at least the settlement can be quicker and we can get the results immediately. That is my point here.
Edith, with your permission, my 2 cents on what Rutvik just said. Insofar as Rutvik, you mentioned about mediation, I completely agree with you. I mean, that's, if you have the choice, you should mediate first. But it can't be a compulsory process of, so for example, because of, what you said is correct. And because of that thought process, I think in India especially, you would see that they've tried to overreach the mediation aspect, where they've made mediation compulsory in commercial courts disputes. So what you are doing is on one hand expediting the process by saying, we will have commercial courts. But on the other hand, you're saying that, oh, you have to mandatorily go for mediation before I take the case on file. And practically, if you see, you are now delayed by 6 months because your mediation goes on for 6 months. So you've just taken 2 steps forward and 1 step backward. And mediation should be a voluntary process because, and I'm sure you must have experienced this, that when one party goes to the mediator and says that I want to mediate the dispute, and the respondent says, oh, well, this is going to be now fun for me, and let's try to delay the process. And he says, yes, I'm interested in settling, but at the end of the day, during the mediation process, there is zero inclination from the respondents to actually try to settle the dispute. And that simply causes the delay. So I feel that, the idea of mediation is fantastic, but it has to be a voluntary process from both ends, and both should have the same mindset that what you just suggested. That is so far as the mediation goes.
Well, let me add to that. Of course, in the Netherlands, we have a solution to that as well.
Well, Netherlands has all the solutions.
Yeah, you should all come to
So-
the Netherlands.
so
There,
just
there
to-
because to add to the mediation part, in labor law cases, a judge will not adjudicate your process if you haven't tried mediation first. So all the parties know it, and from the employer's end, they usually say, okay, we have to go into mediation, but actually we don't want to, right? So what they organized in the Netherlands, also from the mediators themselves, is a pressure cooker mediation in 1 day, which is accepted by the courts. The lawyers, together with the parties, go and sit at the mediators table for just 1 day. You sit there and you decide up front that if you cannot reach an agreement within 1 day, you go back to court. So it will not take you 6 months. And it is, why are the lawyers there? Because usually they are a disturbing factor, as we all know. In this particular case, the idea of taking the lawyers to the mediators table is that the parties, when they reach an agreement, the lawyers at the table of the mediator can write the settlement agreement there and then. Because we all know that if the parties go to the mediator, they go back to either their spouse, which is also a problem, or their lawyers, and they tell them, yeah, you know, we've reached a settlement, even if it is not allowed to talk about what they did in mediation, they still do. And then the partner, the spouse, or the lawyer says, are you crazy? You should never have accepted that. You go back and you renegotiate. That's what's happening, right? So that's why we do a 1-day mediation in which the parties are there until they are so tired that they want to settle at the end of the day, and they will. And then the lawyers draft the settlement agreement, then there you are. So that's how we solve the problems.
That's excellent, actually.
It's nice, right?
Yeah, excellent.
That's really nice. And as Ish said about, yes, 6 months delay, I have also seen this kind of practical issues. But when we see mediator, by virtue of Commercial Courts Act, a mediator is appointed. So that mediator is generally picked up from the local bar. He is unfortunately not aware what are the issues. Technically, he is not so sound. So if a judge feels, or if a mediation center feels, oh, I'm having good relations with this gentleman, he can be appointed. So this is a negative point. So if we put this negative point apart, and if we really feel that for example, I feel that Eddie, this is the best for solving this issue, if I come back to you, and you will support us, to me and Ish, to solve the issues. Definitely, why can't we solve the way you have solved just now? So
I think the solution that Edith is suggesting is that you should have that 1-day mediation, and that's like the excellent solution. The only difficulty, Edith, and this is where we'll require Netherlands' help, for especially jurisdictions in Asia, obviously barring Singapore completely from that common analogy. How do you have trained mediators? Because as Rutvik correctly mentioned, the problem of mediation, even if you have a 1-day mediation, is we have retired judges who are acting as mediators, or practicing lawyers who are acting as mediators, and we don't have professional mediators mediating the dispute. And the problem is once you have a lawyer or a retired judge, the perspective of mediating a dispute is lost at some point, I feel.
Interesting. Anyone in the room from Germany? No? Well, let me tell you that in Germany, I think one of the problems as well with mediation is that we as litigators, we think that mediation is a soft thing, right? Right? You know, hardcore is going to court and soft skills is doing mediation. Well, in Germany, they are cleverer than we are, because they think that mediation is a very important thing also in commercial matters. And they take this very seriously, and they're doing a great job there. So any comments from the room, from you, about mediation or arbitration? Yes, sir.
Hello. Hi, good morning. My question about mediation, how it could solve such problem with major companies, just like what happened with, let's say, FTX and other companies who deal with a lot of consumers inside one platform. So such thing, mediation could not work there because you will not settle with, let's say, 1 million customers. What do you think the mediation on such cases, or it's not possible?
I'm trying to see whether I understood your question correctly. How to solve consumer matters in mediation, was that it?
Yes, especially with the big platforms. Such you have 100 or 100,000 customer. How you will mediate between the two parties, because the second party is 100,000 customers. So who will be representing them?
Yeah, there are some organizations, or at least I'm looking at my colleagues here. There in the Netherlands, we have some organizations who are taking care of these consumers and also organize these kind of alternative dispute resolution, let's put it that way, because there are various possibilities of doing that. And I don't know how it is in your countries, but consumer protection in normal legal proceedings is huge. And is a huge problem for companies, actually, and businesses, because the consumer protection is so high that they don't even have to go to mediation, because they already have an advantage when going to court by just being a consumer. One of the things, for example, is in unfair trade practice. If you get to the bar of unfair trade practice, that's what lawyers do in consumer rights, then the company has to prove that they're innocent instead of the other way around. So that's one of the instruments that the law gives the consumers in the Netherlands, and I'm quite sure that it's like that in other countries as well.
Well, many jurisdictions, including India, have their own consumer courts. So, consumer disputes are actually taken out from the civil proceedings, from the civil courts, and they've been given separate judges and separate adjudication process to decide those disputes. And unfortunately, this has happened prior to arbitration kicking off in most of these countries. So the arbitration and mediation has so far not had a chance to interact with the consumer court, and there has not been an overlap where, to be honest, how many of the companies, when they're transacting with their consumers, would put an arbitration clause? I don't think anybody would choose that, because
it would not be allowed in the Netherlands. It is it's against the law.
Correct, and so therefore, to have arbitration or mediation conflict with the consumers is something that we will not see for some time, or will be an exceptional case. But if I've understood, what you try to ask is what happens when a company faces, and this is apart from the consumers, what happens when a company faces, for example, we have in the maritime law, it's not the consumers per se, it's the whole different, client and client kind of base and contract based, where you have, multiple LCs and, different forms that you have to comply with and different submissions. So for example, if you have Maersk, they have about, on a daily basis, even within India, they have about 5,000 contracts which they enter into on daily basis, and none of them would qualify as consumers. So how does Maersk deal with this kind of dispute, where can they mediate with 5,000 of their clients or 5,000 contracts? Isn't that what you're trying to ask? So, you will have to, logistically as a company figure out of having, in-house teams which are trained in mediation to deal with these kind of disputes, and have your own, redressal mechanism within the company for addressing those clients and trying to hold a mediation so that, the client does not drag you to the courts or to arbitrations, which is an expensive process. And
yes,
I'm sure Rutvik can tell us more, because he comes from the company which would be faced with this kind of problem.
So I agree with both of you, but two things we need to consider very clearly. The consumer rights, as a general principle, these are all statutory rights. Globally, global jurisprudence is giving you as a consumer statutory rights, while all your arbitration or mediation, these are your contractual rights. So even if you have a contractual rights, for the statutory rights specifically for consumer or for small suppliers, there is no restriction. Even if you have a contractual right, still your consumer can invoke its remedy under the statute. So this is a very clear fundamental. But as Ish and they clearly mentioned how to resolve this kind of issue, then your contracts, you need to identify which are the contracts. The contract has to be well defined about the mechanism or settlement procedure. And if it cannot be settled, that what are the alternative dispute methodology that you need to move further. But if still the matter goes to the consumer, so for example, the person takes you to the consumer redressal forum, and there, if the representative goes and asks for the settlement, even then the tribunal itself will support you. In India, we have this kind of system that tribunal will support you, that okay, you come and negotiate and you settle the matter. So tribunal here will act as your mediator. So that is the difference.
Also, these are the kind of issues that are faced by financial institutions and banks which are lending, where a lot of them are lending to their clients, and those will not fall under consumer because they have their own debt recovery laws and the banking regulations which will govern them. I think one of the aspects that I have seen in my arbitration practice is most of these financial institutions and banks have a mechanism in their dispute resolution where they say that a particular designated person from the financial institution or bank would first try to mediate this dispute within the first 30 days. And that's where they try to avoid going to the arbitration or going to the courts or any debt recovery mechanism, and try to resolve and see if the recovery process can happen in that first 30 days. So I think that's one of the solutions, that you have your own redressal mechanism where you have trained mediators or in-house counsels who try to resolve this dispute, keeping the interest of the company as well as of your client in mind.
Yeah, that's a very good solution. By the way, one more thing with regards to consumer law. Once you you claim that it is an unfair trade practice as a consumer, the other thing that the consumer will ask, and which will be automatically granted once the judge will assume that it is an unfair trade practice, is the annulment of the contract. And it will be granted. As soon as the judge thinks that it's unfair trade practice, for example, putting in a clause where people have to pay crazy penalties or have to go to arbitration or something like that, then the judge will say, okay, unfair trade practice towards a consumer, and the annulment claim is assumed. So then you don't have a contract anymore, and the company has to pay back the money. And that's also a very strong instrument within the Dutch law, stemming from European rules, of course, to make sure that the companies are not putting things into their contracts which are harming the consumer. But one last round of words of piece of advice. You already gave yours, which is amazing, but still I will give you the opportunity once more. Please, what is your piece of advice regarding slowing down, speeding up the process and slowing down problems in the meantime? And maybe also in comparison to the way that China is solving that, would be interesting.
In simple language, a piece of advice would be, first, initiative by lawyers. That is the first and foremost thing. Secondly, you need to push the judge to move forward. And before moving further, at any juncture, if we find that dispute resolution is possible by way of mediation, it is a fantastic remedy to resolve, because no institution can afford to continue the litigation for the years. As a lawyer of corporate, I feel that my company is bleeding. Even with a single day, the judge or the court is taking time. So every day I have to pay interest to the bank institutions, which is not acceptable to me. So even if I can consider that what is the best solution I should adopt by way of mediation at any juncture, I should create much pressure on my lawyers to move faster in the court. and simultaneously, with the help of both the parties, we can jointly represent to the judge also that, sir, please expedite, these are the problems. So these are the simple advice that we can expedite, or we can speed up the trial.
Thank you
And
very much.
solution, not the trial.
Yes.
We can get the solution at the end of the day.
Perfect. Thank you very
Thank
much.
you.
Ish, your closing words.
Well, my closing words are very simple. Have more judges, enable them to devote more time to trials, and curtail the practice of seeking adjournments because of lack of counsel or because of lack of availability of parties, or just make the whole disclosure process more simpler. And until that happens, I think the fastest remedy still lies with arbitration. So unless the courts find a way to get over these lacunas, and the parliament enables appointment of more judges in these multiple jurisdictions, especially places like Brazil, India, and China, where the population is enormous. So you require equal amount of judges in those jurisdictions, and until those happen, the parties will be forced to seek for people to adjudicate the disputes outside the courts. And that's my 2 cents on
Thank
the
you very
solution.
much. Okay. Some final words from my end. We are called advocates, which means we are advocating for our clients, right? That's what we're supposed to do. So my closing remarks would be, in advocating for our clients, we have to think of the best strategy in the interest of our clients, because sometimes we kind of get caught up in the game because that's what we like. And maybe once in a while, before starting, we should think of the strategy which serves our clients best. And sometimes it's not in court, but outside, even if we like to be there. And even when in court, we can still, adapt the strategy if we see that things are not going on. And sometimes, settling can also be better for the parties than going on. And let's be honest, a happy client is a joy forever. If you do that, they will stay with you, and there will be more nice cases with them. So that would be my advice. Think of what your client needs and give it to them. Thank you very much, also to my panelists.
Thank you, Edith. Thank you, Ritu.
Thank you very much.
Thank you.
Any
Thank
last
you very much.
questions for the panel? Challenges you are facing?
We already did that.
My name is Aya. I'm from Egypt. I'm a partner in a solid law firm. Well, in Egypt, we have either one of 2 ways. Either it's litigation, which, as you said, takes a lot of time, or arbitration, which costs a lot. So when I come to something applicable, it would be mediation. But there is one problem, that even if I draft a contract, I don't know on what criteria to assign a mediator. Is it best to be an expert in the business field, or just a lawyer or a judge, retired judge, who has a legal background? So I'd like to know your recommendation if I'm going to assign or choose a mediator, in order, because this will be more applicable and more, easier and faster for my client in Egypt. Thank you.
Okay, interesting question. Thank you very much. Well, what we do actually, and I'll ask the gentleman in a second as well, is we have lists of trained mediators, registered mediators who had taken tests and exams and all these kind of things. They come from different backgrounds. Some of them are lawyers, some of them have a psychology background or something like that. In the registry that we have, it says what the background of the lawyer is. So mediation should be willingly from both parties, different from what we do. We just go for our client and that's it. And what we do is that we have the parties choose a mediator from the registry. And if they cannot choose one amongst them, we usually have a list of 3, 4, 5 mediators who would be best for the case. And then the first task for the parties is to come to an agreement on who the mediator is going to be. But it's going to be somebody who has exams and who is in the registry. That way they can choose somebody, for example, if it's a commercial case, somebody with commercial a background, or if it is an international case, somebody who also speaks various languages, or if it is something more family law-minded, then you can have somebody, there is a special group of mediators for that. Any additions from
I think the solution to your problem would be, first, as Edith mentioned, you need to be sure that you pick a mediator who's trained, and that's where most jurisdictions are lacking of trained mediators. We have list of mediators in a lot of developing countries where, as I mentioned earlier, we have lawyers who have not been trained, we have retired judges who have not been trained as mediators. So you need to pick, and I'm sure, and obviously from my experience, I feel that Egypt is one of the jurisdictions where this is still predominant, where there are lawyers and retired judges who are still acting as mediators when, and I'm not saying that they can't act as mediators. It's just that they're lacking the attitude and the training of what is to be achieved in mediation. It's to be settled. The idea is to settle. It's not to ask one party that, okay, this is what you want and this is what you want, and we have A and Z, and just try to pull them somewhere between N and O. It's not something of that kind. You need to sit with each party and make them realize as to where they stand and what is more reasonable and practical for them to achieve out of the litigation if they pursue this course ahead. And the second solution would be, to time-bound your mediation. Unfortunately, a lot of these jurisdictions have a problem that the mediation goes on for months. And, as Netherlands has a practice of having the mediation in one day, probably for some of the companies it will be near impossible task to do, but you need to get closer to that 1 day target. Probably have 7 days or have consecutive meetings. Because moment there is a gap in the negotiation, parties lose interest in mediating the dispute. So, you need to have meetings consecutively because the pressure is built and the parties constantly see that, we are heading in a particular direction. And the third is, if you see that the other party is not responding to mediation and this is just a delay tactic, terminate the mediation and move to the next step immediately, because, you're just wasting time in the hopes that the other party is genuinely going to mediate the dispute. You having an intention to mediate is one thing. Your respondent or your claimant, asking for mediation is a completely different aspect.
Thank you. We have another question from the gentleman going to the center microphone.
I'll just mention one point.
Go ahead.
In furtherance to the suggestion by my colleague Ish, his point is very clear about point number 2. And the first one I would like to mention, that mediation is not a formal process. So what I did recently, that we had a technical issue for one product. I approached to that party that instead we were already into litigation. I said, let us avoid the litigation, and for this technical thing, let us appoint one of the veterans who is having fantastic skills. We approached to the veteran, both the parties decided amicably. We approached, and in 3 days we resolved the issue which was pending since long, for more than 2 years.
Excellent.
So
Yeah,
this way it can be adopted. So otherwise, if you write everything here, there, then there is no difference between litigation and a mediation process.
Absolutely.
So this was my point.
Perfect. Yes, the gentleman.
Hi, my name is David. I'm coming from the legal tech aspect of in the law systems. I would like to ask you something. Do you know in the Netherlands or in India or in China, are you using any kinds of ODR systems? For example, maybe arbitration models of technologics or mediator, something like that, of online dispute resolution systems? Because I know, for example, we will take the European Union that they are using, they build a ODR system for all the European Union. So I would like to ask if you are in the Netherlands or in India, because I saw in the internet that the system, the law system, is entering now the ODR system. So I would like to know if you know about it, something like that.
Edith, can I answer that? So, ODR is not really different than ADR. Uh, so, well, I wouldn't call it ODR because there are a few aspects which you can exclude from the online process. For example, mediation is something where the body language of the parties, the demeanor of the parties, the cultural references, the caucus, meetings that you have, really are not fruitful when you are doing it online. Identical problem with negotiation, but expert determination and arbitration are two things which are already going online. For instance, a lot of arbitrations that I do now, and prior to COVID, this was all physical. But with the COVID-19 coming in, it is like a boom for having virtual meetings now. So whether a party is sitting in a different continent or a different city, it's very convenient now to have virtual meetings and virtual hearings of the proceedings. So it's not more of an ODR, but it is actually taking the same process online on virtual meetings. And if you feel, for example, as we're discussing trial, if you feel during cross-examination that you require the physical presence of the witness to notice his demeanor, or to to make points, or just to make sure that there's no tampering of the witness, you can have physical presence of the witness with the arbitrator. And that's something that I've done that in the past, where the cross-examiner is online, but the witness is sitting in my chambers. So this is something that has been regularly being done during this COVID, and obviously post now COVID as well.
Yeah, let me add from the Dutch perspective. I was part of online dispute resolution in various proceedings during COVID, because that was actually the factor that speeded up that process. We had 20 proceedings in financial regulatory matters, which also had civil aspects, where the parties were in different countries, where we had hybrid meetings as well as fully online dispute resolution with the courts, with all the problems that were there, actually. The cameras not working, sound not so well, and then these things got better and better. And I also had a online mediation in that part where the parties were in different countries. From my personal expertise, I thought at the beginning, oh, that's wonderful, I don't have to go anywhere, it saves me a lot of time, let's do that more often. But quite honestly, there is nothing like real face-to-face dispute resolution, mediation, or any other kind of dispute resolution, because body language, the way people behave, things that you cannot see online or that you cannot sense, you will miss that on online dispute resolution. It is an option and a perfect thing that we can have it. All courts in the Netherlands have cameras now that make it possible for the court hearings to be online. And for example, the Netherlands Commercial Court, they are fully ready to do the entire hearing and all the parts of it online, no problem. Also, the rules and regulations are made that this is possible and legally valid. But I do feel, as being a litigator, being there, you feel that something is lacking. And when you're there, it's different. So if you have the option to do it live, I would still do it live. And otherwise, it's a good alternative. And yes, the law has been adapted in the Netherlands to make it possible.
Comment.
Okay, so every technology has pros and cons. But as Edith said so rightly, that human touch needs. And if possible, you can do, if you really want to save the cost, online is better. And cross-examination, COVID has taught us a lot in last 2-3 years. So this we have already started adopting into the litigation also. Still we have some of the processes online going on. And definitely if we try to keep trust on each other And some of the processes like putting affidavit and all, things should go well. So that is what is our suggestions here.
Thank you very much.
Please put your hands together for the panel. Edith, gentlemen, thank you very much. All right, ladies and gentlemen, we are now going to break for lunch. However, first, just before lunch, there is a group photo with the other conferences in line with ours. And so I will ask you to go to the one floor below, and that is where the photo and the lunch will be. All right, and then we shall reconvene here at 1:30. Thank you.
Hey, 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 hey. Nice. Check, 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 check. Hey, 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 hey. Check, 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 check.
Okay.
Check, check.
മൈക്കും കൂടി ചാമ്പ്യൻ കളിച്ച്
check. Hey.
Welcome back, ladies and gentlemen. If you can please take your seats, we shall be commencing momentarily. I hope you've enjoyed your lunch and had a seat in the shade. All right, ladies and gentlemen, first off, I would like to once again thank our gold sponsor, FidaPay, and iBlockchain, our silver sponsor. We are extremely delighted for their support and to have them on our side. Let's talk about investments, shall we? All right, so there was an influx of investments in India over the past few years due to its attractive business environment and skilled workforce. Our upcoming panel discussion on increasing mergers and acquisitions trends in India and their impact will explore the trends behind this phenomenon, as well as analyze its financial and its legal implications. The panelists for this discussion are, please help me in welcoming Kaushik Mukherjee, President Legal at India Bulls Housing Finance. Welcome, Kaushik. Next, we have Ashish Jain, Lunia founder, Samvidhan Attorneys at Law. Welcome. Next, Anaga Anansingaraju, designated partner, Kanj & Co. Welcome. Eman Ali, Senior Associate. Alif Fazalboy, Senior Partner at ALMT Legal. Welcome back on stage, sir. And Upendra Nath Sharma, Partner, JSA. Welcome back as well. All right, panelists. You have 50 minutes, and the panel, the timer will indicate the amount of time left, and the last 10 minutes will be for question and answer. Would you like to?
So good afternoon, everyone, and welcome to this, the first session in the afternoon. I'll be moderating this panel, and thank you to my panel members. They often say that the first session after lunch is it the easiest or the most difficult? I mean, people are well fed. We've had a very interesting morning, a great lunch. People are now raring to go again. Or are you too well fed and ready for a power nap? So we hope we keep you engaged enough so that it's the former and not the latter. We have a great panel, as I said, and Alexandra has introduced everyone, so I won't spend much time introducing everyone again. The topic we have for today is M&A trends in India. And I think the last 3 years, you will all agree, has been some of the most interesting years that we have had in our lifetimes. In 2019, when COVID first hit, in our M&A practice, at least our experience was that everything came to a grinding halt. And for the first couple of weeks, nobody knew what was going to happen. Then we found the trend that there were some great smaller acquisitions available for the taking. A lot of the small businesses and promoters were finding it very difficult to deal with COVID. And the bigger players and the private equity investors saw a great opportunity. So within a few weeks of COVID, the M&A practice again started picking up with these kind of acquisitions. And thereafter, as we all got used to life with COVID, and especially now that hopefully COVID is kind of behind us, we've seen great trends and great acquisitions happening. India has been one of the great destinations, as Alexandra said. And so without much more ado, I will first ask Upendra, who is a partner at J. Sagar Associates in the Gurgaon office, specializing in M&A transactions. I'll ask Upendra to give us his thoughts on the recent trends in M&A. Is it more cross-border? Is it domestic mergers? Is it private equity? And what's kind of happening in the market? So Upendra, if you can give us your thoughts.
Thank you, Arif. Good afternoon, everyone. As Arif just mentioned, after lunch is a tough session, but I hope we'll be able to keep you guys awake. Coming straight to the point on M&A, you see, despite COVID-19 pandemic, and thereafter, global supply chain getting affected, and also the Ukraine-Russia conflict, and their consequences on, economy, inflation, etc., not to forget the global, headwinds in terms of economic wars coming. Despite all these factors, Indian M&A market has been doing very strong. We've seen unprecedented growth in terms of numbers, in terms of transactions. And there are several reasons for this. You've had people wanting to, companies wanting to adapt themselves for want of better technology, for creating more value, increasing their base, to attract more attention and reach out to the more markets. In that scenario, that's how it's been happening. In M&A pure, especially startups, private equity has been very active. And, even in the, green energy space, technology, all these have been very, very active sectors. And it is expected that going forward also, these will remain very active. In terms of shared numbers, India in the first 8 months of 2022 had the largest M&A transactions, which were about $148 billion, and about 58% jump of the corresponding period in the previous year. Of course, US was the largest contributor, followed by Singapore and Japan. And then Google's investment of about 700 million in Bharti was also noteworthy, one of the bigger ones this year. So that's been the trend. And you see a lot of cash availability, young entrepreneurs, and as I said, people wanting to create more, reach out. Even domestic M&A has been doing very well. The biggest one, about $60 billion, was HDFC Bank merger with HDFC. That's the biggest landmark in the financial services sector in India. And that's also a trendsetter. We'll see more consolidation in that sector. Putting just the financial services sector, I think they in turn had about 300% growth over the first 9 months of this year. So, that's the trend which has been there. And also the startup, they are the kind of new age innovation guys. They upset the status quo, create more opportunities. Even there, we've had about 50% jump. And besides that, the number of unicorns born in India is amazing. And we will see going forward that unicorns will also be creating more, acquisitions. They will start more, synergies, getting more companies within their fold. We've seen, Byju's acquiring overseas, Good Learning, Epic. Yeah, even, other outbound investments have been very strong, such as, Adani's, SB Energy, Reliance doing ROC Solar. So, those kind of things, so has been very active. So in this scenario, both M&A, the domestic M&A, and outbound M&A is going to be thriving going forward. I think that's largely the scenario, Alif.
Thank you, Upendra. So, as you've seen, the trends are looking good for India. And the Indian government is always propagating that there is ease of doing business. That's the propaganda of the government, that we want to introduce laws, we want to introduce regulations, we want to make business easy to do in India. But is ease of business really a reality, or is it a myth? Do the regulations, do the laws really support ease of business? And I think this is a topic on which I can talk for hours, but of course I won't be doing that. I just want to talk about a couple of legislations and procedures here, that when you have an M&A, you have to look at exchange control laws, you have to look at Companies Act, you have to look at, if there's a merger, the Insolvency and Bankruptcy Code, and then of course if there are public sectors, all the SEBI regulations. And sometimes even if you're buying a business, there comes into play GST issues. So the compliances have now kind of overtaken the law. And earlier, where we used to have legal and compliance heads being common, now very often you have compliance being separated from legal. It's okay if you have big companies listed on the stock exchange, multi-million-dollar companies, you want to regulate them, you want to make sure the shareholders are informed, you want to make sure procedures are in place. But when you have smaller private companies looking to grow their business, sometimes compliances, to my mind, can be quite troublesome. And I think simplification is necessary. Take, for example, a recent deal I did, which was a private company, young private company with a little bit of investors, and looking for a great opportunity, needed funds urgently, identified a foreign investor willing to invest $10 million immediately. As lawyers, we did a great job. The agreements were signed within 2 days. Everything was ready. Money was ready to be sent. But then wait, we had the compliance team, get into play and say you have to do a lot of compliances. So first the company had to open a new bank account, because when you issue shares to a new investor, it's a preferential allotment. And so they couldn't use the existing bank account, they had to open a new account. That takes its own time with KYCs and everything. You need valuations to be done, not one but two. Under FEMA, you need it from a charter accountant or merchant banker. Under Companies Act, you need it from a registered valuer. The current capital of the company is small. You need to increase the authorized capital. So you need to again pass a board resolution, a shareholders resolution, file a form, some SH7 or something with the ROC. That's not just a filing. You need an approval from them. That can take a few days. As if that's not enough, you have to then make an offer to the foreign investor. He's already agreed, he signed the agreement, but you have to make an offer in a prescribed form called, again, PAS-4, and you have to file that with the ministry on the ministry website. Then the investor has to accept the offer. Still some more formalities. You have to now have a board meeting again to approve the offer. The bank account is opened. Then you need to, actually the money comes in to the bank account. When the money comes in, I still can't use the money. I have to actually issue and allot the shares, and then file another form, PAS-3, with the MCA website again. And only then can I issue the shares and use the money. So by the time the formalities are done, the money comes in, and the company can actually use the money, the opportunity may be lost. Now, luckily in our deal, we all got it done in a matter of days. But with all the compliances, with the KYCs and other things, it could easily take a few days or a few weeks at times. I've seen transactions. And really, it defeats the purpose of wanting to grow your business quickly. And even after that, there are post-investment formalities, which, of course, we won't get into now. So there were two legislations which were introduced last decade, which were supposed to be path-breaking, or three legislations, like the Companies Act 2013 overruled the 1956 Act. And then there was the IBC, the Insolvency and Bankruptcy Code, which was hailed by people all over the world as a path-breaking legislation, and the same with the Goods and Service Tax. All have been actually on paper good legislation, barring, as I said, the compliance nightmares which are present in all the regulations. Anyway, enough of that. I would like to call upon Anaga now, who is a partner in her firm and with over 20 years of experience in M&A and particularly with the NCLT and the IBC code, and she's also a mediator. So I'd like her to share some of her thoughts on the regulatory challenges and hurdles and how that impacts the M&A sphere. Anaga?
Thank you, Alif. Good afternoon, everyone. So yes, this ease of doing business in India is a priority for this government, as they have been stating this since 2014 when this new government came into power. Since then, if we see the ranking of India on the ease of doing business in the index, it has gone up from 130 to 100. So this happened in 2017, and that was largely due to this, the introduction of this insolvency and bankruptcy code, which is not only for resolution of sick companies, but also it is in terms of, it's known as, it's called as a game changer, wherein being a game changer for resolution of these companies and even for exiting. If a company wants to close down, then for exit, clean exit or for easy exit, this was touted as a good regulation which would help companies to get out faster if they want to close down, which had been like a lagging point in the Indian economy, where companies were not able to close down or wind up very easily. Sometimes it used to take decades in the high courts to close down the companies, especially if they were sick units. But IBC was touted as a game changer, and in the beginning it did work in that way, because the jurisdiction to handle the M&A as well as the insolvency matters is with the National Company Law Tribunal, which is a specialized tribunal which has quasi-judicial authorities, and which once we approach that, we don't need to go to the civil legislations at all. And in this, the NCLT is equipped with judicial and technical members. So these technical members are generally professionals who are equipped to handle these matters, who have had requisite experience in the respective fields. So they are able to handle these matters of M&A as well as not only getting caught in the procedural aspects of civil law, which used to be the case when it was with the high courts. But with IBC and it coming to the NCLT, the M&A process was expected to be smoother, with the benches understanding what the urgency, what is there in an M&A process. So the M&A, the regulations which are there are a code in itself. So we don't need to approach the civil courts for any other steps in the process except for adjudication of the stamp duty. But otherwise, it's a code in itself by the M&A, the entire process with the NCLT. What has, I would say, gone wrong in the sense is the pendency which is there, because the sheer volume of cases which are being filed on a daily basis in these courts is tremendous. I mean, if you look at the bigger benches which are there in the cities like Bombay, Bangalore, or Chennai, or even Delhi, the sheer volume is so much that they are unable to cope up with the volume of transactions which are there. And it's the same bench which handles the M&A matters and also handles the IBC matters. And IBC cases are just piling up. And on to top it, we had the COVID pandemic. In 2 years, there were online hearings and those things which were really not very effective in getting a resolution or to trying to get to the, to fasten the process, which was the intent of the law. Again, a few bottlenecks, if we can look at it, are getting clearances from a couple of government departments, which is required in the M&A process. So that is where even those people need to be sensitized. So previously, we had to wait endlessly, for some department to give their clearance so that the NCLT can proceed with the final orders. But now even they have been sensitized and it has been made time-bound, that if they don't respond within such and such period, then the courts can go ahead, we can go ahead without waiting for their clearance to some extent. So these are some procedural aspects which are being brought in, but definitely it's not where it should be as of now. There's always a scope for improvement. I think with this, in any country if we go, we take inputs and we take best practices from other countries, and then that is where we are able to have a better law or a better implementation of that law. Because like Alif rightly said, it's there on paper, but when we are actually implementing it, because of these reasons, there are delays. smaller benches or in smaller cities where the number of transactions or the volume of transactions is not as much, we are able to get M&A transaction completed very fast, maybe as compared to what we have in other countries also. But especially in the larger benches, I think there is definitely some scope for improvement, and if we are able to reduce the volume and the sheer numbers there, we should be able to get that also in control. Having said that, definitely the government can do something in terms of simplifying the process, maybe not insisting on all the clearances which is there, or even the timelines. Like generally what they say is that merger or an acquisition, it's for closely held companies typically. It is only an internal matter between the shareholders, so which is something why the government should interfere so much. So here in this case, I think to some extent, definitely the regulations can be relaxed, where we calling the shareholders meeting, we don't need to go to the courts and take their approval for smaller matters. So this is something which can definitely be done, and which should be done if we want to keep this ranking on this ease of doing business. And other things, I think, in terms of improving the procedural aspects and the regulations, is minimizing these kind of bottlenecks. So if we know that we can just proceed without getting those clearances from those departments, I think things will happen on their own. Alif?
Thanks, Anaga, for the insight into the NCLT and how it works. Now we've seen that there's a great increase in M&A activity. We've also seen that there are a few bottlenecks and a few regulatory impediments. But despite all that, I think India is a great place to do business. I mean, I can say that I'm quite passionate about this. And I mean, despite my color, I'm fully Indian, made in India completely. And I can definitely vouch that, I mean, the people, the culture, the market, the vibe, everything is fantastic in India, and I would definitely encourage people to invest in India. Now, when we were talking about topics for discussion in today's panel, I invited suggestions from everybody, and the youngest member of our panel, Iman Ali, came up with a topic called killer acquisitions. And I said, what is killer acquisitions? And she said, well, as the name suggests, they are killer deals. And things which are not in the ordinary, they are different, they are high profile, they have huge values, and basically make the headlines. And not only Iman, but even Kaushik has got a lot of experience with his being the head of legal at India Bulls in the industry sector, previously a lawyer at various law firms. And both have got some very interesting deals to talk about in the media, pharma, and other sectors. So may I ask Iman first to give us a few words on some of the killer deals that she's come across, and then followed by Kaushik. Thanks.
Thank you, Alif. Thank you. I hope some of you are still awake after that wonderful lunch. So let me start with what killer acquisitions are. So killer acquisitions essentially occur in transactions where nascent firms are preemptively dubbed as being future competitors. They are preemptively dubbed as future competitors to well-established players in the market. That is the reason that they are called killer, because one, it kills the competition, and the second is that after the acquisition, a lot of the research and development that was being undertaken by the target company is either shelved or abandoned, and that is the double meaning of why these acquisitions are named as such. So big MNCs generally have a lot of resources to monitor the market, patent journals and such, and to identify competing drugs and acquire startups or product portfolios that would in the future harm their own market share. On a global scale, when we come to the pharma industry, Indian pharma accounts for 20% of volume and 1.4% of value on a global scale in the pharmaceutical sector. The CCI tries to deal with this in its own way. What it does is it brings in the concept of abuse of dominance, which is Section 4 of the Competition Act. So it includes actions of acquisitions of nascent competitors by developed companies. But so far, to date, the CCI has not prosecuted any company under the Act and under the abuse of dominant position. Additionally, the CCI has to date provided clearance to all mergers in the pharma sector. The problem with monitoring killer acquisitions is slightly difficult because they are deemed to be killer only after the merger has successfully taken place. And there is abject difficulty in preemptively labeling an acquisition as killer, since the allegation is that you're stifling the competition. And that can only come into picture once the merger or acquisition has been completed. And more so in the Indian scenario, because in India, the way clearance for production of drugs is given is, it might not be clear in the initial development stage of the drug whether it's meant for sale in India or abroad. Section 4 is also very cumbersome and may not be utilized where damage has already been done. There may be a different approach. What I suggest is that there should be a different approach for the life sciences and pharma sector by removing the de minimis cap. So certain transactions, by the nature of their value, are excluded from the CCI's eyes. And with pharma, we should take the step of not excluding them, including them, so that nascent competitors can also enter the market. Another facet of this whole argument is that most drugs which are launched in India are developed and tested abroad first. So the Indian market and the availability of drugs in India is highly dependent on the merger and acquisition scene abroad as well. So we are interdependent on each other across countries for availability of drugs. However, in the aftermath of the COVID-19 pandemic, it is looking like the CCI wants to take these up. So let's hope for the best. I will move to Kaushik now.
Hi everyone. Thanks for that. So when we were discussing topics and she brought out the fact that she wanted to talk about killer acquisitions. Now, I thought that let me speak about something that will be close to, what she is trying to bring out. So I thought that I would pick, and there have been quite a few significant mergers and acquisitions in India in the last couple of years. I think Upendra alluded to that, so did Alif. So it's a difficult bunch to pick one from to speak about. But I thought that why not take this opportunity to talk about hostile takeovers, because they're extremely rare. You see one in maybe 2 or 3 years, a significant one in 2 or 3 years, and so it's quite rare. So the one that I would like to speak about is the recent takeover or attempted takeover by the Adani Group on NDTV, one of the largest media houses in India. Now, this is a really interesting one because it did not start off as an acquisition. So NDTV is held by its promoters through a promoter firm in which its promoters held a significant majority, maybe 99 or 100% of the equity capital there. Now, this promoter entity basically took a loan from another entity that was controlled by a large business group. Now, as it turned out, this loan was secured by warrants, which gave the warrant holder the right to convert the warrants into equity shares of the company and thereby, upon conversion, get a significant majority in the company. So what the Adanis did was they actually purchased the company which was the lender to the promoter firm. So they acquired the company, and immediately upon acquisition of the company, they sent a notice for conversion of the warrants because the loans were still unpaid. So they converted the warrants and they ended up owning about 100% of the company. And this promoter holding company in turn held about 26% of the shares of the listed NDTV company. So 26, 27%, something like that. So indirectly, by acquiring an entity which actually was a lender to the promoter company, they acquired a stake in the listed NDTV entity, which was actually, the promoters of that were these two media barons, the media baron and his wife. Now, what this does is, so of course, once they converted the warrants, they had to, in India, they had to do a tender offer. With the tender offer, their holding now becomes 37% of the listed company, whereas the promoters hold about 32% of the listed company. So now this is a perfect situation now for these two groups to actually thwart each other, ultimately in a position whereas in which one will have to step down and the other will have to take control of the company. So why this is significant is because this was a backdoor entry into the firm. The Adani Group did not try and acquire these shares at all from the current holders. They did not do an acquisition per se, but through this circuitous route, they are in control of one of the largest media companies in India. So this is a perfect example of a hostile, and now what remains to be seen is, in future, how do these two groups, so one has 37, the other has 32, each one will thwart the other in everything that this guy wants to do, because under Indian law, you need a special resolution for anything that is important that you want to do with the company. Special resolution is 75% present and voting. So if these two guys are present and any one without the support of the other cannot pass a resolution. So it'll be interesting to see where we go from here, but I suspect one of these guys will have to bow out and sell their stake to the other. And I mean, no, I think the newer guy is the guy who has much more ability to do that. So this is a way in which, you know, the Adanis actually have now taken over and acquired control in NDTV.
And thank you both for the insights into some of these killer acquisitions. I think the story on the hostile takeover was very, very interesting. I move on now to the last member of our panel, Ashish, who's a founder of his firm in Chennai. Ashish was quite passionate about wanting to talk about the impact of FDI on the Indian manufacturing sector and whether we should also encourage overseas investments to gain technology as opposed to only concentrating on inward investments. So Ashish, can you give us your thoughts on that?
Thank you. Good afternoon, everybody. We are always looking at how the country is attracting investments into the manufacturing sector. We have been successful in doing this to a certain degree. But it also comes with a caveat where our knowledge, technical know-how of manufacturing is limited to what exists within the country. We have been of late seeing instances where large companies have been acquiring companies abroad. To cite an example, the Tatas have acquired quite a few companies abroad, and they've bought in technology from these companies to manufacturing in India. This has resulted in the manufacturing cost in India going down, number one. Number two, good flow of knowledge from developed economies where the technology is much advanced. And number three, in my opinion, it benefits the manufacturing sector of the country where technologically advanced products are able to be sold at a competitive price. As a policy, maybe the industry together needs to work on what kind of investments need to come into the country. Because we have witnessed a few industries coming into the country where they have attempted to kill off Indian traders, Indian manufacturers, which is not good, which is not good for the country's economy as such. Wherein, if there was a policy method, a policy shift, there is a method, but if there was a principal shift in policy where Indian companies are encouraged to invest in technological companies abroad, that would greatly benefit the market present in India. What this would do is, it will act as an equalizer where we are able to attract investments into the country. Right, we need capital, we attract investments into the country, but at the same time, when we are acquiring technologies abroad, this helps us take control of the same. One of the points put forward during our discussion prior to this panel was, are we not already doing it? Are we not taking in technology from abroad? We are taking in technology from abroad, but we are not owning these technologies. Only when we own the technology, by purchasing the company abroad or picking up a major chunk, a controlling stake, will we own the technology and it can freely pass into the country. So maybe the industry together needs to work on this and suggest to the GOI how we need to encourage more acquisitions abroad, at the same time keeping the inflow of FDI intact. This, I'm sure, or rather I'm convinced, that will balance out the export and import situation, and the mechanism to do this needs to be mergers and acquisitions only, and not just borrowing the technology from companies abroad. If this is done, I'm very certain that the manufacturing sector in India, especially automobile, I think of late technology, a lot of mobile phone companies are coming in. So these manufacturing companies will greatly benefit, and companies operating in India, listed in India, will benefit greatly.
Thanks, Ashish. And I think we've heard insights on different topics from all panelists. Ashish has just concluded with his wish list on how we can encourage the manufacturing sector and the acquisition of technology. May I ask each of the panel members to just speak for a minute on what you think might be, what would be on your wish list for 2023, or what you think might be some of the sunrise sectors which should be encouraged by the government. For example, like electronic vehicles comes to mind immediately. So let me go in the reverse order. Maybe Kaushik, you can speak for a minute or so on what is your wish list, or what do you see happening next year?
So before I get into wish list, I just want to quickly say that what has been really encouraging for me is that, so I've been in this practice for a number of years, and in the beginning what we used to mostly see is companies at a high growth stage which are looking for either angel or venture funding or even PE funding, are the transactions that were manifold and more common. However, the one piece of news that I want to basically share with all of you is that in the period between 1st April 2021 and 28th Feb 2022, there were 71 tender offers in India for takeover of substantial stake or takeover of control of listed companies in India. Now, why this is significant is that listed companies in India are already, unlike a venture firm where the growth will be very high. You're already in an evolutionary cycle where the company is at a reached critical mass. Now, if you're still able to show growth in such companies, that augurs well for the future. So I would like to close by saying that, and banking, finance, and technology, as Alif also mentioned, are the two sectors that saw a lot of action in the last year or so. And I'm hoping that this trend continues well into 2023 and even in the future.
Iman, would you like to say a couple of words?
Yeah, I think on my wish list it would be that domestic companies in India should focus on investing in research and development, because a lot of these companies are more focused on marketing, off patent, whether it's drugs, whether it's cosmetics, whether it's something else. And rather than that, it is to focus on innovation so that the economy overall can have a boost from that.
I think that's a very good wish list. Upendra, anything?
Yeah, you see, during the pandemic, all age group people started going online shopping, and that's been a big booster, and I think going forward that will continue. So e-commerce activities will grow to a great extent. And also the private equity-backed M&A, that is going to be a big booster, because in the last 1 year, private equity-backed M&A in India was 28% of the global private equity, which surpassed China by about 4%. China was 24%. So that will lead to a lot of investments and backed by private equity. And given the commitments to green energy, I think the green energy will be the hot cake, whether it's e-vehicles or other green energy sources. Besides that, as I said, there are a lot of new talent, new entrepreneurs coming up, startups. They will continue, and they, the bigger ones may have global dreams like Byju's. They will try and go overseas, and Byju's is a big trendsetter to lead others to global reigns. So these are the sectors I feel should be.
Thanks, Upendra. And one thing I've learned over all my years is that one must let ladies have the last word. So, Anaga, can you just give us some closing thoughts?
Thank you, Alan. So, for helping these sectors which are on everybody's wish list, I think the regulatory processes need to be strengthened. So, in my wish list for 2023, it is fully functional NCLT benches with 100% capacity, with adequate staff, and also some simplification in the procedures, especially to cut down the red tape, and wherever we are facing these pendencies, that would be on the top of the wish list for all the other wish lists, I think, to be fulfilled. Thank you.
I think that's amazing, because that's exactly my wish list. I mean, today I had 3 matters in the NCLT, and my junior just messaged me saying none of the 3 were heard due to what they call as paucity of time. And the judges didn't have enough time to hear it. So I think that is definitely top on my wish list as well. And I would like to thank the panel for a wonderful insight into so many topics. We have a few minutes for questions, so if anyone has any questions, please feel free to do so.
Please use the microphone in the center of the room, please. Thank you. Because we want you on camera. You see the camera there? It's live streaming.
Hi, I'm Rahul. So all of you panelists spoke about acquisitions, mergers, investing into R&D. I just want to know and have a word from you people that why any of the Indian brand has not invested in a good mobile manufacturer or a laptop manufacturer. All is assembled in China or comes through China only.
Who would like to take that one?
To any particular panelist, or does anyone want to answer that one?
I think it's more of to do with technology.
Yeah, please.
In the microphone, please, so we can all hear you. Thank you.
Rahul, mobile manufacturer. You'll be very surprised. I walked into a mobile shop yesterday in Dubai, and I asked, can you show me a mobile? And I said, where are these mobiles coming from? His straight answer was 100% from India. I said, is nothing coming from China now? He said, sir, it's almost stopped. Yeah. So on the mobile side, I'm sorry I'm taking your time on this, but on the mobile side, I think there's been a huge difference on the Indian side. Yeah. But on the laptop side,
So the mobile side, all the Indian manufacturers are just assembling the things. The raw material, the chips, they are coming from Taiwan or China. None of the Adani, Tatas, Birlas, none have invested in making a global brand like OnePlus, Apple, BlackBerry, to name a few. And even after 2 decades, the laptop is a handy thing. It's a everybody necessity, but the Indian companies are not able to make a global brand.
They don't copy as well.
They are getting into joint manufacturing of Apple things.
Yeah.
So,
can I?
Yeah, please.
Yeah. So this I think comes down to the kind of technology we have in manufacturing. I don't think India has the technology to manufacture the semiconductors that are required for the functioning of these machines. You have Intel, which is a global corporation who dominated the market thus far. Now I think Apple is coming, they are manufacturing their own silicon. So this is where I think Indian companies need to step up. If you look at the Ambanis, the Adanis, the Tatas, with the exception of Tata in a certain sectors, they are more of traders, and they thrive on trading, buying and selling of goods. We need to strengthen the manufacturing landscape here, and I think the next, or what is going to be in demand forever, is technology. Unless we have some policy incentives to encourage manufacturing of technological products, we are going to stay in the same place where we are going to be service providers, where companies like TCS and Wipro are going to have huge market caps, but that may not be the harmonious growth that we are looking to achieve.
Thank you. Yes.
Yes. Good afternoon. This is a very interesting topic. We just recently concluded a transaction in India, so we are happy about that. Yani, on behalf of our company, Abdul Latif Jameel. So my question actually is related to deal breakers or acquisition killers. So to which extent and what exactly define the line between abuse of dominance versus fair competition under the Indian law? And to which extent the competition authority could be considered as a barrier to entry, especially when it comes to approval, process, requirements, and the duration in particular. So I have another question, but I'll stop with one because of time. Thank you.
Though I'm not an expert in competition law, but under the Indian law, there is a provision for abuse of dominance. However, it is rarely used. It has not been put into action so far, especially in the sector that I've been studying, the pharma sector. The abuse of dominant position is there in the law, but it is something that is not being used.
I think also the larger issue that she mentioned was that, you know, the whole process of approval for a merger by the competition authorities in India happen at the time that you are actually trying to do the acquisition. So this is pre the acquisition, whereas the killer steps actually happen post the acquisition. So there may not be enough in law today to be able to prevent this. But this is something that if this trend continues, then I'm pretty sure that at some point the regulators will look at this.
Yes, last question.
I heard the wish list of all the panelists, especially for the 2023. And considering the fact that we have already reached 8 billion as far as the population is concerned, and in the India scenario also, a lot of lands being used for the construction. So in light of it, what would be the future of agro-tech industry? And I would like to hear from either Alif or any of the panelists. I mean, why agro-tech is not in your wish list?
Agro-technology. Is there a future for it in India? Yes.
Oh, I definitely think there's a future for agro-technology, and in fact, I think at least in the policies, there is a lot of encouragement for, horticulture plants breeding. I mean, it is being encouraged. Why it hasn't taken off, I don't know the answer to that. But I think it is, I mean, we are based on an agricultural economy, so I see no reason why it should not take off. I mean, any of the others have a view on this?
Yeah, I think this will take off in a big way, except that, it's a matter of choices, which one is going more and which one is less. But this has great potential, and I'm sure the global players will come in. There are already, seed companies from the US or the Europe who are looking at India. Some are already invested, and I think there would be lots more in this field going forward. Plus, the government also has to ensure that, the local farmer is not disrupted. The big companies come and take over the manufacturing and the bases, so that his livelihood is not, disrupted. So that all has to be taken into account. But in the long run, it has a great potential.
I think it's also a mindset, because we have these age-old trade unions who kind of tell the farmers, feed them with misleading information, saying the big players will come and you will be deprived. But it's the other way around. If big players come, there'll be more demand for the products, there'll be more demand for exports. So I think a lot of the mindset of some of the age-old thinking has to change.
Thank you very much, Alif, for moderating this panel. Thank you, panelists, for all the insight. Ladies and gentlemen. Thank you.
Thank you.
All right. All right, next we have a keynote on the advantages and disadvantages of open banking, how it can revolutionize the financial services sector, and where regulation comes into play. The speaker, who is our gold sponsor and the CEO and founder of FidiPay, will also talk about what steps organizations should take when considering using open banking in their businesses. As an avid supporter of disruptive technologies, he has paved his way into India's fintech industry. Please put your hands together for our next speaker, Mr. Manan Dixit, founder and CEO of FidiPay. Welcome, sir.
Hi, everyone. Hi. So good afternoon, first of all. I know this has been a post-lunch session, so I'll try my best to not make you sleep. Now, open banking has been a talk of the town for around a decade now, and a lot of companies around globe has been talking about it. But what exactly is it? Is it actually the next wave that we are all talking about in fintech? Or is it just something that a fashion statement that has become? So today, I'm here as Manan Dixit, founder and CEO of FidiPay, to talk about open banking. Is it actually the future or just a fad? Now, before going deep into the open banking, let's just see what actually it is all about in a very brief and a few timelines that is there. So open banking evolution has happened over, I would say, around 2 decades now. And it is nothing but a method of using modern technologies so that the convenience, the reliability, the speed of transaction can happen, and a business or an individual can truly feel the integrated systems at large. Now, if I just go back to the timelines of how it all started out, especially after the dot-com bubble, we saw the introduction of internet banking. And it was a wow moment for all of us, because we were able to sit at home and do all kind of transactions through the internet banking portal versus the physical branches and everything. And after that, immediately the Payment Service Directive came in picture in the UK government, and it introduced the openness to the basically the systems so that you can perform transactions across the domain. and it got adopted by European Union or European Commission in 2013. Before that, UK government launched the open banking standard. They came up with another directive towards it. So that's just a small timeline to talk about. In 2015 is when actually the framework of open banking came in picture. And the UK government directed all the banks to come up with a complete ecosystem of open banking, and that was adopted by European nations across and now to the globally. So after 2020 is when the lot of happenings are started happening. Now, coming to open banking systems, there has been a lot of innovations around it. Like we know about open neobanks, we know about SME banking, we know about payments that has grown out. But what exactly are the challenges or the road ahead? There are multiple factors to it. Nobody can quantify each and every factor. I'm just considering few of the points as per my views that is going to be useful in the open banking framework for any organization. So coming to the first pointer, which is digital transformation. Now, digital transformation has played a very key role in every startup, every domain, every industry that is there. Be it fintech, be it education, be it health, be it marketing, everything has played around with technology. And because of that digital transformation, today up here we are sitting. In fact, we have seen the best use of digital technologies during the COVID times, wherein we were all sitting at home and using a number of technologies around us to have that. Now, how that digital transformation can be used within the open banking framework is a key to it. Now, first pointer being improvising the customer experience. Any technology that comes in picture, it always brings a convenience to it. So there's always that part that comes in. But what is the experience that it is bringing in? Is it good? Is it bad? It is neutral? Is it something which is going to benefit? Or is it something which is going to across the globe, be it consumer or business, we are all spoiled for choices. If I talk about India, today I have so many applications on my phone that I can choose every day and go for next 60 days without repeating the application. Now that's choice of consumer. But if I talk about open banking, I don't even have a single app right now through which I can perform my business banking or a neo banking throughout everything. So that's going to be one very key aspect in the overall open banking infrastructure. Secondly, being the operational efficiency. See, with technology, the biggest challenge comes in with the efficiency of this overall system. We are able to implement the technology, we have coded well, we have improved the experience, but again, the efficiency is not there. Now, efficiency is not only related to a particular startup or a company, it is the overall ecosystem at large. If I talk about a fintech industry, startups are just enablers. We are just a medium to process a transaction which is initiated by a customer through his bank. We cannot be a bank. Once we become a bank, we are out of that league. So that efficiency has to be improvised across the ecosystem. It is not only that a startup has to improvise it out, the infrastructure at the bank end, the infrastructure at the central bank end has also to be improvised out. And that all can happen through digital transformations with the introduction of newer technologies and systems and a lot of systems across. Thirdly, being a very key point is facilitating the regulatory compliance. Any fintech or anything into a financial domain has to go through regulation. And facilitation of that regulatory compliance is the key for any startup. Because what happens is when some new innovation happens, during that time there's no regulations around it. But as soon as it starts going to the masses, the regulation kicks in. And that's when it becomes difficult for a startup or a fintech company to survive out because they have not thought of it. But again, through, as I said, through digital transformation, a lot of things can happen. So regulatory compliance is, again, the segment which has to be taken care very strongly. Fourthly, being the data security. Now, the way payments have become an integral part of our life now. Nowadays, we don't even need to carry our wallets. We can just carry our phone and roam around. Similarly, we should be able to have that confidence into the consumers of open banking as well. And that can only happen with the enhanced data security. The customer should be able to control when his data is available or not. Like as was discussed in the morning session about data privacy and systems around it, like it's all in the cloud. So you can control those things, like when it is in the cloud or when it is not. So that's about enhancing data security. Lastly, like with digital transformation, innovation always comes in picture. And due to that, today, up here we are all sitting because of innovations that has happened across our lives. So that's about digital transformation. Now, in terms of regulatory changes, as I've pointed out earlier, that regulations is a very integral part of the entire fintech ecosystem, and that is very much necessary to protect consumers at large. And with regulatory changes, what all can be done is, firstly, is increased customer protection. Today, the data that is flowing through our systems, through our mobile phones, through our laptops, and the entire digital network is humongous. Now, if there's no regulation around it, nobody is liable for that data. And tomorrow, if something happens, we keep on hearing the leakages at the bank end, at the financial institutions end, at the startups end, and that's one of the concerns around it. And that's where all this data privacy laws has came in picture, all this regulations have came in picture. So regulatory change is one key aspect wherein the increased consumer protection has to happen, so that consumer feels confident around it. Okay, it's a regulated entity, it's regulated systems, and whatever is there tomorrow, somebody is liable for it. There's no way that he can be at fault and not get caught into it. Secondly, being an oversight, increased oversight and risk management. Now, with an introduction of digital transformations and technologies, banks have become more encouraged, or not encouraged, I would say, banks have become more, I would say, in terms of, like, they have become more vigilant. That they have to implement the risk management system. They have to have dedicated teams. They need to have the AML processes, which should be digitally implemented, so that if any activities or any frauds is happening, it can be alerted out. And that's a good piece that has to be implemented into the regulatory changes. With regulatory changes, the biggest thing that comes in picture is a greater financial inclusion. Any technology that comes in, if it is not regulated or if it is not falling under any compliance, there are high chances that it will only be available to the elite class or the affluent classes. It will not penetrate to the masses. Why? Because there's too much cost into it, there's too much of hassle into it. Why go deeper into the region when we can just service out the affluent class and make money out of it? But with the regulations, the level playing field is created. The competition is being created, and which ultimately results into a greater financial inclusion. With financial inclusion, when the companies are going down, ultimately it's all about who reaches farther, who reaches faster. So obviously the enhancement of a customer experience comes in picture, and a customer service delivery comes in picture. Because today, if I'm using a particular system and if there's no customer service into it, I'll stop using it out. So enhancing customer service becomes a part of that entire ecosystem. And this increases the transparency and the compliance, both at the institution level, because they have to maintain the data clearly, they have to report it out, any kind of AML activities which are happening up, they have to follow the compliances, they have to take care of the entire 360-degree angle into it. So that about the regulatory changes is. Now, in terms of open banking systems, as I said, that it has been there for a very long time, and we all have been hearing about open banking. But if we see still today, like across globe, if you see, there would be around, what, 25, 30 companies, which we can confidently say, okay, these are open banking companies, or these are the companies who are working into open banking on a bigger piece. Like there would be bits and pieces on a regional level, but if we see at large, there would be a very few number. But if I similarly see into the payments space, there would be a flood of companies in every region. Now that's what the open banking is lacking right now. Why? Because there are a lot of hitches around it from the banking institutions also, from the regulator side as well, from the central bank as well. Like, is it something that we have to go into? Can we not avoid it out? Is it something that we can just restrict it to a payments, or we should not allow the banking? Like, I'll give you an example. Back in India, we are connected to over 8 to 9 banks now on the open banking side. Every bank has their own terminology. Somebody says it's open banking, somebody says it's connected banking, somebody says it's API banking, somebody says it's payment API, somebody says it's just banking over the internet channel. So it's different thought processes that they have. Every bank has their own set of processes that they have implemented. Few has implemented us into a banking system, few has considered into a payment space, few have considered us into a banking correspondent space. Now, that's just because of the lack of the experience or the lack of the regulations around it. Though India has a regulation around payments, especially UPI that we have all seen, which has grown tremendously, but on the banking side, a lot of things are missing right now. And to enable on a larger scale, open banking is going to change a lot of dynamics into the entire ecosystem. Like, imagine a business who is using a particular ERP, say SAP. He can just go into an SAP finance module, connect his bank account, do a transaction from itself, see his statements, do all the reconciliations by SAP, and that's just a service improvement for him. He doesn't have to worry about any of the messy things of downloading the statements, doing the ledgers, completing the entries. All can happen automatically. And that's a power the open banking has. Not only this, like today we see on an open banking side, like if I go to a particular payments app or a third-party service provider app, I see a lot of offers that are coming in. Now, those offers are not from the bank. Those offers are from the cross-sell of the data that has happened. And that's a serious concern that we have all seen and raised out. But with open banking, the same bank where I have an account, the service provider can supply this kind of analytical data to the bank, and bank can generate a customized offer for the customer. Now, that's a power that a bank can have. Like today, I have came down to Dubai from India. So my bank, ICICI, would have generated a customized Forex offer for me in the bank, and it's a customer. It is not going out of its ecosystem. So that's what open banking can do, and that's what the power of it is. Now, around this, the customer experience, which I've talked about earlier, has to be improved. There are still lots of gaps, which we see on a day-to-day basis. No clear platforms are there. Still a lack or lack of confidence, I would say, wherein the people are not confident that, are you able to process my transaction without my authorization? So that's a lot of experience which is missing out. With these experiences, again, the data analytics, the insights come in picture. Again, today what happens is, all this data analytics and insights happens. I'm not saying it's not happening because of the thing, but it is all happening from the third parties, from the cross-sell of the data. But with open banking, it can all happen within that ecosystem. So enhancements of that data analytics for the bank also. Right now, I, as a consumer, the bank only knows my bank balance. Bank doesn't know my spending patterns. Bank doesn't know my loan patterns. They all get to know from their third parties. But with this, they get to know all this things, and they can build their products around it. So that's all can be happen with an enhanced data analytics and insights to the bank. Obviously, it will end up resulting into the increased efficiency for the entire ecosystem because, say for an example, there's a small bank which doesn't have a bigger lending book. Now with open banking, they can exactly know which customers are available for the lending and they can process that out. Right now they have a lot of manpower or the third-party providers to do that. But with this, they can do all these efficiencies in a better way. And lastly, into improved risk management. This is apart from regulation, this is one very key aspect of the open banking that risk management has to be implemented. And there cannot be a single leakage into that entire risk management process. Because when you are opening up doors for the flood of the data, a lot of play arounds can happen with that. So risk management, AML systems, AI, artificial intelligence, machine learning systems has to be implemented for the risk management. Now coming on the similar lines, cybersecurity it's one very critical piece into this entire open banking framework that we all talk about. Because at the end of the day, what is happening is when a system is flowing from a consumer to a third-party service provider to a bank, there's a lot of risk that comes in picture. Plus, what kind of a third-party service provider systems are, whether it is regulated, whether it is not, whether it is secured, what kind of data that is happening up, how the fraud detection is happening. So the cybersecurity plays a very critical role into this entire piece. And enhancing customer security is one very key aspect into this entire ecosystem, because with an implementation of enhanced customer security, you are not only giving a trust to the consumer that you can perform transactions safely, you are also ensuring that any fraudulent activity is stopped. And consumer is confident to perform a transaction through the open banking ecosystem. Like what has happened with us using payments ecosystem. Like when the wallets came in picture, when the internet banking came in picture, we were all very skeptical around it. But with the increased regulations and the frameworks and securities and every kind of thought process that is implemented, today we know those frauds have come down. Though there are still frauds around it, but if you see the kind of percentage that has come down, it's drastic. So that's an enhanced customer security which is required that can automatically, that can only happen by implementing automated monitoring systems. Otherwise, it can't happen. You can't rely on any of the manual systems that is up there. On the regulator side, the regulator has to improvise on the data privacy laws, on the data purging laws, on the data sharing laws. One very amazing piece that has been introduced in Indian ecosystem is account aggregator. Now, account aggregator, I'll just take 1 minute off to the topic. It's on the lines of an open banking framework, I would say, because typically when a consumer has to take a loan from a banking ecosystem, he has to share tons of data, right from his KYCs to his bank statements to his income tax details to a lot of such data that goes in. And this is all going into a physical format. It goes through multiple hands. You don't know who have that access to that data as a consumer. With account aggregation, the customer can authorize a third-party service provider to have an access to that data only directly from the bank system. No third party comes in picture. The third party is only enabling the platform. They are not processing, they are not storing, or they are not neither, like no kind of data is flowing through that party. It is directly flowing from the banking system to the lending company or the loan service provider, I would say. So that's again a bigger implementation on the account aggregator side, which enables the solutioning on the open banking framework and which comes under all this solutioning in place. Sure, I'm just finishing off. So in terms of cybersecurity, I've already talked about. I'll just quickly talk about two things. So one is banking as a service. So I've talked about open banking, and banking as a service is just a byproduct out of it, or it's just a subset of it, wherein entire banking services can be given out to the consumers as a third-party service providers with the APIs and all that. And there has been a lot of infrastructure development so that you can do deposits, transfers, lendings, and money, a lot of things, bill payments and everything. We have been working into the open banking ecosystem for a very long time now. That has been one of our core at FidiPay. And we have developed one of the good open banking systems back in India and are connected to a lot of corporates around it. So thank you so much for patiently hearing it out. Any questions?
You spoke about a lot of information and data being, gathered by the banks. In open banking system, how do you keep the government's hands off the data? Because, a country like India has a lot of political agenda and a lot of financial information, if you must have noticed, is getting used, during the last 10 years. And, having such a system in place, allows a lot of corporates to be targeted, a lot of investments to be targeted if that kind of information falls in the hands of the government. And with your company being registered in India, it can't be off the hands of the government. You will, at some point of time, either be coerced or subjected to disclosure of that information. How do you deal with that?
So it all boils down to the regulation around it. Like today, if I talk specifically about India, UPI has been one of the very successful implementations using the open banking framework. And today, India processes over 700 billion, or rather 7 billion transactions in a month, processing over 10 lakh crore rupees worth of transactions. Now, all this data, government has it only on the transactional side, not on the consumer side. That is only restricted to the bank. Even banks are not allowed to share that data until and unless there's a law enforcement agency that comes in picture because of certain fraud or things that has happened out. So when you go to a bank, because of the regulation, even they cannot share that data to anyone. We as a service provider are also bound by that same regulations around it. So as I said in the presentation as well, that it's all about the regulation being into strong. So customer data security is a very key aspect. And if there's no regulation around it, obviously such kind of things is going to happen. So that's one of the bigger piece on the regulator side that has to get implemented to have that confidence into the ecosystem. And that's why, like, even now, like I talked about that it has been there for over a decade, but still that confidence is not there. Why? Because that regulation is not there. So the consumer don't feel confident whether should I do that or not. So I hope I have answered you.
Thank you very much. Please put your hands together for Mr. Manan of FidiPay and his insight on fintech and regtech and regulation. Thank you. Thank you, sir. All right. We'll now move on to our next bit on automation and money. Technology is rapidly changing how businesses interact with customers and vice versa, leading to the need for greater efficiency and improved customer service. With the introduction of automation, it has become easier for customers to access services without having to go through complicated paperwork or lengthy phone calls. This new approach can reduce costs, save time, and give customers more control over their finances. Ladies and gentlemen, let us welcome our three speakers for this fireside chat. First, Ms. Amira Ismail, Head of Acquiring, Arab Financial Services. Welcome, Ms. Amira. Salim Said Khamis Al-Khalbani, Head of Business Operations and Support at Bank Dhofar. Welcome, Salim. And Gopal Krishnan Rajamani, Cluster Delivery Head, Cloud and Infrastructure Services, BFSI Middle East for Wipro. Welcome. You can take the three center chairs, I guess. Yeah? All right. So for the next 25 minutes, the floor is yours. And the last 5 to 10 minutes, Mr. Moderator, will be for questions from the audience. Thank you.
Okay, able to hear? Good afternoon, everyone. So it's a pleasure to be the moderator for this talk, which is very close to everyone, automating your financial services. And I'm pleased to have with me Ms. Amira Ismail, as a head of acquiring from Arab Financial Services based in Bahrain, and Mr. Salim Said, head of business operations and support Bank Dhofar from Oman. And we'd like you to introduce yourselves, and then we'll start this.
So, hello everyone. I know it was a very long day, so we'll try to make it as short and sweet as possible. So, my name is Amira, and I'm working as head of acquiring in Arab Financial Services, which is subsidiary of Bank ABC in Bahrain. I came here with an experience of 25 years in the world of payments and operations. I used to work with one of the American companies as regional director of operation, looking after all the Gulf region, in addition to the Middle East later. I'm Oxford alumni. I've done my diploma with Said Business School and another diploma from Cambridge. I didn't start in the world of payment. I just studied English literature, and after I finished my studies, I just found out that I cannot do this, and I cannot be an academic person. I need to be with the money. So I changed everything. I restudied. I started again, and here I am today with all of you esteemed leaders of payment and laws. Thank you very much.
Thank you. That was awesome. Mr. Salim.
Yes, my name is Salim Said Al-Kalwani. I'm head of business operation and support in Bank Dhofar. Prior to that, actually, I was head of CRM, customer relationship management, in which we implemented a strategy to transform Bank Dhofar to be more customer-centric, so to address and meet the clients' and customers' needs. And I think this this discussion is more about customers' needs.
Thank you, Mr. Salim. And myself, you can call me Gopal. So I've been in this industry for 3 decades plus, and I worked around the globe, in India, in Singapore, in Hong Kong, and now I'm in Dubai for the past 3 years, worked with various banks across Society General, Deutsche Bank, Prudential, Citibank, Mashreq here in Dubai, and now with Wipro. So it's a privilege to be the moderator for this talk. And just to set the context, I think we all know all banks are striving to be the digital bank, correct? That is the mantra, and the previous session by Manan also spoke about that open banking, correct? What are the challenges and other stuff. I just wanted to run through some of those areas, how currently the banks face challenges, primarily in the business side, there is always a suboptimal customer experience, correct? There is never a nirvana in customer experience. You can always do better than what you did today, correct? Tomorrow is a new. And then the other big challenge for all the businesses face is how to improve revenue, correct? And how to improve revenue is through customer acquisition, correct? So that is the base, and be it in any part of the banking space, retail, corporate, trade, unless you get a customer, you don't have money on the table, correct? So how do they then increase the leverage on that? And I think Manan spoke about the open banking. And then when we move from business to the operation side, they face challenges because traditionally banks are always having data which needs to be processed in batch, correct? So that's why all the core banking system which you have are so dependent on the end of day should run properly, correct? Otherwise, the next day, there is a challenge. Then you also have a multi-day onboarding process, so which again, the operations team, has to make sure they have the STP enabled to reduce that. And then we have other challenge of multiple systems for the agents, be it the customer service agents or be it the the people on the ground who go and get the customers. They have to log into multiple systems and be wary of the different challenges. And very limited self-service capabilities. That's what banks are now enabling it. Then from the technology side, banks have been as old as a century old, correct? So I come from Citibank, which is 100 plus years. And they are used to having legacy technologies. And it's always a fight how to do the dual path, correct? So we need to move into the new age, plus maintain the old, and then, balance between those two things. And that is bringing in a lot of complexity because they introduce a lot of middleware environment, and that has, all the challenges of connecting. And then data. So that becomes another big challenge. Most of the banks have data of customers, but it's siloed. They don't talk to each other. So the golden source of data is still in building, correct? So there's no bank which can say, I know my customer across all the banking domains, be it retail, corporate, trade, or anything, because the regulations sometimes dictates it, and sometimes the banks have evolved like that. They start with the consumer banking, then move to the corporate banking, then to trade finance. So these are the key challenges which all banks face, and that is where the steps of automation comes in. And I would lead into the topic based on that. So I'll like Amira to take us through, because she's been in the acquiring industry for so long, and we would like to take the journey of, the card acquiring as well as the payment, what has happened in terms of the evolution. So over to Amira to take us through from that.
Thank you very much, Gopal. So for the evolution in the journey of the credit cards, and as long as I'm the head of acquiring also for the merchants, I think this is a very long journey. And it starts actually in 1950. Is the name of Frank McNamara brings anything to your mind? Do you know the guy? Do you know who is he? Any clue? Okay. So 1949, gentleman, his name was Frank McNamara, went for a dinner with the wife and two of his friends, and it happened that he forgot his wallet. And of course, it was a very embarrassing situation. And guess who helped him? Of course, the wife. She paid the bill. He went home and he was frustrated, and he decided that next time, if he forgot his wallet, he has to pay. So he came up with the first credit card that was in 1950, which is diner's card. So he managed to go for the same restaurant in USA after 1 year with a board card, and that was the first charge card, and he used to pay his bill once a month. So it came from here, and he managed to have like 10,000 customers. So 10,000 customers in 1950, and we are today in 2022, and we are having more than 26 billion cards between credit, debit, charge, reloadable, 26 billion, and we are having 8 billion population. So the journey, I think it was too long from the 1950 to today. After the 1950 and 1960, that was the credit card magnetic stripe introduced, the one with the magnet stripe at the back of the card, which has all the customer information. And then 1986, first chip and PIN card was introduced. And then 2007, the first contactless payment cards, debut in UK. And then 2010, virtual wallets and apps. 2011, Google Wallet. 2014, the Bitcoin. And then we have, after that, the launch of first biometric payment card, and that was again in 2014 between MasterCard and ZWipe. Samsung Pay 2015 payment beyond, which is like we are having now, and we've been telling you this since morning about the open banking, the embedded payment, and the central bank digital currency, buy now, pay later, and digital wallets. To have your own credit card before, either you go to the bank or someone will come to you, and there's a lot of KYC, there's a lot of requirements, and it may take you at least like 1 week, 10 days in order to get the card. Now, you can get your card in less than what? Just like to open a bank in your digital bank, which we have now in Bahrain, it takes you 2 minutes to open your bank account, and you are getting your virtual card on the spot after these 2 minutes, and there is a physical card. If you want, this will be delivered to you next day. So 2 minutes to open a bank account and to get the virtual card with a limit. All what you have to do that do your eKYC, which is put all your requirements attachment, and then put it in the app. The app or your bank account is not only one currency, it is like 5 or 6 currencies. This is up to you. And it is a bank account and a wallet and a card at the same time. So this is where we stand today. And I know that the evolution is taking place in a very scary way. I think like by no time, even there will be no cards, there will be no wallets, there will be some other payment methods, which like everyone is looking for.
Awesome. Thanks for taking us through the journey. So I think many of us might remember the diners, but the new generation might not know the diners card. So that's become obsolete. So Mr. Salim, on the same journey, from an operations point of view, what are the things which you saw, getting automated to get into this acquiring process?
Okay. What I think from my experience, normally when, for example, implement a new initiative, they concentrate on the re-engineering of customer-facing processes. But no, in order to succeed, you need also to re-engineer the internal processes, which is very important, because if you only concentrate on the front-end process, still you have the back-end processes. And we have actually a lot of technology, but the good thing, the thing that it's not utilized very well. So the most important is the idea how you utilize the technology, how you utilize the data. I give you an example. We run one of the credit card campaign in our bank. So through the call center, telesales. So they call the customers, offer him a credit card. Most of the customers are interested. But once they reach to tell the customer, in order to avail the offer, you need to visit the nearest branch. He said, okay, I will go. So we found out that most of the interested customers, actually, they didn't visit the branch. So what we have done, we utilize our technology. We utilize our ATMs. So the customer is no longer required to visit the branch to accept the term and condition, because acceptance of term and condition, this is central bank requirement. So once he accepts through the call, we will send the credit card through a courier, local courier, and through ATM he can accept term and condition and activate the credit card. So this is a simple example that the technology is not used very well, or we don't have the idea to utilize the technology. Another example, if you can allow me. Now I think most of the banks, they are not utilizing the data. The data about the customer himself, his preferences. A simple example. Now, when you insert your debit card in your banks, it still will ask you, what is your preference language, Arabic or English? Although millions times you press the same language. So this is how we need to act in terms of utilizing the technology and utilizing the data.
Thanks, Mr. Salim. And I would also like to share one example, which having worked with Mashreq, so they again launched a new card for the teenagers, So they call it as Mashreq Neo Next. And I felt that was a very thought-provoking innovation because I opened it for my son, through my account. It's all through the mobile banking, and it just needs to key in his Emirates ID details because the bank already has mine. And then he gets an e-card within 5 minutes, and then he also gets the physical card through the courier with a brand new packaging, which is attracting the teen with some gifts, hampers and all, So they ask few questions, what are you interested? So he told soccer. They send a soccer T-shirt, type of a thing, so which impressed him. And the good part is he feels, proud that he has a card which he can use, and we have the control also. And it gives all the controls which you need to, in terms of limits, in terms of where he can use, which countries, which websites, all that control we can also give in so that we, somebody's told in the morning, correct? So security by design type of a thing, data protection by design. So those are already taken care so that we know, teenagers sometimes don't understand those risks and they might get into a trap, not by themselves, but just by swiping in somewhere or keying in an online site that could get phished, correct? So those type of things were also prevented. And this was a very good experience for the teenager as well as for the parent, and all these things happen through the automation process of acquiring. So I thought that will be a good example to share. I'm conscious of time, so I think everyone shared their experience. Now we go into the next areas, correct? So all businesses know they want to change and they want to transform, correct? But I always feel technology needs to be embedded with the business demand, correct? It cannot be, oh, this new technology has come, for example, cloud, put everything in cloud, So if that gets driven, then the business doesn't know the value, correct? Unless business, you can go and communicate to them in their language, hey, by doing this, I'm able to, traditionally you are doing 20 customers per day, with this you can do 40 customers per day, and type of a thing. And then it makes sense, you say, this was enabled by this technology. So I would like to hear from Amira and Mr. Salim some use cases which has been there because you have been in the executive committees where there is always, business versus IT priorities clash, and where the unison has to happen.
Actually, I'm not sure it's a clash or no, because now it's not the automation for the sake of automation. It is automation for the sake of the business. That really we need to enhance our business. We need to enhance the customer seamless experience. It's not only because okay, we want to show off that we're using this or that. I think one of the use cases is the digital onboarding. And digital onboarding, actually it was really successful in our case, either from B2B or B2C, because business to business, for example, for the merchant himself, he can onboard himself. All what he has to do is just download the application, and then he can onboard himself, put all his information, including the KYC and everything. And then by doing this, it will save him a lot of time, and he can get the point of sale or whatever in no time. Business to business, digital onboarding, this is for the digital banking. We have the first digital bank in Bahrain, as I just mentioned earlier, that you can open your bank account in 2 minutes. What we're referring to, Gopal, is that when you are using something like a robot, for example, we do have Fatma there, which is like a robot, Fatma and the chatbot. Yeah, sometimes you are in a situation that you cannot really wait for long, and then when you are asking a question, because she's systematic and she's already trained to answer certain answers, which is not what you are looking for, here it clashes. It clashes, and you feel like, no, I want to talk to someone who can really understand what I'm talking about. So to have a good balance between the technology, the automation, and the customer need, this will be a key factor of success.
Great. Mr. Salim?
Yes, actually, I totally agree with and the important things that the technology we don't implement technology for the sake of technology implementing. Sometimes we end up implementing something, but no one is using it. I'll give you an example what has been implemented in Oman. We have implemented a wallet in the ID card, in the shape of the ID card, national ID card. We implemented a wallet. So the customers can use their national ID card for any type of payment in the government, in the shops. But for example, for me as a user, will I use my debit card or the credit card or national ID card? Of course, I will take up my credit card or debit card. So this is one of the examples that we don't implement technology for the sake of implementing technology.
Thank you.
Panelists, we have 4 minutes left. Perhaps one question from the audience if you'd like to.
I think we'll just do a wrap-up and then we go for the...
We have 4 minutes left. Thank you.
So again, just to wrap up from your country's perspective, in the next 5 years when you look forward, so what do you think some of these automation capabilities need to be enabled, in context of your countries of operation?
I think in no time that the credit card, which we love too much, will not be there anymore. Even the wallet will not be there. It's more of a biometric, facial recognition of the finger or the eyes, and in addition to artificial intelligence, both together. This will take more place. It's like it will be customer experience, like, okay, there's cameras in the store, and then they can take like my biometric by whatever, with the camera, with the item I bought, and then they'll send the bill to my bank directly. This is what I see in the next 5 years, or maybe a little more than the 5 years. But I'm sure that there will be like a decrease of the credit card and the wallet. Thank you.
Yes, for me, in order to know what's the customer expectation in the 5 years, I need to put myself in the customer shoes. So for me, if I am a customer, and I'm now also a customer for a bank, I need a bank to delight me, not only satisfy my requirement, to delight me. Now, for example, before my birthday, send me happy birthday, and this is a voucher with this discount. This is partnership with another third party, and also data, utilizing of data. Same, for example, your wife's birthday after 3 days, and this is a 20 voucher for jewelry shop, for example. Your kids, the same for the kids. Other than this, I need to use mobile apps to instantly avail credit facility. I don't need to visit a bank. I need to, through my mobile, because they have credit scoring from central bank, they have all the information, they have my salary in the bank. So this is what I'm looking for.
Thank you for those insights. Let's open it for the questions from the floor.
Do we have a question for the panel? Yes. You know where the microphone is.
Actually, I won't be happy if you didn't ask. Because this will only be our session, you didn't ask, okay?
Yeah. No, I have questions all the time, but they are not allowing me. So. Sorry, this is actually related to how the alternative payment solutions will affect the customer centricity from one angle, and how the cryptocurrency will affect the alternative payment solutions in general, including forex industry, as if that will be a part actually of the impact related to the alternative solutions.
That was a tough question. They're debating.
It's like half-baked question, and it needs 10 pages of answer.
I think it was echoing a bit, so we couldn't hear that question also clearly. So you were asking how...
Can you re-ask the question, please, sir?
So maybe it has 2 parts, the questions. The first part is the effect or impact on customer centricity. So if that's, actually this may also relate to competition between the various service providers or banks or whomever is providing such services. That's from one angle. From the other angle, how cryptocurrency can play a role actually in this alternative solutions, and will it impact or will be impacted, with such evolution in terms of alternative payment solutions?
For the first part in terms of customer centricity, I mean, it's already mentioned in the session for the open banking utilizing the API. So there's nothing, no one's who own the information. You don't know who owning the information. So this is, I don't know if this is answer your questions or. Yeah.
Thank you very much, panelists. Please put your hands together.
Thank you, thank you.
Thank you.
Thank you.
Thank you very much. All right. We will now move on to our next panel discussion. The legal profession is changing at a rapid rate, with technological advances and globalization having an impact on how lawyers work and interact with one another. Time to have an open discussion about where we see the profession going in the next decade or so. So let us call upon our panelists. Advocate Kanchan Talreja, Senior Counsel for Advocate Kanchan Talreja and Associates. Welcome. Can we get one more chair, please, for the panel? Hotel. Please, if we can get one more chair. Thank you. Next, we have Hannah Beko, Head of Mission, Legal Studio Solicitors. Welcome, Hannah. Mr. Mark Sea, Senior Partner for Denton's Roddick. Welcome, Mark. Virginie Tassin-Campanella, Founder and Managing Director for VTA Tassin. Welcome. Roar Thun-Wager, CEO and Founder Facilitator for Wager Negotiations Institute. Welcome. And last but not least, Mr. Franco Teich, Partner, Barandom Legal and Tax. Welcome. Last 10 minutes are for questions from the audience. Thank you.
Hello everyone. So we have got such a large panel for this topic that Mark and I are going to be co-moderating. I also thought it was fantastic that this topic obviously excited the interest of so many of us. So yes, to be able to keep all these rowdy lawyers in check, there are two of us moderating. So I'm going to come to each of them and ask them to introduce themselves. So Kanchan, I'm going to hand over to you.
Hi Hannah, good afternoon everyone. I'm Kanchan Talreja. Having practiced in the Supreme Court of India, various high courts and the trial courts in India, I have dealt with a lot of about 250 to 300 clients, and I'm proud to say we have been able to get 90% results in favor of our clients. I have singularly handled a lot of pro bono matters, and I am the legal head of the National Sports Club of India, which is based in Mumbai. I legally represent Inlax General Hospital, also based in Mumbai, and I'm the legal head and the trustee of Rashtriya Seva Samiti. Thank you. Over to you, Roar.
Thank you. My name is Roar, and it's very helpful that Katy Perry made a song about me. So that's it's made it much more easy to travel abroad. I am a reformed lawyer, I call myself. I've worked in the law industry for the last 20 years, but 5 years ago I established a negotiation institute where I do trainings in negotiation, mediation, and conflict resolution. So I do the foremost to help people stay outside the courtroom, but I'm very happy to be here back in the room with a lot of lawyers. So I hand it over to Mr. Franco.
Thank you, Roar. Hello, everybody. We are sitting here in finance, money, and law, and unfortunately I'm both. So I spent 30 years plus in focus on the financial industry next to health, medical industry and technology industry in various roles, be it on the C-level in different roles, on the board of directors level, be it as an attorney, independent advisor, be it as an entrepreneur with his own money in these industries, and finally as a professor at the interface between legal and business. Today, I'm partner of a Swiss law firm, business law firm in Zurich and Zug. I'm partner of a business advisory company, boutique in Zurich, and entrepreneur in different industries. Hand over to you, Virginie.
Thank you. Good afternoon, everyone. My name is Virginie Tassin-Campanella. I'm an attorney at law at the Paris Bar. I'm practicing also in Zurich as a foreign European lawyer. And I founded in 2016, so almost a bit more than 6 years ago, almost, my law firm, which is a public international law firm dedicating to international issues raised by sea and ocean activities. So it's any type of activities in the sea or concerning, for example, marine resources, which could be mineral or biological. So the range of activities and topics are quite fascinating. I'm working, for example, on deep sea mining, biological use, for example, for cosmetics or pharmaceuticals, cooperation, regional fisheries in conflict zone, ocean data. We're talking a lot about privacy of data. There's a lot of issues related to ocean data access and use. For example, the data that is collected from satellites for ocean modeling of the health of environment of the ocean, or could be used, for example, for mapping the seabed. So it's quite fascinating, and I'm very happy to be here and part of this panel. Mark?
Thank you. Good afternoon. So I am Mark, and as you can hear from the various panelists, that we have a very diverse and interesting panel with us. So what do I bring to the table? Well, I'm just a dispute resolution lawyer. Formally, I am the co-head of the commercial litigation practice in Singapore for Dentons. I also do a range of arbitration and mediation. But more than that, I'm really a problem solver. That's what dispute resolution is all about. And part of my job is keeping clients out of problems. So I'm in risk management as well. Over to you, Hannah.
Oh, thank you, Mark. Yes, my name's Hannah Becco. I'm a commercial property lawyer. I've been self-employed with my own legal business for about nearly 11 years now. Interestingly, it seems a lot of us had a shift in 2016, so I wonder what was happening that year. I had by then been running my business for sort of 3 or 4 years and hit a stage that many lawyers see in their careers of chronic stress and almost burnout. And actually, the lessons I learned at that time led me to create my training, coaching, and speaking organization in 2016. And so I've had thousands of lawyers, probably, had the privilege to train and coach thousands of lawyers over the last 6 years. And it really is a passion of mine. So I'm very passionate about mental health and well-being in the law, how we can change the culture, how we can stop so many people leaving the career that they trained for so long to join, and how they can be more authentic. And in fact, I am that person who brings their book everywhere with them. I wrote The Authentic Lawyer earlier this year, which has been 6 years in the creation and research. So those are sort of passions of mine alongside actually running my legal business. So we have lots of things to talk about, but I think before we get into questions, Mark, you had a little piece you were going to open us with.
Yeah, I thought that we would open up with a central theme. So here, really what we're going to talk about in this very broad area is how we can be better as lawyers, right? How can we better serve our clients? And how do we keep our profession sustainable? Hannah, you talked about the mental stress, the chronic stress that lawyers feel. And indeed, there's probably no better time than this to ask the question, what does the future of the legal profession hold for itself? How do we ensure sustainability, and how do we make sure that we will still be relevant and thriving in the next 10 years or so? We begin with the backdrop of geopolitical issues which are fairly seismic in nature, to say the least. We've got the Ukraine war, tensions between countries, a shifting of powers, strained relations between countries. And within the legal profession, we see numerous headwinds. We talked about the changing landscape, the intense regulatory environment that we now have to practice in, with increased scrutiny over cybersecurity, data protection, as we've talked about this morning during the panels. And at the same time, there are numerous challenges as the law changes. We see a renewed conversation about ESG, the environment, and how that conversation continues to mature will again affect us as practitioners, as the legal community. And how then do we stay on top of things and relevant to our clients? The legal profession has faced a difficult time during this pandemic as we emerge from it. We've seen the great resignation, as it's called, across the globe. In Singapore itself, 2022 saw a 30% year-on-year increase in lawyers leaving the profession. And you guessed it, it's the junior members of the bar. So that's where we stand. But it's all not doom and gloom. At the same time, we're on the cusp of a technological change. We're in the midst of a revolution. We heard about the changes in open banking just a minute ago. And the future is bright for lawyers. But what is our direction of travel? Where are we going from here? And that's the questions that we would like to talk about today and to hear from you as well.
Thank you, Mark. Yes, I was just thinking actually that for years I've tried to talk my own children out of becoming lawyers because of what I've seen the profession in, many of the reasons you talked about. But actually my nearly 13-year-old has decided now that he wants to become a lawyer, maybe because I own a firm and he thinks he's going to walk into it, but you know. But actually, just like Mark said, I think there's so many positives that actually I am now not trying to talk him out of it anymore, so that is very good. I'm going to come in a moment to Kanchan to start us off, but I thought I would throw out a quick question to the audience. Does anyone remember the 394th District Court of Texas and why it was in the news in February 2021? A video that did the rounds. No? Does anybody remember the phrase, "I'm not a cat, Judge"?
I'm not a cat.
No? If people have missed that video, please do give me a shout and I'll send you a link. But I think it was a nice moment where a lot of the legal profession across the globe came together and showed the world that we have a humorous side. I don't think it was so humorous for the poor man who was, representing his client in court in front of the judge.
I'm not sure if it's intentional either.
Well, no, I'm sure it wasn't intentional, and I think the poor man was absolutely mortified. But I think it goes to show partly some of the challenges we've all faced during the pandemic. So, Kanchan, I'm going to ask you to talk to us.
Some of the challenges from working from home, when your children are using the same device like you are. Fair enough. So we are dealing with a very vast subject, but I specialize in litigation. So most of my working hours are in court, and that is the subject I would really like to touch on. The last 3 years have been challenging with the COVID pandemic, which has led to a surge of online hearing. How successful was that? While the highest litigation and regulatory proceedings did very well, the lower trial courts faced a number of challenges, mainly due to lack of funds and the sheer size of the caseloads that they deal with. As a result of which, the trial courts were not successful at all for online hearing. However, clients did notice and were positive towards this change. It saved time, it saved money, and brought about results at home. So while we are aware that we are all headed towards online hearing, what I really feel is a blended approach would do well. In the next decade, lawyers will be faced with the challenge of working with machines. A lot of our jobs will be done by machines. However, there are several cases where personal appearance is a must. The pixels on the screen cannot replace the need of a judge to see the sweat on the brows of a defendant or a witness while giving his evidence. This is my view today. It is a must that lawyers keep themselves abreast with not only the amendments in law and the precedents, but also with the latest technology that help our field. The use of artificial intelligence while we are in courtroom arguing will help us bring about more effective resolutions and solutions, saving time, the court's time, as a result of which we will be able to deal with cases faster and better. Our main problem, access to justice, will be eradicated completely with the help of technology. Today, 46% of us have access to justice. What happens to the rest? Bringing online resolution will make justice accessible to all. That is how I feel about online hearing, a blended approach.
Thank you, Kanchan. And actually, I don't know if you're aware of this, but that leads us very smoothly into a question that I had for you, Virginie. Because I know when we were talking earlier this week, you were talking a lot about how people, I know you didn't phrase it access to justice, but you phrased it as in people don't always know when to come to a lawyer or when they should, or they don't come early enough. And what I'm thinking is, I think to go to your point, Kanchan, and as we were hearing about from one of the speakers earlier, the courts are obviously absolutely overrun at the moment. And so maybe if people came and took advice earlier, maybe things perhaps wouldn't get that far. So you're going to talk to us a little bit about sort of why and when people ought to come to lawyers in the future a bit earlier.
Yeah, I think it's a very good point. I will say specifically in my field, so I'm really in a niche, within the law, because I'm working in international law, and more specifically in public international law. So usually it's a field that is reserved for states. And this field has been actually, and is still only valued for dispute settlements. So, the part of the access to justice for state is very important. It's a very big concern. You have basically arbitration and what we call international dispute settlements before international courts. But international law at the beginning was designed to promote peace. That's the goal. That when we went out of the Second World War, we created international law to promote peace, to make sure there will be agreed minimum standards between all states. So for me, actually valuing these fields only through the scope of dispute settlement is really sad. We're missing the point. And basically, as a lawyer, I'm even more happy when states don't go to court, They can settle their dispute before, or even better, they will never have disputes. So that's, the dream states. So the advisory parts of this field, public international law, doesn't much exist. Actually, it's not well developed. And it's even less developed for the private sector, for NGOs and international organizations and regional organizations. But this advisory part is really crucial, because at the end we've created rules, in different forms, and we actually, lawyers or a judicial authority to make sure rules are implemented, not only defended, but also implemented. So being able to advise on the implementation of this law to any type of actors is really crucial. So we need to disconnect even lawyers themselves, but the general public need to be able to be more educated about the wide range of services and the use of lawyers in the society. And I have many examples that I can give, I'm working more, at the international level, so, with diplomacy, international organization. And it's not only the private sector, I will say lawyers between themselves, we don't know the fields of others, so we still have a lot to learn. Governments, for example, I remember my first meetings with ambassadors, they got scared that a lawyer were contacting them because they were believing that, they were threatened. So I had to say, no, I'm actually representing a client. So there's nothing related to dispute settlements. And then you have, for example, international organizations that believe that international lawyers only represent private interests, which is not true. But you have other international organizations believing that you only serve states, which is not true. So there's a lot of misunderstanding about, what lawyers do and how they could contribute, actually.
Yeah, I mean, it's true. The practice of law is a very broad one. And could you share, maybe in the next 10 years or so, as we talk about the purpose of lawyers, the role of lawyers, and the interaction between the different fields, how that interaction can be improved to avoid that misunderstanding? Where do you see the gaps, and how do you think we could fill them?
Well, I think there's two dimensions. There's the dimension within, I will say, the legal sector, so in between us, academics, practitioners, and all the ecosystem that is surrounding the legal industry. We need to understand what exists and how we can create an ecosystem that works in synergies, because most of services are complementary. They're not competing with each other, but we still have a way of looking at it as a competition. So I think there's a big problem here. And then more generally, I will say there's a problem also with ourselves, because, for example, lawyers practicing in law firms, they stay within law firms, We don't have an important impact in the society. So, for example, if we take big issues like sustainable development, and everyone is concerned with sustainable development. We all heard about sustainable development goals and issues related to sustainability. I never hear lawyers about how they could actually have an impact on this, but not within their law firm, not only for their clients, but just to contribute with their expertise to debates, public debates, or public opinions, or, journals, interviews. And I believe that the issue we have right now, especially with greenwashing, so it's something that I work a lot within the blue economy, what we talk about, it's also happening because no lawyers are speaking, because for us, greenwashing is nonsense. We have like a methodology to prevent it, but we never hear about this. So companies, when they are left alone with no advice, they don't know how to do with all the policies, they follow the policy without having a critical thinking, and they get into the trap. So I think being outside of the legal world and being more accessible and visible will be really important.
Yeah. Wow, I absolutely love that. And I think your main 2 points that I picked up there is competition. We have historically, as a profession, I think, seen ourselves as being in competition with one another. I see that changing already and continuing to change in the future. We can collaborate far more closely, as you've said. But also, yes, lawyers even themselves realizing that they could step out of just the small world that maybe they knew and into other areas where they could have a big impact as well and help. And I know someone I know who works in client relationship management, one common thing he hears from them is, I wish my lawyers were more human. So again, I'm going to come to Raw in a moment, but when I was stalking you on LinkedIn, Raw, I saw that recently you'd done a training on hardcore soft skills, and I love that. Hardcore soft skills. So can you tell us a little bit more about being more human and these skills?
I definitely will. I think that is one of the elements lawyers need to learn more about. And when we planned this, we talked about starting at the educational level and at the universities, and not depending on what law firm you start with it, and your partner's view on how lawyers should work. And back to what you said, Vivian, use us earlier. And we need to adapt to the person coming into the room. And the person coming into the room has often been in a conflict. And when they have been in a conflict, minor things could be huge. And we need to have a better understanding with the use of human skills why this is happening. So one of those elements, I believe, I used to say, humanity is the kill, is the key. And it's the key for us to adapt to the future, to be better lawyers. And better lawyers so the clients would come to us on an earlier stage. And I decided when I started my company not to use my title as a lawyer. And a lot of people were afraid, you know, a strange move, because that's such a traditional and well-established title. And I decided I wanted to be a facilitator. And I wanted to avoid some of the elements you met when they said, hey, why do you bring a lawyer into the room? I don't want to be the advisor they are afraid of. I want them to open. So back to your question, who am I? And be aware of my own assumptions and biases with the people I'm meeting. Maybe the client, maybe the other side. And I try not to use the word counterpart. I try to use the other side. Our ability to understand them. Where do they come from? Their perspectives. So challenging ourselves in the approach of our own clients and of the other party, I think that is a way of bridging more than building, what's the word? Walls between us. And part of that is also another concept I have created together with a psychologist. And we call that negotiations with the brain in mind. And brain in mind because the brain is influencing us whatever we think we are rational and logic. And I know when I make decisions, it's many of those decisions that are made on an emotional level. So for us to be more understanding of what the brain bring with us to the table, I think that's part of my answer to your question.
Thank you, Roar. I know you'd have so much more to share with us. In fact, all of the panel here have got a lot to share, so I would find them on the breaks and things to hear more. But Franco, I want to come to you next because Roar almost stole your thunder there, but not the exact words. Because on our Zoom meeting this week, you said something that stuck with me. You said, shaping of our profession must start in the universities. Tell us more.
Yes, because there the young people are educated and the young people are the future. So if we still teach our young lawyers or finance experts the way we have been taught, probably they are not fit and cannot cope with the new environment. So it must really start there. I come to that back right away. May I be a little bit more
please
provocative than you guys?
Please do.
Law is not enough. Finance is not enough. We are not in the middle of the world. We are not driving the world. Who is driving the world? It has been said so many times, the human beings. No one else, the human beings. And therefore, at least I have no legal issues. I have no financial issues. I'm happy. I have issues of life. I have issues of business. Whether this has a legal aspect, a psychological aspect, a financial aspect, a technical aspect, I couldn't care less as a client. I have an issue of my life. And I think here we have to change minds. And this starts in the university. Of course, where else? Where else? So we should focus on the needs of our clients, accepting that there are no legal issues. There are only issues of life. And for that, you need a counselor. Are there Italian-speaking people in here? There is a wonderful Italian word for it. It's called consigliere. Consigliere, you're laughing, you know it because you speak it. Yeah, you speak Italian, I have learned. Consigliere. Consigliere is the trusted advisor. Takes you by the hand. Takes you by the hand and go with you through the storm. That's what we're gonna be and have to be in the future, and this starts with university. Something else we never should, probably most of the lawyers and finance experts don't have it. Who is curious in that room here? Really curious, wants to know everything. Probably all of you, but some outside of this room not. We are on a way to lose to be curious. And if we lose that, we lose the, in my point of view, only advantage to what we heard this morning of artificial intelligence. AI can do everything. They can do everything in finance, they can do everything in law, but what they can't do is being curious. And, in my belief, also empathic. I know this lady in this morning said empathic, you can learn that as a machine. I'm not sure, but not curious. And a lawyer must be curious. He must find out what the issue of life is of that human being coming into the room. That's so important. And there we should start in university to learn that.
Oh, that's really so true. And, you know, I'm glad you mentioned curiosity. We started with I'm not a cat, so I see the link there. You know, Franco, you started really about talking about our universities, and as trite as it may sound, the young people, the young lawyers are our future. But for those of us in management, in law firms, and indeed for all of us as lawyers, and for those of us who are not lawyers, and are in the financial community or in society at large, there is a problem because the young people are leaving. And that really comes to the point that you raised, Hannah, which is about mental wellness, well-being. Are we looking after ourselves and the profession sufficiently? You know, the IBA published a report, one in 2021, about the well-being of lawyers, and the Young Lawyers Committee of the International Bar Association published one earlier this year. And the results are fairly disconcerting, to say the least. Apparently, 1/5 of the legal profession amongst the young lawyers, this is 40 and below, apologies and my condolences to anybody who doesn't fit in that category, well, they're going to leave. That's the indication given by the young lawyers today. And Hannah, you know, it's interesting that you talked about your daughter. In Singapore, just last week or the week before, the president of Our Law Society ran an article in the papers about lawyers and lawyers' children. And apparently, a lot more lawyers do not want their children to become lawyers this year compared to the last. So where's the trajectory for that, Hannah?
Oh my goodness. I spend hours training on this, so how am I going to fit this into 1 minute? Do you know, you referenced a few studies there, and when I started working in the mental health and wellness space for lawyers 6 years ago, I did so to help people like me at the time. I was 35, had the title partner, had the nice house, nice cars. My husband was a partner in a law firm as well. We had 2 healthy children. And yet I was chronically stressed and actually quite unhappy, which, you know, you look at life on paper and say, why on earth are you unhappy? And those are the people I thought I would have to help. But over the last few years, and this is frightening, the number of junior lawyers suffering with stress and mental health conditions has rocketed. And there was a study, the Junior Lawyers Division in the UK, I can't remember the exact percentage, but it was something like 17% said that in the 2 weeks before the survey, they'd considered suicide of junior lawyers. So we are doing something wrong, very wrong. We are getting better, I hope, and there's not just myself, there are many people working in this arena now to improve mental health for lawyers. And I'll be honest, yes, the junior lawyers have a part to play because mental health and well-being is always 50-50, the organisation that you work for and the individual themselves. But actually the real responsibility for me lies with the leaders. The partners that they work for, the example that they set, the team leaders that they work for. If they don't value their own mental health and well-being, if they don't value their own boundaries around their work and what time they finish and their weekends, their evenings and their holidays, then the juniors don't feel able to either. And yet we are facing a new generation of lawyers, as many of you have probably seen, where they do have very different boundaries to us older lawyers. They are saying, 6 o'clock, that's it, I've finished now for the day. And then unfortunately the senior lawyers are picking it all up because somebody needs to do it for the client. So we are seeing a really big generational shift, and it will be interesting to see how it pans out over the next few years. I don't know if any of the panel have got any thoughts.
Yeah, thank you, Anna. I think there's also a dimension that has been covered but not really addressed completely here is, to what I've seen in the new generation is also sometimes when they leave university or they enter the legal practice, they don't have much hope. But they don't have much hope also because they don't know what is possible. So again, and it's a personal example for me, my core specialization is law of the sea. Law of the sea is a very super special niche, among the niche of international law. And it's not being taught anymore at university. In most universities, it's not trendy. You do investment law, you do human rights, you do WTO, but law of the sea is a bit strange, it's a bit dusty. And basically, a lot of students, at university, they really enjoy this subject when they have the chance to take it. But they don't believe it's possible to practice in the field because there's no example. And so for me, when I had the chance, I have like a strange background because I was working at the UN before, and then I actually founded my law firm after, all of this. And I actually didn't want to listen, to people telling me it's impossible to work in these fields, because for me it was making no sense to actually believe that such a big field, such a huge ecosystem could not have any opportunities to offer, for clients, for companies, but not as a business model, to be of service to the companies who wants to operate activities and needs to be guided, basically. And so I think there's also hope to give, to students. And often the tip that I give is not to listen to people. Really listen to your guts, because, a lot of people repeat what they've heard without actually thinking or challenging, the status quo. And there's still a lot of innovation to do in the legal practice in terms of services, in terms of range of services, everything. And so if we believe that we're stuck in a model, I think it's the wrong way to evolve in the next years. I think we should really be curious, exactly, and embrace diversity and be able to challenge, the status quo and say, look, there's a gap here. Yeah. And actually, the myth of saying, like, you need to enter a big law firm to have, like, a nice business, it's a myth. Yeah. Because as a single practitioner, you can do really well, and you can have a lot of fun. And no, but it's true, and it's important to state it, it's not just the nightmare, it's also the satisfaction. You can have fun, you can discover things, you can work on topics you never dreamed you're going to work on. So it's really curiosity and innovation for me.
Panel, would you like to open to the audience in your last 9 minutes?
Oh, thank you.
You're welcome.
Franco, have you got a very quick point?
A very quick point, and adding what you were saying. The generation said, and why? This is the future. And all companies, be it a law firm or whatever, this will be one of the most challenges we have, because they completely tick differently. And if we do not move as employers, the set and why will not move. We have to adapt to them. Why? Because otherwise we don't have clients. Yeah. Because if we have no resources, we will have no clients.
And so my question then is, how do we bridge the gap? So based on the survey, 41% of the young lawyers can't even begin the conversation with bosses. They can't talk about mental wellness. So where do we go from here? Any thoughts?
I think many of them need social skills because I run an NGO together with my family called Sport for Understanding, where we train youths and children in communicating and learning basic conflict resolution skills. And we do exchanges across countries, and what we experience, they lack the ability to small talk. A simple skill of meeting what we do in this conference. they are not trained in it. They are very good on social media and online, but meeting you guys face to face, up here, out here in the hall, and talking, they are not trained in that. So we need to learn them basic communication skills. But that's, I think, part of what you imagine. You said, you know, we learn them imagination. And a lawyer need to learn to imagine it and to be creative. And that's part of the skills I think we need to focus on.
Yeah.
On a lighter note, I mean, they need basic communication skills. We need to give them a lot more coffee breaks. I think the learning will happen there.
You know, I never thought you'd have to train lawyers how to talk, but apparently so. You know, I just want to pick up very quickly Virginia's point about embracing diversity. Is there a challenge for women lawyers in particular?
Well, thank you, Mark, because as Mark and I were both just fighting there to speak, I don't know if you noticed who was going to go first. But yes, this is actually a topic that Kanchan mentioned to me earlier this week. I mean, it's close to my heart. Since 2018, I've been running various women in law groups. And I was actually going to say, I'm very pleased with our panel composition today. So congratulations to the organisers. I like to think it was planned and not an accident, but very pleased with our panel composition. But yes, there is clearly huge challenges in the legal profession still, with women joining and staying in the profession. In the UK, 54% of new entrants every year are women, and yet about 30% are partners, and I think it's 15% are equity partners. So there's clearly still a long way to go, I think, in the profession with regards to women.
I mean, that's visible from the audience. How many women lawyers do we have here? I mean, if you all can raise your hands. What, it's
kind.
About 15%, I believe so. So
yeah.
Right.
I'm sorry, Mark. I was about actually to ask a question to my female colleagues. I've experienced specific issues linked not only to the fact that I'm a female, but that I'm young. And so there's a problem of credibility as a woman when you're young. You're more respected if you're 50, 60. And this is, I think, a problem as well. It's not just, you know, basically the sex or gender. It's really the problem also of how you're perceived depending on your age. And I don't know if it's specific to women, but I felt it was more specific to women. And it's been for me something that I've been struggling with even now. I feel like I will be better, you know, at 60. I'm more successful.
Don't wish your life away, Virginie. No.
Let's meet again when you're 60.
Yeah. Yeah.
So, I mean, it does seem like we've got our work cut out for us. It's not just a question of women lawyers being involved, but now women partners, right? And how then do we ensure not just that there isn't a glass ceiling, but that as law firms we actively cultivate our women partners so that we bring out the best, right? And fully leverage on talent. I think that seems to be the key. When we talk about being better lawyers, better law firms in the service of our clients. Now, we've covered quite a range of topics today. We've got just 4 minutes left. We would like to open the floor to some questions, and I see hands going up.
Go to the microphone, don't forget.
So you have to go to the mic.
Hi. My question is relating the last of what you just spoke about women and mental health. And I know a lot of organizations. One of my closest friends, he had a heart attack at the age of 28. And he was working on a firm, in a law firm in India. And now he's having trouble finding a job because other organizations are saying, oh, you're already at risk and we don't want to put you in a stressful situation. And I know this is true of mental health also. When you open up and you honestly say that, you know, I do suffer from this and this, organizations tend to shy away. So my question is, how can organizations better equip themselves to be more sensitive to these issues?
Well, that's a great question. Raw, Franco?
May I start with a short story from a friend of mine, partner in a law firm, and his quote was, we value your service, the way you are perceived by how much money or how much income it is. And if money, income, is the key value in this, that's why maybe part of the reason 60% of lawyers are divorced and see less to their children. So what kind of value, where is the goal for a success? And I think individually we need to ask ourselves, when will I be happy? And what kind of work will I do when I'm happy? Do I need to earn X or Y? And can I do different things? I think that's part of it, but as long as the industry is pointing toward value of money, I think this is a huge challenge, and that's why your friend have difficulty coming back.
If I may add, let's look at the Z generation. They have already solved it. I mean, the two of us are the old white men. They have already solved it. They would not do that anymore. No way. They want to have a purpose. They want to have a purpose of the company, and they have their own purpose. Then they will match it. If it doesn't match, they will not work for you. And they will not make partner. They don't want, even if you want them. So that's the issue you have now as a partnership. What do I do with them? You have to move as a partnership. They will not move. So, partner that only work project-wise? Terrible. It will come. It will come. Partner that work only part-time. I know this already exists, but it will come to a much broader extent. And there, with the set, there is no issue between female or male anymore. They want the same. So we have to ask the set generation, what do you want? How can I bring you in the business, in the lawyer business, in the financial business? When would you come? When what would be given? That's the only way, in my point of view.
Yeah. Maybe we've got time for one more question.
Actually, we are out of time.
No, we haven't.
We have 40 seconds. Would you like to add another answer to this question?
Well, yes, my thoughts were to the question of does this person tell their potential employers? Very difficult decision, and I know that. My preference for people I'm supporting would always be yes, find the places where you can be honest. The level of the honesty is up to you, but certainly with the employer, both employed and self-employed team that we have, we always want to know where they need our support so that we can give it. So I think hopefully everyone will be able to find the right homes for themselves, because there's the argument that mental health affects 1 in 4 of us. It affects 1 in 1 of us. We all have mental health, just like we all have physical health, and we all need to look after it.
Well, it seems that we've pretty much run out of time, but for my part, I would just like to really thank everyone for listening. We've covered, again, quite a bit of ground, and maybe just to pull the strands together very quickly. We talked about the challenges that we faced, the online justice, and whether that is really going to come to fruition. And then we really talked about the role and the purpose that we have as a legal community. Virginia shared a little bit more about how we need to interact more and understand each other and understand the business as well as the roles that each of us play, and to focus not on differences but on synergies. We don't just see each other as counterparts, right, but as the other side. And it does seem, right, that above all, us being humans fundamentally, and lawyers are human, that is absolutely key. That is absolutely key. And I think only with that perspective can we look after the next generation of lawyers and future leaders, the young, and all of us as we progress through the profession, because it's tough, right? And mental health issues, well, they are always at the forefront. And I think, and what I gather, from hearing various ones on this panel, is that if we are to forge forward as a profession, to stay relevant and on top of things, then we need to look after ourselves as lawyers. We need to ensure that we are sustainable, and that then puts us in the position to continue to do well.
Fantastic.
Well, thank you very much for your
Thank
time.
you very much for
good
sharing
panel.
your personal experiences with us. Thank you, panelists.
Thank you.
Thank you, moderator. I believe Consigliere was also in The Godfather, yes? Yeah, wasn't it? Thank you, Mrs. All right, get ready for a fireside chat where the speakers will be talking about the importance of having a robust intellectual property strategy and how to protect yourselves against infringement by competitors. They'll also discuss what to do if someone infringes on your IP rights, including when it's worth suing or when it makes more sense to just settle out of court. All right, the speakers for this fireside chat: Mr. Yong Boon Oi, Managing Director at Exi Intellectual Property. Welcome back, sir. Shaina Jones Magrone, Founder and Managing Attorney for Artisan Law. Hello. And Vaishvi Khare, Director at Vindhyas Solicitors and Associates. So you will have 35 minutes and the last 5-10 minutes for questions from the audience. Thank you.
Well, good afternoon, everyone. Thank you all for joining us today. You know, I'm such a loud person, I can't believe that you couldn't hear me. So good afternoon, everyone. We want to thank you so much for joining us here today. As you know, my name is Shaina Jones Magrone. I am the founder and managing attorney of Artisan Law, based in New York City. So happy to be here in this lovely city of Dubai. You know, we really want to, I think we should all introduce ourselves, but we really want to do something different and have a real chat discussion with you. Because intellectual property, to the extent that you know about it, can be very amorphous, right? We want to make sure you understand some basics as we go into our topic. So, you know, if we could all just introduce ourselves so that everyone is familiar with who we are. So.
Okay. Hello, everyone. I'm Vaishvi Khare and a director at Vidyas Solicitors and Associates. So we are currently based in Mumbai, India, and we deal in the matters related to corporate law, media and entertainment, data privacy, and IP.
Hi. My name is Yong Boon. I'm from Malaysia. So we primarily specialize intellectual property in Malaysia and Singapore. So as he mentioned, intellectual property is a topic of discussion for a while now, to be very honest. Even in Malaysia by itself, the law has been established for almost 50 to 60 years. But the issue is, until today, intellectual property law is still a wide topic of discussion up to today.
So my law firm works in a couple of sectors. We work in intellectual property and business law, as well as in estate planning, helping with brand protection as well as asset protection. And I would love for us as a panel to really just set the tone for understanding what we're talking about when we're dealing with intellectual property. You know, we're really dealing with three major areas, you know, patents, copyright, as well as trademark. And when you think about brand protection, you often think about that trademark portion of it. That's what often comes to mind. It does, however, encompass all of that. And of course, there's trade dress as well. So I wonder if my esteemed colleagues can just talk a little bit about, you know, how you work with your clients in those major areas and what you see with them in those areas.
Well, we have a lot of clients in our firm. Primarily, they are SMEs, right? They are like startups, so on and so forth. So, in a lot of them, even law firms, to be very honest, when you want to start a business, typically you either get yourself registered with the, what they call company commissions, or even law firm, you get yourself registered with the bar council, so on and so forth. But people don't remember. When you do business, people know your brand as the business. People do not know your company as a business. So that's why, for example, a brand name, essentially we call it trademark. That's why the term trademark. It's a trading brands for you to be in the market. So essentially, a lot of times we have a lot of like startup, SMEs, so on and so forth. Whenever they come to us, they will always ask us this question: why? Why do we want to file for a trademark? Why do we want to spend this kind of money? Might as well I spend that money on marketing. Might as well I spend that money to do some investment to grow my business. So the issue in hand, people do not understand the importance of brand name. For example, about 6 to 7 years ago, I'm not sure whether you heard of this, Chanel. Chanel is a huge brand, right? Chanel is a huge brand, right? Ladies, I'm sure you know the brand Chanel, right? So what happened was, Chanel wanted to enter into Indonesian market, right? So they have a contract with a very well-established, a mall, a very well-established mall in Indonesia. So what happened was when Chanel wanted to enter into Indonesian market, the attorney over there made one mistake. They got the company registered in Indonesia, but they did not get their brand registered in Indonesia. So what happened was, Chanel, obviously being a big brand, they wanted to sue. Right, they wanted to sue the IP squatters. Someone actually filed for that trademark in Indonesia. However, the problem is, Chanel has an existing contract with the mall. So time is of the essence, right? Chanel don't have a choice. They settle out of court for about almost 10 million US dollar, right? So the thing is, brand protection is something that a lot of business owners today, right, is never something that they will put it as a forefront, as something that they will spend money on at the onset.
I think Young Boon makes a great point. I mean, several great points. You know, one of the foundational things that I know we each have to deal with our clients is making sure that they even have taken the steps for registration, whether it's trademark, copyright, patent. You know, patent folks can tend to be really quick to get to the office. But our trademark and copyright clients can be a little bit slow, right? Dealing with whether or not they want to make that investment, or even understanding how important it is to them, both for the registration with the office as well as their domain name registration and what the issues can come about with that. What have you seen?
You guys are absolutely correct. We have a client from a startup background, music label, production houses. So there are so many people who actually understand why we should, register our IPs. And there are some clients who do not understand, like, what is the importance of, registering your trademark, even your copyright work, etc. So we really suggest our clients to, register your IP so that you can protect your brand's identity and reputation of your company, which is really important because it takes 20 or more years to build your reputation or goodwill of your company, and it will just take 5 minutes to ruin it.
It's an excellent point. You know, in the United States, we have a very well ingrained history of intellectual property rights as well as intellectual property protection. Copyright as well as patent rights are built into our Constitution. We have congressional acts to address trademark. But even with that, it can still be a difficult undertaking in order to get your clients to move forward. And then once you do get them to move forward and you register, you have the all-important task of having them understand the importance of monitoring their brand for infringement. Many of you may not know this, but the onus is really upon the brand holder to do all of the work from monitoring whether or not their brand has been infringed upon. And it kind of makes sense, doesn't it? You know, you own it, you protect it. So I wonder if we could talk about some of the stories that we've seen, infringement cases maybe you've seen, lessons you've given to your clients.
Well, my client always asks me this question. I spend so much money paying your firm. we have gotten the trademark registered, we have gotten the IP registered. Why is someone else infringing my mark? So that is something very, very commonly asked. I'm not sure whether your client asks you that question, but I always get that question. They'll be like, I already got it registered. Why is someone else using it? So the thing is, as mentioned, you own the brand, right? You own the brand. It's your duty of care to get it actually properly maintained, properly watched, and monitor to make sure whether any third party actually infringe on your rights. It's like owning your house, right? I'm not sure about other countries, but in Malaysia, we like to build fences, right? We like to build fences so that people don't just randomly walk into our houses, right? So it's like owning a house, right? If you protect it, it's your job to make sure people don't trespass, right? You cannot be expecting once you get it filed, it stops there. And the best example is always the digital space, right? With the current era, the digital space is huge, right? It's basically borderless, right? So sometimes imagine this, right? You are, for example, a UAE company, right? You own a brand, you get it registered. But the moment you go online, the moment you put your business online, cross-border happen. When cross-border happen, how do you get yourself protected? How do you stop a third party from infringing? It's a tough question. It's a tough strategy. It's very, very hard. It's very, very costly for you to actually get your brand protected everywhere. But the thing is this, once you go online, once you go into the digital space, it's your job as well to basically find a strategy to get yourself protected and make sure people don't come into your house.
So there are so many clients who will obviously register the trademark, and then they do not want any services like, for a watch services, journals, watch services. And there was one client who actually copied the whole trademark and then asked me why people are coming after me and all that. So I always suggest that you should always seek a consultation from a lawyer, not from a CA or something who do not have the knowledge over the legalities and everything.
So my law firm works very heavily with clients in the fields of cosmetics, fashion, and tech. And when companies come to me, they will come to me in the startup phase, but oftentimes I will also have clients for whom I do an IP audit for. And I'm going to say that at both stages, I will see some of the same things, right? There's generally a lack of strategy. If they have filed, where are they going to look to do their protection? Who's going to do their monitoring? And what's going to be the budget in order to do that? So for any of you who have clients, I think a lot of this talk is about how can we also help our colleagues to understand how to identify these issues for their clients, either refer them to other counsel or just give them some words of wisdom about how to move forward. So you really need to address your clients and talk with them about what's going to be the budget. How robust can they be with their monitoring? Who's going to be in charge of looking at what the standards are of how their brands are addressed in the online sphere? Who's going to make sure that their handles are properly protected and properly maintained in the international sphere? And if they are going to be international, as Young Boon said, who's going to be in charge of that monitoring overseas, making sure that they are appropriately registered with whatever international protocol they may be addressing in whatever part of the world they are? It's important to take the time to make sure that your clients are properly counseled and moving forward in that direction, because for many companies, intellectual property is the largest portion of their revenue. It's the most important part of their business. I know in the United States, IP is one of the highest, if not the highest, product that we export. It's extremely important in the national and international sphere. So I wonder if you all could talk about any any horror stories you may have seen, or how you help the client to move out of a horror story that you've seen. I know we've all got some, guys.
We have client, that we actually do not look into the litigation sector, but yeah, we have clients who actually copy the trademark and come to us related to it. Yeah. So.
Well, a horror story. Definitely we have horror story when we're in the legal industry, you see. Right. So, for example, in Malaysia, we have about 70% of our population are majority Muslim. 70% of them are Muslim, right, in Malaysia. So, for those Muslim society, what happened is they are very in Malaysian market example, they are very keen in terms of certain level of cosmetic products, right? So the thing is, when it comes to all these different cosmetic products in Malaysia, right? Their price point are typically very, very cheap. For example, it can be as low as $10 to $15. So a lot of time they actually use their brand to sell, right? So because of that, their sales in a month can go up to $1 million. So imagine how much transaction it actually goes on. So because of that, in Malaysia, very, very commonly for this industry, there are a lot of IP squatters. So a lot of those not honest traders, what will happen is they will typically go and file for all these trademarks, and then after they reproduce all these cosmetic products. I'm sure in other countries, even in Malaysia, OEM for cosmetic products are very, very common, right? So what happened is they will OEM all these products, and then they start selling at a much more cheaper rate, and of course the quality is much more worse than the original product. So we conduct a lot of raiding cases with the Ministry of Domestic Trade. We conduct like private raids or even private investigations, so on and so forth. So when we do all this raiding or even private investigations, so on and so forth, you'll be surprised the amount of violence that this infringer actually put forth when the raids actually happen. So protecting IPs is not about protecting it as well. It's about to protect your business, because IP is your business. So business owner need to understand that without your brand, without your IPs, you don't have a business.
Also, in today's world, we all know everything is digital right now. So there are so many people who actually build a similar websites. They do cyber squatting, they do typo squatting, they'll claim your URLs, similar URLs, they'll do, there's so many different brand abuses such as counterfeit products. They'll make exactly your product with your exactly logo. There is so much piracy in the copyright sector as well.
And so I think when we see clients and clients see individuals abusing their rights, abusing their marks, one of the main things that I know I have to, and I know my colleagues do as well, we have to counsel our clients on when it makes sense to go forward and what it makes sense to do, right? So if you are not aware, IP litigation in general is often going to be a very expensive affair. And so clients have to really have an understanding as to whether or not they have the stomach to go all of the way. So oftentimes addressing an infringement can really be a step-by-step process to see how far your client can go. I know oftentimes for my clients, we'll start with an infringement letter to someone. You know, it's a scary letter you send out to someone, you say, you're using my stuff, don't use it anymore, otherwise we're going to court. And oftentimes that will be enough to scare somebody away. Because what you may not know is that most infringers are never confronted about the process. But then once they are confronted, they know they're seen, they often understand what the consequences may be, and that may be enough to push someone off. Then after infringement, you may have to go further and then further move into the litigation space. But I wonder if my colleagues could talk about some of the steps that they take in working with their clients in addressing a potential infringement or an actual infringement.
Well, to be very honest, if I may add on, typically sending a cease and desist, a warning letter to the infringer are something very common. But a lot of time, clients or even business owners, they don't understand one thing. If the infringer, they have the firepower in terms of money to go through the litigation process with you, they may actually destroy your brand. They may actually take your brands away. So the thing is, it depends on country to country basis, right? Certain country, they follow first to use system. Certain countries, they follow first to file system. So it really, really depends case to case basis. We do have clients, they are in a certain jurisdiction whereby first to file system. But in Malaysia itself, they are the first to use, right? So in Malaysia, we follow first to use system, right? I think in US, you follow first to file, right? Or first to use?
It depends upon,
okay.
It depends.
Yeah. So it really depends on countries to countries basis. So our clients, right, they have their mark registered in Malaysia. They spend a lot of money in filing them, what they call, in promoting their brands and get a very good valuation and goodwill eventually. However, when they want to enter into another market, when they enter into a first to file system market, some of them, they don't even file it first. Some of them, they actually use it first before they file. So this is something that the client need to understand, which jurisdiction you enter, so on and so forth. Even so, sometimes it's not about, we have to understand one thing. As a business owner, what you want is you want worry-free, right? What you want is when you enter into market, you don't want to have any problems. You don't want to have any issues. You don't want to consider, can I enter into this market? Can I not enter into this market? So that's something very, very important for us to consult our client and ask our clients, what's your strategy? What's your export strategy? What do you plan to expand your business, or do you plan to stay within the local market?
So for me, I always suggest my client to settle out of court because it is obviously much more cheaper than litigation. Litigation will always drain the clients. But obviously, as you said, it depends on case to case. If you are a prior user, so in India, we also follow the first to use basics. So yeah, if you are a prior user, then you can obviously go and, sue the client if you have an upper hand over that matter. But yeah, it's much more better and efficient way to settle the matter out of the court.
So I agree with Vashvi. I find that it works better for the clients to settle out of court. I find that for many matters. I have been, prior to becoming an IP and estate planning attorney, I was a trial attorney for the first part of my career. And I think one of the best things that I received in that training was an understanding of how to spot issues that are going to bring you into litigation and then how to try to walk you back or provide the protection in advance. And what I often find for clients is that trying to find a settlement out of court is often going to do the most for them in terms of their peace of mind, in terms of their pocketbook, and also in terms of coming to an understanding of really what the importance is of having that strategy in advance, right? It's really a lesson in understanding how to proactively move your brand and your company forward. Once you have a situation where you've dealt with an infringer one time, you do things much differently from a corporate and a brand perspective. And so I wonder, for my colleagues, before we get into some Q&A, hopefully you guys have some great questions, if there are any, specific strategy points that you give to clients, that you often find yourselves giving the clients over and over, that you think helps them move forward?
Well, I always, whenever a client comes to me, other than advising them in terms of the protection in the local jurisdiction, obviously, I always ask them, what's your next strategy? Do you plan to export? Why do I always ask that? Because there are certain jurisdictions that very, very commonly that I tell my client to look into. For example, Indonesia, Australia, even China. Those jurisdictions are a very common jurisdiction where IP squatters actually exist. For example, I'm not sure, have you all been to Australia? If you actually been to Australia, you will never actually see Burger King in Australia. So in Australia, Burger King is actually called Hungry Jack, right? So why? IP squatters issue, right? So it just doesn't make sense for Burger King to settle it or even buy the IP over. So very often I ask my client this question, what's your export strategy? So in order, once we know the export strategy, there are a few methods in doing it. For example, there's some international protocol, we call it the merit protocol, right? We can go through that for a cheaper option for our client, right? Or we can go through a conventional method whereby we file it in different jurisdictions to help our client to protect their rights. So very, very often, I always ask my client this question, what is your strategy? Do you have an export plan? Do you have an export strategy other than the local market?
Okay, so in my opinion, everyone should, firstly, everyone should register all their IPs, as it is a great asset to your company. And also hire a professional who will guide you and who will monitor and protect the brand's identity and reputation of your firm and the company, as it will obviously prevent the loss of consumer trust and losses, and it will obviously safeguard your name and the reputation of your firm. So yeah, I think you should obviously take the advice from a professional who will give you in a more better way. So, yeah.
And I will just add on to what my colleague said, particularly Vashvi, in terms of the registration. So in the United States, particularly for trademark, you do actually have to use the mark in order to receive the rights. We have a system where you can actually file as a mark holder where you are actually in use. We also have an intent to use system, right, where you can indicate that I do intend to use this, I do intend to put it into the marketplace, I'm not quite there yet, but I want to protect those rights. And so part of the strategy is looking at what your marks are, what you're going to use them for, and then you can plan out at what time it makes sense in order to go forward with that protection and that use, right? It is important, of course, to look at what your export strategy is if you actually do have one, right? So you can plan out what of the protocols you want to use. There are various regions around the world that have, we call them protocols. They have cooperation systems for trademark registration. The Madrid Protocol being the largest international body for the registration of trademark across the world, right? Affecting many of the European countries. There are also some localized protocols. There are those in certain areas of Africa, certain regions of Africa, certain regions in Asia. And then there are some also additional individualized protocols across various states that may not participate in others. But you, of course, have to look at what you're going to be doing in the future so you can have that plan for when it makes sense to do what. If your name is already taken someplace, and if you need some form of a coexistence agreement, or if you just have to register as something else, right? So I want to give my colleagues the opportunity to give, any closing thoughts they may have, and of course, take some of your questions.
Yeah. The one statement that I always tell my client would be, protect your brand is not because you want the protection. Protect your brand for your business.
That's true, actually. Protect your brand. Obviously, register all your IPs again. that is that is the one of the most and important asset for your company. That's true.
So I would say that, brand protection is really about peace of mind. It's about making sure that all of the hard work, effort, resources that you've put into building what you're building is really going to be there for you when you need it the most. IP protection will give you that. So with that being said, we'd love to answer any questions that you all may have.
You said that it's good to settle out of court. My question to you would be, when do you advise that it's worth the fight?
When do you advise what, I'm sorry?
That you should fight. Because we do talk about brand protection, trademark protection and everything. But when would you say that you should fight to protect, and what format of fight would you recommend?
Well, to be very honest, it's a business decision whether you choose to fight for your brand or not. Because ultimately, when you go for a litigation process, it's very, very costly, right? Sometimes when you were to decide to expand your business, you only have a limited amount of fund, right? So you have to make a decision. With that fund in place, do you have enough fund to fight for your brand? Or do you want to use that fund to actually build that business in that particular jurisdiction? So we cannot advise our client when to fight or when not to fight. I mean, let's be honest. Anyone on the floor as lawyers, we will definitely ask our clients to fight. That's where our fee comes, right? But the thing is, we are not in that position to advise our client whether to fight or not. Why? Because ultimately, it's a business decision.
I think some of the things that, you can look at in making a determination about whether to go to litigation over your IP is, how deeply entrenched are you in the market? How much capital have you expended in order to build that brand? Have you gone into production already? Are you already in markets, right? Are you already registered in one class? So for example, in the United States and abroad, right, you have to actually register your trademark in a particular class. You have to show that you're using it for this particular thing. So are you deeply entrenched in that class? Is it a class that you're really, really, really trying to move into? Or can you really step back and move on to something else, right? A lot of this, I'm going to say, can be alleviated in the filing process. I really do think it's so important to stress to your clients that, doing that work on the front end is often going to save you a lot of heartache on the back end. So have you worked with someone to do a very comprehensive search to see what's already going on in the landscape with your potential brand, right? So you cut off litigation at the pass. All right. Anyone else? Anyone else?
Thank you. Sorry, regarding the last point that you just mentioned, protecting the trademark or whatsoever, it depends actually on the category actually you are, registering or filing, starting from the search till the end actually of the protection. So the question here, sometimes non-registering in certain classes may create a confusion if somebody else steps in and use that brand in different category. So what's your advice for that based on what you just mentioned? And if there is a previous use actually of certain trademark without registration, to which extent that will help in protecting the trademark if somebody else steps in and register that before the original owner, register it? Thank you.
That's a great question. So, there's a couple of things. I think one of the most amazing things about the trademark system, and particularly the trademark system in the US, is that simply because you're registered in one class doesn't mean that you're precluded from registering that same brand in another, right? I don't know if you've ever heard the phrase that there is nothing new under the sun. But the truth of the matter is that many of the thoughts and ideas that we may have for a brand name, someone has likely thought about it before, and they may have used it in a different context. So simply because someone is registered in one class doesn't necessarily preclude you. You may have an issue depending upon perhaps how closely related those classes or categories are about moving forward, but there are persuasive arguments that can be made. So there's a cost-benefit analysis of looking at if you have a brand, or you're looking to register a brand that someone is already using in another class, how closely related is it? What are the arguments that you can make to differentiate yourself from that other brand? And also, even before going forward, you have to make a strategic decision as to whether or not you want to engage the other party to perhaps engage in a coexistence agreement. All of those are strategic decisions. Now, as to the second part of your question, you know, you have to, or a client has to make the decision fairly early on about what it's going to be worth to fight for that particular brand. What does it really mean to them, right? We have in the US what's called common law trademark rights. So, of course, we are a system where you need to use it and you need to file for it in order to get that high level of federal protection. But there are also people who never file, and these people may find a brand that's already using their mark and they've filed with the office. They may still have some common law rights. That's going to be a particular case in the US where you may have to engage in a coexistence agreement. Often that common law mark will have its rights in its particular region, often its particular state, and that federally registered mark that may have come later will have rights across the rest of the country.
The World Intellectual Property Organization, they have basically divided trademark applications into 45 different classes. In particular, class 1 to 34 is for products, 35 to 45 is for services. Example, class 20 is for furniture, class 1 is for chemical products, so on and so forth. So one of the key areas business owner, even applicants need to understand that when you file for a trademark, it's very important for us to identify the classes that you are in, right? So if you want to monopolize the whole industry, it will never happen. It will never ever happen. In Malaysia, many years ago, I think about 10 years ago, there was a case between McDonald's and McCurry, right? So McDonald's basically sued this Malay restaurant called McCurry, McCurry. So what happened was McDonald's actually lost the case. So McDonald's being such a big corporation, obviously they will file for all 45 different classes. However, there are a lot of people, they ask the same question. McDonald's, they are restaurants, they are in the food industry. So obviously they'll be the same, they will file in the same class as McCurry as well, being a Malay serving restaurant. However, McDonald's actually lost the case. Why McDonald's lost the case? The court decision was McDonald's primarily, their target audience are people who dine in for fast food. They will go to McDonald's for fries, they will go to McDonald's for burgers. However, for McCurry, their target audience are very, very different. Their target audience are audiences that go in there to have curry dishes, to have rice. So even you were to try to protect yourself in various classes, so on and so forth. Every single brand, every single industry, you have a distinction point in your business. So ultimately, the important part would be getting the right attorney, getting the right IP lawyer to help you when time matters.
I think that's why comprehensive search is very important, but people don't get it. They just go and just register themselves or, through a lawyer.
Thank you.
All right, we want to thank you all so much for your time. It's been a pleasure speaking with you today.
Thank you, everyone. Enjoy your evening.
Thank you very much, panelists. That was a fantastic synergy amongst you. Thank you. All right, ladies and gentlemen, it's recognition time. I would like to welcome on stage Mr. James Cummings, founder of Kijana Educational Empowerment Initiative, to present the awards to the outstanding leaders that have gone beyond. Mr. Cummings, welcome. Okay, I'll just wait a few minutes. So those receiving an award, if you would like to say a few words, please feel free to do so. I'll just get the microphone. Thank you. Fantastic. All right, Mr. Cummings, ready? Shall we commence? All right. Our first awardee goes to Mr. Mohammed Al-Qasim. Congratulations, Mohammed. We can take a picture in the center of the Congratulations, Mohammed. Thank you. Our next awardee is Aliyah Alzira. Just stairs right now. There's closer stairs. Welcome, Aliyah. Congratulations. The job well done. Thank you, Aliyah. Our next award is for Surav Ghosh. A few words, Mr. Suraj. Okay, all right. All right, thank you. He is accepting on behalf of Mr. Ghosh. Fantastic. All right, our next awardee is Shaista Sarki. Welcome, Ms. Shaista.
Hello, thank you so much. It has been 21 years into academia, founder of 2 law schools. I give this credit to my chancellors who had faith in me. Trust me, the key to success is empowering. That is it. They empowered me and I empowered my team. And hence this award. Thank you so very much.
Okay, our next awardee is Mr. Ionis Giannakakis. Welcome, sir.
much. This is definitely one of the highlights of my career, spanning more than 30 years already. And this award is dedicated to my team. Thank you very much.
Next, we have an award for Mr. Stephen Ranger. Congratulations.
Thank you for that. My great pleasure and honour to receive this award. I'd just like to say a couple of quick thank yous. Firstly to Mr. Hussain Luta, the chairman and founder of our law firm, my dearest brother, I'm very close to. Obviously family and friends who supported me over 51 years of working. The lady is talking about 21 years. It's a long time, of course. And to customers, to staff, who've tolerated my often aggressive behaviour, but hopefully for their betterment. And finally, I'd like to say thank you to the Dubai Ruler's Office that have always supported the many initiatives that I've put forward over the 20 years I've been here in Dubai, and encouraged and listened and changed, which in this world of suspect leadership, let me say that, quite amazing that we have a ruler and a ruler's office that listens and makes changes when it's appropriate. Thank you.
Thank you, Mr. Ranger, for your words. Our next award is for Miss Iman Ali. Welcome back, Miss Iman.
I think all I'd like to say is that the credibility that this award brings with it, use it to stand up for somebody who can't stand up for themselves. But in the process, don't forget to stand up for yourself first.
Well said, Miss Iman. Thank you. Very true. Our next awardee is Vaishvi Khare. Welcome back, Vaishvi.
Ladies and gentlemen, it is such an honor and privilege to accept this award here. Thank you, Law 2.0 conference, for giving me such wonderful opportunity to connect with everyone and learning the curve. And a special thanks to my family, who is always there to support me. And a special thanks to my husband, Pratik, who is obviously a great corporate lawyer as well. Thank you again for the award, and enjoy your evening, guys. Thank you.
Thank you, Ms. Vaishvi, for all your hard work and effort. Our next award will be for Nevin Jacob Kosny.
For this recognition that is given to me. I dedicate this to my team members, to the firm that I'm working with, United Trademark and Patent Services. It's an intellectual property law firm. For the trust that they have entrusted upon me. One advice that they have given me all the while that I was working there for the past 12 years is, be a leader, empower your team members. If you have to step up during the time of crisis, make sure you step up. But if you have to step down to empower your team members, do that. And that's the advice that I do even now, because for the last 3 days, 3 of my team members are on medical leave, but I step up. But the reason that I'm here is because of the team. So kudos to them, and thank you so much again for the recognition, and congratulations to all the other recipients.
Thank you very much. That was wonderful advice. What happened to the lights? I will turn on my... All right, our next award is for Mr. Ish Jain. Congratulations, Mr. Ish.
I think the first thanks goes to my father and my team members who have helped me reach where I am today. Also thanks to my mentors who have, in the last 15 years guided me on the right path. And thanks to Law 2.0, I mean, as arbitrators, generally we don't find a lot of award categories which recognize the work that arbitrators do. But considering the kind of wide range of participants over here and the wide range of backgrounds that each of the award recipients are from, shows the kind of recognition that has been given to people who normally would not be recognized for the extraordinary work that they do over here. So congratulations to all the award recipients over here as well. Thank you.
Thank you, Mr. Jain. Our next award will go to Ramazan Zorlu. Come on up.
Hello, thank you very much. It's a great honor to have such recognition. Actually, it belongs to my team in Sun Express Airlines legal team. Thanks to my team. And also congratulations to other participants and recognitions. Thank you very much. Yeah.
Thank you, Mr. Zorlu. Our next award will be going to Rawan Abdel Noor. Awards. And before last award will be for Hans-Peter Beisser. Okay, we will hold on to Mr. Hans-Peter's award. Not before last, I'm sorry. We have several more. Don't worry. Next up is an award for Prashant Shenoy. All right, we will hold on to Prashant's award as well. I would like to call up on stage Amira Ismail. Welcome, Amira. Congratulations.
Actually, today is the Kingdom of Bahrain National Day. So I'm dedicating this award to my beloved country and the Kings of Heart, King Hamad bin Isa Al Khalifa. Thank you very much.
Thank you, Amira. Miss Aliyah, are you sure you don't want to come back up and give us a few words that you missed out on? No? Mr. Mohammed? Yes? No? Okay. Trying again. Our next awardee is Vikram Dugal. Come on up, Vikram.
It's an extreme privilege and honor to receive this award here amongst all the esteemed members. I would like to dedicate this award to my team, my mentors, my family who's out here along with me. They have supported me through thick and thin. And one piece of advice which I would give to all is, what keeps me going is learning should never stop. I have been in the banking industry for the last 20 years. And what keeps me going is every day being a hustler, trying to solve new challenges and getting out of the comfort zone. So all the best, and I look forward to connecting with you all over the next couple of days. Thank you.
Thank you very much, Mr. Dugan. Our next awardee, please come up, Mr. Ratsnari Kara. Mrs. Ratsnari Kara. My apologies.
Good evening to everybody. Thank you so much for this award, and I'm so happy to be here amongst all eminent personalities. I just want to say a little bit about the work I do. I'm an investment advisor based out of Bangalore. 90% of my clients are women, and I'm right now growing my team to make sure we create a larger impact for women, empowering them to take financial ownership of their lives. I'm looking forward to meeting more people who want to create that impact. Please reach out to me if there's any way that you want to work with me. Thank you.
Thank you very much, Ms. Kara. Next up, we have an award for Mr. Salim Al-Kalbani. Welcome, Salim. Welcome back.
To receive such award. Many thanks to my family and my team who supported me to receive such award. And also I would like to thank the conference organizer team for organizing such event and give me an opportunity actually to meet a group of experts like you. Thank you.
Thank you, Mr. Salim. Next up, we have an award for Mr. Majid Al-Tunisi. Welcome.
I would
would like to thank God for his scouting blessings, as always. I'd like to thank my team, my mentors, and as a personal advice I would like to give for my young brother like me, always follow your dreams and never let anyone let you down or, or influence you otherwise. Thank you.
Thank you, Mr. Al-Tunisi. Next up is an award for Ahmed Al-Ben Saleh. I believe we will hold on to Mr. Ben Saleh's award. Okay, and last but not least, please join me on stage, our last recipient, Mr. Mamadou Touré. Welcome, sir.
I would like to thank everyone for this award. It's an honor and a pleasure. And, you know, like this quote from Newton said, you know, I could see thus far because I sat on the shoulders of giants. And along my path, I've had the chance to come across extraordinary people, extraordinary giants who believed in me, who believed in my dreams. And their names are, you know, Nelson Mandela, Graça Machel, President Obasanjo. But among some of those giants, there were others that are even bigger, but so much younger. You know, their names are Joshua, Yoliswa, Malaika, Menelik, Jelia. Those are my kids. And I want to dedicate this award to them for being very patient with me with all my absences and my hard work and my sleepless night, and for never stopping believing in me. I want to thank their mother also for their patience. And I want to thank my team who from the get-go have followed me in this crazy dream of a better world for humanity and shared prosperity through innovative finance. And without them, I wouldn't be where I am today. And this award is for them and for everyone who has made me who I am today through tough times and great times, and everyone who made my life more challenging, because as I did so, they helped me learn to become stronger and to overcome such challenges. This is just the beginning, and it's a very powerful and important milestone that I'm honored to welcome. Thank you very much.
Thank you, Mr. Touré. That was beautiful. And last but not least, a few words from Ms. Aliyah.
Hi, everyone. I would like to dedicate this award and the trophy, first of all, to my dad, to support me, to be tough and a lawyer, and to stand today with all these nice people here, and to my mom, of course, for supporting me, and for my kids, and for Bahrain. Today is our national day, and to King Hamad Isa Al Khalifa and his wife Sheikha Sibicha to support women, and for all the women around the world. Thank you.
Thank you very much, Aliyah. Thank you, Mr. Cummings, for joining me on stage and handing out the awards to our lovely recipients. Congratulations to all awardees for all your efforts and your hard work. We shall end the session today with our last fireside chat. The discussion will be, as we move into Web3, it will become easier for businesses to share and analyze user data and grow massively by harnessing the power of its decentralized network. Join our speakers as they give you a bird's eye view of how to leverage everything that Web3 has to offer. So please welcome on stage our speakers. We have 3 of them. I would like to call upon Ms. Corina Reibchen, co-founder and CEO of CryptoClue. Welcome, Corina. Next up, we have Mr. Wasim Jarkas, CEO of iBlockchain. And Mayur Podar, Director and Chief Business Officer for 3.0 Verse Limited. Welcome, Mayur. So we will have 3 microphones. Test. Okay, very good. Thank you. All right. Do you want to semicircle a bit to see each other? Of course. Yeah. Okay.
You can also skip the chairs if you want.
Up to you.
You can do it.
Please take some time for the questions.
Yeah, sure. Sorry. Okay, sure. Would this be fine?
Good. All right, the floor is yours. Okay. So we can start. Yeah.
Hey guys, myself Mayur Poddar. I'm the director of 3.0 Verse. We are a company based out of Dubai. As we all know that this industry has grown a lot in the past 5 years. And when you talk about Web 3.0, of course, the blockchain comes into picture. There are multiple offerings that has been there in the industry. Now, the biggest challenge for every user in this industry is that how to select a particular offering. How should I enter that offering? How should I eventually earn something out of that offering? Because today, every platform which is available in this market is all about what they want to offer. But collectively, as a marketplace, today we do not see any platform which actually offers you all the solution as a one-stop solution at one particular dashboard. So typically, when you transfer the funds from one individual wallet to another wallet, it requires a lot of gas fees. There's a lot of security challenges. All these things are into the picture. So what we are building as a technology is a single dashboard, single wallets, where you can execute multiple trades on multiple avenues that's offered in the Web 3.0. So you don't have to again and again hop in and hop out on multiple different offerings in the market. I'm sure the biggest question comes is the centralized versus decentralized, and I'm sure we have much more speakers who would be talking about what is centralized, how the centralized could be advantageous, how decentralized could be advantageous, and I'm sure we'll have a better fireside chat rather than just a normal one-way communication. Yeah.
Yes, hi, my name is Corina. I'm CEO and founder of CryptoClue. So we are providing global education in Web3, so everything regarding crypto, NFT, DeFi, decentralized autonomous organization, and much more. So it's for the mass market, and yes, I'm providing here the education part. We have an app for it. I will explain later more, and happy to be part of this fireside chat.
All right. Thank you, Corina. Thank you. My name is Wasim Jarkas. I am the CEO of iBlockchain. And as the name says, we are advocates of decentralization to the greatest extent possible that the solution and the technology can provide. Going back to the topic and to the introduction done by our colleague, I think for me, the topic and the title of the topic itself is a little bit paradoxical, so I'm going to play the devil's advocate role here to trigger some fire in the fireside chat. So Web3, the concept of Web3 is all about decentralization. It's the decentralized internet. That's the shortest definition of Web3 is. Web3 is decentralized internet. So it's all about taking the internet infrastructure and porting it into a totally decentralized infrastructure base and building applications in a decentralized manner, which are the D app, decentralized app, and run the whole ecosystem into a decentralized manner and pushing the power and the ownership of the data and all the associated privacy concerns to the end users and to the ownership and to be owned by the hands of the end users at the end of the time. So when we talk about having a central place or pushing all the offerings that Web3 can give and take it from one place where we can leverage or we can benefit from the offerings of Web3, in my opinion and my immediate understanding, again, it's paradoxical because it defies the concept of Web3 itself, which is all about decentralization. And if we actually push this into a doing some kind of centralization. So here is where my nuance or my counter argument on that specific topic.
Yeah, but that's also what the people requested. So they want to own the data. So this was the whole criticism, so that, that the central institutions own data privacy. So this is what the people requested, so that they have to own the data. But on the other hand, they need also to take the responsibility, because there is no middleman. There is no bank in between, so they can help. So the help is via Discord and decentralization. Yeah, and of course, I understand what you mean, so that we have some central exchanges and only it's decentralized, it's the original intention for Web3. So that's, of course, it's a conflict. But the people, requested that they have their own data, so that they own their data. But I think not everyone is, is clear that they have also to take the responsibility for it.
I think my friend Mr. Wasim actually said very right thing, that he wants to become on the devil's side today. So it's centralized versus decentralized. But the only problem with decentralized today is the liquidity is a big challenge. So as rightly said by Karina, that many people do not understand what is blockchain, how the blockchain actually functions, how the decentralized network actually functions. Today we see more than $110 billion daily volume on centralized exchange. We are trying to build decentralized exchange since last 2 years. Even Binance is trying, Coinbase is trying. The only challenge that they are facing is the liquidity. If there is no enough liquidity in the market, you actually cannot execute a trade. And that's where the biggest challenge of decentralized comes into picture. But yes, of course, when it comes to decentralized wallet system, I definitely second your thought, Mr. Wasim, that every user should have their own control of their private keys on decentralized wallet.
What I would add on that, I'm basically not trying to undermine the value of the offering, where basically you can create an aggregate marketplace where people can go in and really reap the benefits of what Web3 can offer. The only concern here is that we create more centralization while we're doing that. And the more we leverage that, the instance that we're creating is based more on decentralized principle, decentralized technology, decentralized infrastructure, we are serving the purpose what and why the Web3 has been created. Now, commenting on what you mentioned, and what Corina has mentioned also, which are the end users at the end of the time. The end user don't realize, I mean, especially this, I mean, we're talking about the layman users, not the techies and the experts. They don't know they are using decentralized or centralized, but they want a service at the end of the time. Whether they are using centralized or decentralized today and using the exchange services, they're not aware. They just want an exchange and they want to carry on the services that they want to carry. And with what you have explained, Mayur, is that rightly enough that by doing these cross-chain kind of things that you will be able to save fees and have more seamless experience for the end users. But as advocates of blockchain, decentralization, crypto to a certain extent, I think we bear the responsibility that we offer and we give the ownership to the end user through the decentralized system. And we don't need to make them aware whether they are using decentralized or using centralized, because they're not aware at the end of the time. But we as technologists, we have to keep advocating for such capabilities.
Yeah, and the solution should be easy, accessible, and understandable. So this is what we are trying to face now with our education, because right now it's very complicated also when you want to put your keys on the, your coins on a ledger or so. Then you have MetaMask, then you have this exchange. So the end users got very confused because it's very complex. And the normal users is not educated in technology. They don't know a lot about financing. They don't know a lot of crypto. So this is where we starting with this kind of education, that they have at least basic knowledge, and then also it's up to new startups and so to create some very user-friendly experiences for connecting everything, and so to make it very user-friendly, because otherwise we will lose the people.
So I would just like to add one more point on the decentralization part. When you talk about decentralization, the basic issue that a user faces today, you create a decentralized wallet. If you lose your key, your funds are at risk. So the whole responsiveness comes to the user. Now, as rightly said by Karina, that not every user is very well aware about how important that private key is, how important that public key is. In this situation, what is more important for all of us is to build an educational side of it, to make people understand, aware that blockchain or Web 3.0 is just not a speculative area. It is more to do with technology. It is more that every person today, somewhere or the other, is going to be impacted by this blockchain technology. So let's discuss what exactly is this blockchain. So when it started back 15 years back, nobody understood what is a ledger entry, what is hyperledger, and people started talking about blockchain. Till today, the use cases of blockchain has actually not come into picture. I think UAE is the first country I've heard that they have actually been transformed their national identity on blockchain. That's the added advantage of a country going on blockchain. So blockchain as a solution, I really appreciate that's going to be a future key. But when it comes to centralized and decentralized exchanges or centralized and decentralized application, it is still a lot of time for all of us to move to decentralized apps. That's what I really feel. Over to you.
Yeah, I tend to agree with the argument that decentralization is probably an end state that we should put in front of us as a target, but we cannot start from day one as decentralization. So the efforts of decentralization is a journey that probably has started with centralization. Now the efforts are going towards more distributing the architecture, and then at the end of the time maybe reach the target stage where the ecosystem is mature, the apps to make the user experience, as mentioned by Corina, are actually so user-friendly that it will mimic the centralization part of the user experience. And then also, as mentioned, that the end users are educated enough that they can have the ownership of the data, and they are responsible enough and educated enough to have actually the ownership of their data. However, having mentioned that, I think we should not lose sight of the democratization of the access of the information and the ownership of the information. That's the target that has to be there. This is why the whole blockchain technology and crypto world has been created, which is basically democratize access for information, democratize access for finance, and have the ownership of your data. So that's a journey. Decentralization is an end target. We need to put it in front of us, and we need to grow across that path where we need to reach that. Are we there today? No, I don't think we are there today, but efforts have to continue where we reach to that end state. And Web3 is one of those concepts that has been put in place where it's based on decentralizing access and decentralizing the internet.
Yeah, and I think also not all industries and not all companies or use cases are for decentralization. So there will be some centralized approaches stay. So maybe it's then a combination. But of course, we need to make sure that the people know what to do or what they are doing, because otherwise they will lose a lot of money, what they have already done. So, and then of course a lot of scammers out there, also in the decentralized finance area. So there we need to, of course, bring the people on board, give them up to speed, and educate them, because otherwise they will lose so much money. And we need to also see, okay, there are maybe some use cases that are only for centralization, and some you can use it with decentralization. So I think not all industries, not all use cases are for decentralized. Yeah.
What I would add here is that, again, what has been mentioned by Mayor, that the concept itself, and then going back to the title of this fireside chat, which is trying to move everything that Web3 has to offer into a place, does not have to be necessarily equals or means centralization. So that place itself, and I was think about the Amazon, the AWS, this kind of aggregate marketplaces where you have a full portfolio of offerings, where again you can ease access to what the Web3 has to offer. But that marketplace, between quotation, itself does not have to be a centralized marketplace. It can go on a journey where it can be decentralized, it can be owned and operated by a blockchain technology, and it can instigate more trusts. And going to the point that Corina has mentioned, and then I don't want to mention examples, but I think we're all in the space and we know that decentralization is not particularly as secure as, and poses even more risk than what decentralization. And we see examples in front of us in the last 2 weeks, what has happened with centralized exchanges and how much people have actually lost because of what happened with the centralization of the data in exchanges. So both sides have their risks. Both sides, they serve a certain target. And in my opinion, the idea itself is a very viable idea, but we need to be careful to implement it in a way that does not undermine the philanthropy behind what we are trying to put and what we are trying to implement using Web3 technology. That's why it's called Web3. Web3 is all about decentralizing the internet.
Right. So as you rightly said, it has to be a hybrid model. It cannot be 100% decentralized, or it cannot be 100% centralized offerings. So there has to be a marketplace which could be a hybrid model in terms of, today we have a decentralized platforms like Uniswap or PancakeSwap. Now over here, what people do is the buyer and seller can actually exchange hands at whatever price they would like to do it. But on the contrary, we also have a centralized exchange. So this has to be a combination going forward, because completely routing on a decentralized, I think we are too early at this stage to talk about 100% decentralized or 100% centralized. So this is what I have a view on it.
Maybe we can have some opinions and some questions from the audience.
I think this topic is so itself ongoing topic that there would be many questions which we might be happy to answer. Yes. And this is the talk of the town nowadays. What is blockchain? What is crypto? What is Web 3.0? How to get education? I'm sure there will be a lot of questions. And ma'am, you don't require a mic. That's what you said. So
thank you. You are very correct about that. I'm so excited for this panel today. The blockchain space is so incredibly fascinating to me. So I mean, we know that blockchain is the foundation, but crypto is really like the celebrity kid right now, right? And so what I really am wondering from the panelists, particularly with what has gone on recently, with the FTX implosion, explosion, Sam Bankman-Fried, how do you think that is really going to influence the continued ability of blockchain and crypto to move into more of a mainstream space? Because it was like a train moving forward, and I feel like that has really knocked it back. And then also in conjunction with that, blockchain and crypto, as you all have said, was really about making sure that things were in the hands of the people, right? Information couldn't be controlled. But there is this main movement by banks and central banks to move into the crypto space, right? So how do those things coexist? That's just one of my questions.
Would you like to answer, Mr. Wasim?
Maybe I can start and then you would
Okay.
complement.
I think there are two questions in one question of yours, ma'am. One is with respect to pure blockchain, and second is with respect to CBDC, if I get your question right. That's called central bank digital currency. So nowadays, every country is trying. In fact, India has also gone a step ahead, and they have recently launched e-rupee. Now, they try to replicate what has actually happened with China. China has launched the e-yuan just 1.5 years back. And what they are trying to do is every particular transaction, whether it's in the banking or a cash transaction, they can today easily monitor it. And while doing this, what they intend to do is that every user will be on the blockchain. And once every user is on the blockchain, they actually want to record every transactions on the blockchain, which is an immutable transactions. So technically speaking, if I would say it in this manner, that tomorrow the blockchain, if it's developed under the land department, if I need to remove a 100-year-old land department ownership, it becomes very difficult for a user to get who was the owner 100 years back. But given the fact, if that would have been on the blockchain, it would just one syntax command, and I'm sure I would be getting that details. So blockchain to be used as a CBDC by governments, definitely it's the future. But on exactly how the blockchain is going to be worked out, I would like my friend Mr. Wasim to be speaking more on that.
Yeah, maybe just to add on the specific examples you mentioned in your question, that two quick answers. FTX is not crypto and crypto is not blockchain. So that's probably the first direct answer to that. FTX is not equal crypto and crypto does not equal blockchain. One or two bad actors does not undermine what the technology is promising and what the technology is able to deliver. To add to that, if FTX was decentralized and truly blockchain based, this would have never been happened. The problem with FTX is actually totally the reverse. It's a typical example of a fully centralized implementation of an exchange, which is not the promise of the blockchain. So if it was blockchain-based, truly decentralized, this would have never taken place. That's why, again, it goes back to my idea that, yes, we're not there with decentralization. Education is still needed. Some technical problems, governance problems need to be sorted out before we are there with decentralization. But implementing true decentralization would allow us to avoid such kind of problems in the future for sure.
And for the digital currencies provided by central banks, so yeah, there the biggest question is, so do we really need them when we have cryptocurrencies? For what do we need then really digital money from our physical money? So for what do we need it? Because we have already credit cards, we have PayPal, Stripe, and everything. So for what is the use case for it? And yes, and of course for FTX, it's also kind of knowledge thing. And the press, you asked about the mass market adoption. So what does it mean with the mass market adoption? Of course, the press is really negative, but as we heard here in the panel, so it's not, FTX is not crypto, crypto is not blockchain. So it's not connected, and it's only the negative press out of there, because negativity is louder than positivity. So that means everyone is speaking how bad it is, how bad it was, of course, but we had also Lehman, we had Wirecard, we had so many other things in a regulated environment. And now, of course, it's definitely not good. But then on the other hand, when we see, okay, the end users, they are opening accounts with a cryptocurrency exchange on the Bahamas. So this is also the connection. So in a non-regulated environment. So this is also, and I think a lot of people not even were aware that they had their headquarters Bahamas. So I don't know, but it's yeah, it's a lot of negative press and emotions on the side. But again, it's not crypto and it's also not blockchain. And I think it's only short term, so it will not stop the mass market adoption. It will also not stop the innovation and the whole technology and everything. We all need to be louder on a lot of things, on the whole positive things, so what we are building with Web3. So this is the key, so that we bring out the positivity of the whole Web3 into the world and yeah, put the negative people on the side.
Other questions?
Hi, my name is Sagar Tejwani. I actually had a query. Recently, even the UAE Central Bank had, is in process of issuing a draft. As of what I spoke to one of the people from the regulators, and apparently, even I was looking at a lot of material, and given the volatility of cryptocurrencies, most of these governments have started looking from an angle that this is a speculative investment, rather not a medium of exchange or a store of value. So, in those lines, would you like to just put forward about what do you think about this context? Because, a lot of regulators are trying to, give that sort of an image to people given the volatility, so that draws down the entire vision as well in the future, right? How regulators think.
I would like to take this and then maybe. Okay. When it comes to regulation, this market has always been an unregulated market. And beyond a certain point, when it has to grow, the government regulations have to come into picture. So till today, nobody used to use KYC, AML check. Today, there are situations where you can even go up to wallet check. So when it comes to a wallet-to-wallet transfer, if it has been barred by SEC or if it has been barred by any other authorities in the world, technically speaking, you can actually go saying KYT, that is know your transactions. So government does get that data, and to grow beyond a certain point, this particular whole ecosystem has to be regulated. So I personally feel that regulations are coming for good. There will be a turmoil, which could be ups and downs, but that doesn't mean that this industry is going to collapse. This industry is going to stay, regulations are going to come down, and it is going to be more healthier than what it is today.
So I agree with you on that. Just the area which I want to get more clarification on is because, so what a crypto is being, looked into now is basically becoming like an investment product rather than a store of value or a medium of exchange. So from an investment banking perspective, right, like if a person is holding a portfolio, so what is being communicated by a number of central banks is, oh, you can hold crypto, but it'll be like an, like equity or a bond, just like that. You can hold it for your utility, for your investment purposes. But as such, for a store of value or as a currency, as a tender, it would not be appreciated. So this is the type of things which I have been looking into. So that's the area. I completely agree with you on the, regulatory part of it, on the AML, on the KYC bit of it, and the improvements which have happened, how governments are going towards it, completely on it. But, in the area of investment versus a medium of exchange, that bit.
Would you like to take?
If I can just...
Yeah, sure.
For the topic of what we're discussing, I think maybe we should just go back to what we're trying, because it's not a crypto discussion. It's a Web3 discussion. If we move this discussion into a crypto discussion, that's different. I fully understand and appreciate, but I know that the concept of centralization and decentralization pushes us to think about the crypto, but let's limit the discussion that we're trying to have on the Web3 concepts and how the Web3 is going to work, and centralization, decentralization aspect of Web3, and avoid crypto.
Maybe we can take this offline.
Yeah, thanks.
Any other questions?
Yeah, so Web3 as a concept is yet to sink in various countries. What do you think would be the effect of implementing Web3 completely across the globe compared to what we are doing today?
I would just like to start with an example. Today, all of us, we have a bank account. There are some people who go to bank and say, I need to deposit so that I can earn a saving interest. Normally in India, the saving interest is around 5%, 6%. When the same person goes to the bank and say, I want to take a loan, it charges you anywhere between 9% to 10%. My money, giving it to you, they are taking an arbitrage of 3%. This is just one example why Web 3.0 is going to change the life. So when the buyer is ready, the seller is ready, both of them can come on a single platform, decentralization can take place, and they can change hands. So why do we require an intermediary in between when we can actually change hands together? So Web 3.0 as an ecosystem is going to be a very super robust ecosystem over the period of time. So this could not happen overnight, but yes, it might take a decade to actually come into force the way it has been envisioned. Maybe Mr. Wasim, if you can, or Karina.
Yes, and of course, in all parts of our life, it will change nearly a lot of things. For example, and for our leisure, so the whole ticketing system. So when we go to sports, sports matches or so everything will be on blockchain, everything. And so we avoid the whole black market, so no more fraud out of there. Then we have, of course, the whole real estate sector, where we have the metaverse thing, the AR, VR. Then we have also the whole contracting. Of course, I know it's a law conference, but we need also to think about the future concept of lawyers. So because when we can have everything on blockchain, so all the contracts there. So I think there will be also a lot of changes when we can have everything written there on blockchain. And smart contracts. We have the whole kind of business clubs, the whole financing of companies with NFTs. So when you're issuing NFTs, you don't need any more business angels or less VCs. So everyone can be part of it, and this is a really good benefit that really everybody can part of the Web3 and can take part in investing in companies with it. So when they issue NFTs, for example. So this will be a whole new story, what we create, the whole health sector. We have also here the health conference, surgeries with AI, metaverse and everything. So it will change really a lot.
I mean, thank you, Mayor and Corina. I think there is nothing much I can add on what has been mentioned. Maybe just taking it a little bit one step back and saying that the Web3 is taking the innovation, and going back maybe to the same point, is taking the innovation away from innovation houses that we know today, in a figure of speech, and putting it in the hands of the people. Everyone can innovate. So you take the innovation to a totally new level. There is no barrier of the ideas, how they can be developed and what you can innovate. Whoever is able to innovate, can create his app, can put it in a decentralized infrastructure. And you can see that imagination will be the limit. In this case, it's an actual unleashing of capabilities of innovation, put there up in the crowd and let people innovate and create and be creative about that. So that's what I can add about what would Web3 add to our current life. Any more answers we can take from the crowd?
Thank you very much.
All right. Thank you.
Thank you so much.
Thank you.
Thank you.
Corina, Wasim, and Mayur for this chat on Web3. Thank you, thank you. All right, this signals the end of day 1 for Law and Money 2.0 conference. We shall reconvene tomorrow at 9 a.m. Please feel free to join our networking session. I believe it's downstairs, close to where we had lunch, and mix and mingle with other speakers, attendees, and exhibitors. Thank you very much, and I'll see you tomorrow morning. Bye-bye.